Good morning, good morning, good morning. It is, what day is it? It's Wednesday. It's May 7th. It's day 10,000. No, it's not. It's day 11 of the Karen Read case. And I actually went back and looked through past court hearings to see how long the Commonwealth said that their case in chief would be. And the Commonwealth said that they believed their case in chief would be about 3.5 weeks. They were trying to keep it under 4 weeks. They were optimistic for 22 to 24 days. So we're like more than halfway through the Commonwealth's case in chief, and there's a lot of witnesses we haven't seen. I'm wondering if they are moving towards the accident reconstructionist, because it seems that that's the order that they're bringing evidence in, things collected at the scene, what was found and when. But for the jurors, it's not, I think, a glaring and obvious, where are these witnesses yet? But for us, it is becoming a glaring and obvious, where are these witnesses? Replay crew, everything is timestamped down below. Get the app. Thank you for hanging out. Law nerds, thank you so much for all of the birthday well wishes. The rumors are true. Today is in fact my birthday. The boys left cards at my keyboard this morning. It was very sweet. And we're just going to go to court. Do you guys know what I did last year on my birthday? Do you want to know? Do you want to know what I did last year on my birthday? Do anyone want to guess in the chat? Do you want to guess? Do you want to guess what we did on my birthday last year? Yeah, we streamed the Karen Read case. That's exactly right. We streamed the Karen Read case. That's what we did last year on May 7th. On May 7th last year, we were on day 6 of the Karen Read trial. That's what we did. Should we take a look back real quick? Who testified on day 6 of the Karen Read trial? Well, Sergeant Sean Good, Sergeant Mike Lank, and Lieutenant Charles Wright. We've already heard from Charles Wright. We haven't heard from Good and Lank yet, so let's see if we do. It is nice. Nice in the chat said it is birthday deja vu. It went by so fast. So thank you guys. It's good to see you. It was like it's birthday. No, Nick Ross said birthday deja vu. It's 100% birthday deja vu. We're gonna roll the intro. We're gonna go to court. I've got breakfast. I have a cappuccino. We've got coffee, and we're gonna go to court. We're going to go to court. The light's going to keep changing today because the weather's weathering. So it's just going to be a cozy court day for us. Are we ready for day 11? Who knows? Yesterday, we learned that a dusting of snow was not in fact a dusting. It is it's enough to track a cat by, which was just delightful. And we learned that meteorologist is not the full definition. It's hydrometeorologist. And it is the study of water falling from the sky, or wet things falling from the sky. Also delightful. So yesterday brought us quite a lot of information, but I do think we are moving towards seeing the Commonwealth's accident reconstructionist. It's one of the witnesses I'm really interested to see, because when we look at where the Commonwealth ended yesterday, I think that their use of Herrera was very good. I think that the jury will like him. He's not connected in any way to all of the other nonsense in this case. He knows people because they are employed by the same very large agency. He's like, yes, I know who those people are, but those aren't my friends. I don't know them. I know who they are, and especially because they've been in the news so much, I know who they are. But I do search, we do other stuff. I think the jury will find him very credible. He very much is a neutral, I think, law enforcement testimony. It's not defensive. It's not over-explaining. It's not distancing. It's not, why would I even do that? So I think that testimony becomes difficult testimony at this point for the defense to deal with. We'll get into other testimony down the road that may change that, but I'm interested to see that accident reconstructionist. I think that's where we're going. So we should just go to court. And again, thank you all for the birthday wishes. Are we ready to go to court? I'm ready to go. I don't know at this point. Are we ready? Are we not ready? We're just brace yourselves. It's happening one way or the other. We can't stop at this, can't stop, won't stop, but also where are we going today? Who knows? Hey there, I'm lawyer and legal analyst Emily D. Baker, and this is your go-to destination for live court coverage. I break down the law, the strategy, and the evidence in real time so you know what's happening. No law degree required. So join the law nerds in the chat. They're here for the facts, not and let's get to court. Every time I watch our new intro, I miss my old glasses that I lost in Boston. I need my old glass. I'm gonna have to get a new pair of frames and send the. Every time I see them, I miss them with the gold. Every time I look at the new intro, I'm like, I miss those glasses. I'm just gonna have to get a new pair and then send them out to get all the prescription-y things. It is so complex in my world getting glasses, but I think it's worth. I miss every time I watch. Every time I watch. Joanna Banana said, when were you in Boston? It's been a minute. I don't even remember. It was for a Carson and Kennedy event with New Kids on the Block. So in the summer. So it was hot, like in the summer. So ready? Let's get some hear ye's. Let's get some birthday hear ye's, shall we? Let's get some good old hear ye, hear ye, hear ye. It's time to bring the jury. I mean, we have so many great lines from these courts. But this is a great question. And Samantha, I know everyone wants to know the same thing. What happens if Brennan doesn't call Higgins or the Alberts? Then the defense does. They're on the witness list. The defense can call them too. It just becomes a whole different vibe. So I did not lose them in NYC at the YouTube event. I think I left them in the hotel. It took me a minute to figure out that my glasses case had come home empty. But I think it was the hotel in Boston where I lost them. But it doesn't matter. The frames are still made, so I can just, the whole getting new glasses, because you got to get the prescription, and then I do the customized tint. It's a whole thing. It's a whole thing. But we should go to court. We'll talk about the whole thing later. Y'all know. The glasses people, you know. You know what it is.
Hear ye, hear ye, hear ye. All persons having anything to do before the Honorable Beverly Cannone, Justice of the Superior Court, holding in Dedham, within and for the County of Norfolk. Draw near, give your presence, and you shall be heard.
Give your presence.
The Commonwealth of Massachusetts. This court is in session.
Give your attention. Give your attention, and you shall be heard. Anyway, it sounds like somebody has a leaf blower in the courtroom at the moment. I hope that passes.
Please be seated.
All right, good morning again, counsel. Good morning. Jurors.
Oh, I tint them because I'm light sensitive. It also is a ADHD benefit for me, but I am incredibly light sensitive. I know, give your presence. No, not presence. Yes, presence. No, presence, which is a strange way to say, give your attention and you shall be heard. So.
All right, Mr. Brennan, your next witness, please.
Oh, B2,
Thank you, Your Honor.
thank you.
The Commonwealth calls Connor Keefe.
All right, our next witness is witness 22, Connor Keefe. B2, that's you guys are very sweet. Being here is fine. You do not have to super chat for the birthday, but thank you. That is very kind, B2, and I appreciate it. I will give some memberships throughout the day. We'll do a little like Law Nerd member party throughout the day. So we'll do that. We'll get started with that pretty soon, because those of you that are like, girl, we're here, let's go. We get it. So Connor, there we go. Witnesses up. Witness 22. I'm feeling 20. No, Emily, it's not too early. You know what? It's not too early. Not too early at all. So the mods put a little Lincoln and Nightbot does on occasion as well on how to make sure memberships are turned on.
All right,
so do that. We'll give out some memberships.
Thank you, Your Honor.
To the early birdies.
Good morning, sir.
Could you please introduce yourself to the jury, spell your last name for the record?
Sure, my name is Connor Keefe. The last name is Keefe.
I totally heard it as Keith, like Richards.
Mr. Keefe, where do you work?
I work for the Massachusetts State Police.
What's your position
How do you feel
with the
about that?
Massachusetts State Police?
I'm assigned to
wrong
the
question.
Norfolk District Attorney's Office.
I
you
cannot
a
say
trooper?
Norfolk
Yes.
correctly.
When did you first start beginning working as a Massachusetts State Police trooper?
2017.
How
Did you go to basic training?
kind of
Yes,
wild
the
at
academy.
work, right?
How long was the academy?
Approximately 6 months.
You guys have like a
Did you
Discord
have any
group?
further training after the academy?
Probably.
On the job training?
Yes.
Yes.
Yeah, probably.
In various specialties.
What's your role at the Norfolk County District Attorney's Office?
I am assigned to the homicide unit where we investigate homicides, unattended deaths, suicides, stuff like that. And I'm also a digital forensic examiner at the district attorney's office.
Emily, don't start. Don't start.
Did you have a
Don't-
role
oh.
in investigating this case?
Yes.
Were you a assigned investigator in this case?
I wasn't the main investigator.
Oh,
but
we
I was
know.
involved, yes.
Did you deal with any of the digital forensic evidence?
So we've heard.
Yes.
Specifically, regarding the digital forensic evidence, did you meet anybody to obtain a phone?
Yes.
Who did you meet?
I met Jen McCabe and Kerry Roberts.
When you met
Isn't
with
it
them, did
always?
you have to obtain anything from them?
I obtained a consent form and their cellular device.
I have
After you
questions.
received their devices, where did you bring them?
They were brought back to the forensics lab located at the Norfolk District Attorney's Office.
And what, if anything, did you do with either or both phones?
I conducted a forensic extraction on those devices.
And that's why he's here.
An
He did the
extraction, is that a
extraction.
copying an image
Which
of
is
the
why
phone?
we've heard his name
Yes.
before.
Is that different than analyzing the phone?
Yes.
Were you involved in analyzing Kerry Roberts'
I don't
phone?
know if he testified
Were you involved
previously.
in analyzing Jennifer McCabe's phone?
I would
No.
have to go back and look.
Was your role limited to attaching it to grade key and doing the extraction?
That is correct.
And did you do that?
Yes.
In addition to the phone
So he did the extractions.
If you take us back to January 29, 2022, were you involved in going to 34 Fairview Road in Canton, Massachusetts?
Yes.
Do you know about what time you went there?
Approximately 5:30.
What was your role at 34 Fairview Road that evening?
I was asked by my supervisor, Lieutenant Brian Tully, to assist in processing the scene at 34 Fairview Road in Canton, Massachusetts.
So
When
went
you
to the
arrived
scene.
at 34 Fairview Road,
while
was there
Sir was
anybody
there.
else there?
Yes.
Who was there?
Lieutenant Tully, members of the Massachusetts State Police
Oh, it's good
CERT
coffee
team, the
today.
Special Emergency Response Team.
Are you part of the CERT team?
I don't know.
I am not.
Did you see what the
I
CERT
think
team
it's like
was
the
doing?
air in the atmosphere.
They were conducting
and,
an area
like,
search
moisture or whatever. Some coffee days are better
very
than other
front of
coffee
the
days.
lawn and the street or road in front of 34 Fairview.
Did you have any role
I was
in
talking
that
about my
actual
coffee. That
search?
was actually important. They were searching in the very front area of the lawn and the road, which again, I don't think we heard last trial at all. I think Brennan did a very good job of clarifying exactly where they were searching because it explains, well, you didn't find all these other pieces of Taillight. I'm not saying I don't think there's other issues with that, but where the jury is at this point today, it explains, oh, well, there weren't other pieces found. Oh, well, they weren't searching on the grass because they couldn't clear the snow effectively, so they were just searching on the road. It is an explanation that the jury can choose to accept. So I think that his reiteration of that is, again, helpful for the Commonwealth's case. We haven't gotten to the stuff that's not helpful for the case.
Of evidence.
We'll get
No,
there.
I did not.
What was your role, limited role that night?
To process any evidence that was discovered during the search.
When you say process the evidence, can you explain briefly what does that mean?
Sure, I was had evidence bags, and if a piece of evidence or an item was found, I would place that item into the evidence bag
In an evidence
And why would
bag,
you do that?
to secure it.
because it's evidence.
How would you become aware if there was a piece of evidence found?
The CERT team would alert the supervisor, Lieutenant Tully, or myself that there was an item or a piece of evidence, and Lieutenant Tully would then take a photograph of it, and then I would secure the piece of evidence in a bag, evidence bag.
Do you know if those photographs were timestamped?
However, all of you saying, wait, they have evidence bags now? Not Canton PD. He is with state troopers, different agency.
I believe so.
Your role was to put the evidence in the bag and return it to the evidence room?
Correct.
Did
He
you
put
do
the
that?
lime in the
Yes.
coconut, drank them both up.
If I could begin, I'd like to show you on the screen a series of exhibits. If we could start with exhibit
Ooh, exhibities.
74, please. Trooper, do you recognize that item?
Yes.
What is it?
That is a black Nike shoe.
Did you see that item that night?
Yes.
74A, please.
Oh, they didn't ask about an evidence log.
74B.
Chat, don't get wild today. It's too early for you to start asking things like,
that
what
the
about an
same
evidence
sneaker?
log?
Yes, sir.
After you were alerted to that sneaker, did you place that sneaker into an evidence bag?
Yes.
Did you bring that item with you today?
Yes.
Do you have gloves?
Yes, sir.
There are parts of this investigation that were not
Do you want the lights on, Mr. Brennan?
absolutely
Please, thank you, Your
appalling.
Honor.
And
I'm
then
just
there
gonna
was
move
the rest of
photo
it
down, please.
that was the rest of it. Yes, he
With
has
the
it
court's
with him.
permission, I'm going to move this piece of evidence, item into evidence.
They will bring the one from the hospital later. Brianna asked, any birthday plans for tonight? No, not tonight. Tonight we'll be having dinner with the fam at
Let
home
me
and
ask you a few
sleeping.
questions before you open it. Could you stand and show that?
Yes, sir.
Brian and I have started doing more experiences
Okay.
since our birthdays are so close
There's
together.
red tape on it. What's that for?
What? There's tape? And we went to Metallica. So that was it. Last week it was like the birthday stuff. They have evidence tape, and look at what the bag says on it. Look at what that bag says on it. Evidence. It says evidence. Look, there's signatures on the side of it. There's a computer printout sticker. The sticker would be when you log it into the computer. Spits out a sticker and you put the sticker on. Look at that. Look at that.
To secure the bag closed.
If the bag is open, is it then retaped?
Yes.
Do you write on the outside of the bag?
Yes.
Why do you do that?
To memorialize the date, time when the evidence was collected.
Could you open the bag and show us what's in it?
Yes, sir.
Don't worry, chat. Your relative excitement for the bare minimum of proper police protocol will disappear, I'm sure, again, incoming witnesses. But I think the difference between, like, why would I do that? We don't tape is shocking, right? I wonder if that's why they called this witness. It's like, hey, look, an evidence bag that's sealed and shit with evidence tape and signed. It's just so helpful. It's just so helpful. I saw a number of good questions in the chat along the same lines. I'm going to bring those up while he is trying to use the world's worst court scissors. Chronic Shock's Art Journal is describing evidence
With the
logging,
court's
usually the
permission,
lead
can you show the
investigator's
item?
testimony. Oftentimes, the lead investigator handles all of it, but they are bringing in who recovered it, which makes sense. So they are bringing in who recovered it. Oh, that's the microphone.
Trooper, is that the same item that you found that night?
Yes, sir.
If you could place it back in the bag. I'd ask this to be marked as an exhibit.
All right, any objections, Dean Eddy?
There is no objection.
And the jury will have the ability to take a look.
Sir, you mentioned there's writing on the outside of the bag.
Yes.
What type of information do you write on the bag?
Date, time, location, who was collecting it.
The time that you write on the bag, is that the specific time the item was found, or does that represent a different time?
And then we'll see the
That
other
could
shoe
represent a
from the
different time.
hospital.
And why would that be?
If you're processing multiple things at once, you're bagging things at different times, then when you seal the bag, that could be the time that is annotated on the bag.
Can the item be found before the time on that bag?
Yes.
Would you ever write a time later than when the item was found?
Yes.
I'd like to move now to Exhibit 75, please. And preferably 75A, please. Do you recognize that item?
Yes.
Is that one of the items you bagged that night?
Yes.
And if we could turn to 76A,
Chat,
please.
it's the same shoe. The soles aren't different.
Do you recognize that item?
Yes.
Yo, look. Where are we at? We're at this picture of Taillight. The sole on the shoe is white. It is white where it meets the shoe, and then there is snow, and then there is curb, and then there is lighting and flash. But that is all snow caked onto the top of the shoe. It is the same shoe. All right, let's get back to that picture. I mean, the pictures are not good, but there is snow on the shoe.
Both of those
I'm gonna
items.
back that up real quick so we have. It would be nice to be oriented to where this stuff was found, but everything is so zoomed in. So zoomed in.
Do you recognize that item?
Yes.
Is that one of the items you bagged that night?
Yes.
And if we could turn to 76A, please. Do you recognize that item?
Yes.
Is that an item that you bagged that night?
Yes.
Do you have both of those items with you?
Yes, sir.
Could you?
Yeah, the
do so,
photos are
please?
terrible.
Ms. Gilman, you could take that
It was
down,
definitely
please. Thank you.
more than enough snow to track a cat. The photos are terrible.
570.
Just terrible.
Yes, sir.
With the court's permission, I'd ask the trooper to open the bag and show the jury.
And the world's worst court scissors to open up the evidence bag. So he's bringing in all the evidence that he bagged. The shoe was found up against the berm. So it's not a curb, it is an asphalt berm. So it was found up against the berm. So you can see where the berm is up against it. It does look like they took pictures with a potato. It does. Those are the pieces.
Sir, on those items that are stickers, did you put the stickers on them?
I did not.
Do you know where the stickers come from?
The lab.
I do not.
Come from
Do
the
you know if
lab.
these items are ever sent
they
to anybody other than your
come
evidence
from
locker? Are
the
they ever
lab.
removed and given to lab personnel and technicians?
They come
Yes.
from the lab.
Do you know if that was done in this case?
Yes, I do.
Inside that bag, is there just two pieces?
Did you see how Brennan was like, "Are you fucking joking me that you don't know those are the lab stickers? You're a homicide detective. Do you know that those pieces all went to the lab?" Okay. Is a berm a curb? Yes, it has been described in this case because it is asphalt and rounded. It is not like a 90-degree squared off curb to a sidewalk. So they called it the berm, which gets confusing because there's also a berm from the snowplow going through. So it is a rounded asphalt curb, not a curb that is of different material, more like a sidewalk than the road, if that helps.
Pieces, or is there another piece in that bag?
There's
Brennan's-
another piece in the bag.
Brennan's
When
like,
put
do you have a
the taillight
third
pieces
hand?
in
Can
that
you
bag,
just...
How many pieces did you put in the bag?
I put 2.
Do you know if the other piece in the bag is a piece that broke off, or do you know how that arrived there?
I do not.
Could you just pull out that other small piece and show
Jessica,
the jury
it's
as
not a
well?
problem with this particular evidence. It's already been scientifically tested, swabbed. It's been pulled out at another trial. So for this case, for this evidence, that is not really a concern. They are also hard pieces of plastic, but they've already been swabbed. They're not going to re-swab them after they've been... What? Yeah, you know, if you put that down, you're going to drop it.
Is that smaller piece consistent with the same color as the two bigger pieces?
Did it break
Yes.
off in
Is
the
it consistent
bag?
with the same material?
It's
Yes.
so small.
If you could put that back in the bag, please. I'd move this into evidence, please.
Okay.
There's an objection to it being moved into evidence, which is kind of unusual. You don't often get an objection to it being moved into evidence. Hold on. I wonder what their objection is. He's the one that marked it into evidence. I wonder if they're going to have a chain of custody objection to who pulled it out of evidence. We will just have to see if we find out.
So, Mr. Brennan, I leave it to you and the witness how you do that part.
Yes.
That sounds like foundation, but I guess we'll see.
Sir, on the small chip piece, you don't know how it became chipped?
There's no small little piece in the photos. Why is there a small little piece? A fair thing for Yannetti to fight about. It probably got broken. Is that bad? Yeah, it's not great when you have two pieces and a piece breaks off, but can it be pretty easily explained? Well, that it broke, yes. How it broke, maybe not. Though I did go to an evidence view once where a defense attorney was trying to push on the bag of narcotics. The detective's like, you can't touch them and try to squish them and break them up. What are you doing? So that's not the situation here, but it's going to be very interesting to hear how they're going to talk about the smaller piece in the bag. They have to illuminate it for the jury. It'll be cross-examined about, and it will again allow the jury to be like, oh, were we handling things carefully and thoroughly? Or did shit just get tossed around in the back of an SUV? Like, the bag says 2, and there's this itty bitty little one.
You do that part.
Yes.
Not great.
Sir, on the small chip piece, you
Lyndon.
don't know how it became chipped?
That's leading.
I do not.
I'd ask you to remove that chip.
And do what? Where are you going to put it? It's got to be somewhere.
I'd like you to safely secure it, bring with you, and bag it when you leave.
Yes, sir.
And then I'd like to introduce that exhibit.
Well, you're
We're
just going
going
to
to
say,
mark the little chip.
You'd
Mr.
like to
Yannetti
mark it?
asked to
Okay.
mark that.
yeah, it needs to be marked for
Then we're gonna
identification. What do you
submit
mean
that
he's
for
just going to?
identification. So the small chip that I
Madam
asked you-
What do you mean he's just going to take it? Somebody grab a Stop and Shop bag. We're just bagging it separately. I would like you to take that with you. No. What? No. Just put it in your pocket. What they will likely do is grab just a manila envelope in the court and deal with it then.
secure.
Madam Court Reporter has an envelope.
Yeah. Yep. The court
Thank you
reporter
very
has an Yep. Still better than a Stop and Shop bag.
Yep.
It needs to be marked for identification. You need to give him a pen.
Exhibit BB for identification.
Thank you.
Oh, it's Exhibit B because it's... Sorry. Things have gone off the rail quickly. We're marking new evidence in court, apparently.
Trooper, we have one more bag of items to go through.
Yes.
Could I have Exhibit 73, please?
I have to make notes or I'm going to forget.
Sir, if you could look at Exhibit 73 on the screen, do you recognize that?
Yes.
And what is it?
A piece of clear plastic.
Is that piece of clear plastic, when you saw it, was it at ground level?
Yes,
Did you bag that item?
I did.
When you bagged that item, was there another item along with it in the same bag?
Yes.
May I approach, Your Honor?
Yes.
For all of you that are like, oh, Madam Court Reporter will do it. I know they have the court reporter wearing a million different hats.
I'm showing you a photo. You recognize what's in it?
Yes.
What's in it?
Becky, I
piece of
can't
clear
roll my
plastic.
eyes hard enough.
That's the second piece in the bag?
Becky said, but they don't need Easter to testify on
Yes.
proper police
Is there an
procedures.
accurate depiction?
You know how I feel about this ruling. I think it's a bad ruling. I do not like it. I think it is dumb. However, on the flip side of that, I think the jury is sitting there going, what? That doesn't seem right. That seems unusual. That seems less than ideal. So we've got Birthday buddies in the chat. Thank you, Annika.
Of how you saw it that morning?
Yes, sir.
Anastasia,
Move this into evidence as an exhibit, please.
the double C's are not
There's
going
no
to be easy
objection,
for my
Mr.
brain.
Kennedy?
There's no objection.
Princess Claudia, I have it. I love it. I have it.
With the court's permission,
I will grab
could
it
we
at the
show
lunch
Exhibit
break.
79 to the jury.
Yes.
Miguelina, remind me to grab it at the lunch break because I will say that now and forget. I have it. It is in
Mr. Gilman, would you be
the
able to-
background.
Thank you.
I love it. Thank you, Princess Claudia. I do have it, and it is amazing. I will grab it so the law nerds can see it. I appreciate that.
You recognize that item, sir?
Yes.
And did you bring those two items with you, the past exhibit and
Though
this
there was a
exhibit?
period of time where
Yes.
Griffin
Could you
stole it and
produce
it was
those,
in his
please?
room, so it goes between my office and Griffin's room because he also thinks it's amazing. Griffin also very much doesn't want, especially stuffies, to get lonely. So when Grogu was the only stuffy, Griffin was like, he cannot be alone. He cannot be alone, which I get.
Are these different in color than the last pieces you showed?
Yes.
Yes, they're clear plastic.
The court's permission, could the trooper show these pieces?
Yes.
I'd like to just mark for the record. I would like to just mark for the record that we got maybe 3 minutes past me saying, hey, everybody, look at this. Look at this. We have like evidence tape and they noted where they found it. We got maybe 3 minutes before like, where'd that little broken piece come from? Maybe 3 minutes. I said, don't worry, the wheels will come off. There they go. Whoop. Just. Oh. Evidence getting broken in the evidence bags. Great. Those look like two plastic pieces.
Thank you, trooper. I'd move these items into evidence.
No objection, Your Honor.
Exhibit 80.
I saw the comments about this being Massachusetts. I mean, it's not a low tax. It's not a low tax state.
Thank you, Trooper Keefe.
But I spent most of my life in California, so, you know.
All right, any questions, Mr. Yannetti?
I bet he does. I bet Yannetti does have a few questions.
Good morning, sir.
Good morning, sir.
Trooper Keefe, you testified that you received the cell phone of Jennifer
I got
McCabe
questions
and
about that
of
too.
Kerry Roberts.
Correct.
With regard to the cell phone of Jennifer McCabe in particular, you had her sign.
For all of you that are new to this trial, I really hope this is going where I think it's going because, again, things that make you go,
What is called a consent form, correct?
That's correct.
What is a consent form?
It allows the trooper or law enforcement to, with the owner's consent, we are able to conduct an extraction of the device.
Okay. And on that consent form, there is a description of the item itself?
Yes.
In this case, it would have been an iPhone 11.
Yes.
I mean, it's not a
And,
trick question.
There also is an identifier with regard to a specific phone called the IMEI number.
IMEI.
The International Mobile Equipment Identifier.
Okay.
Yes,
And
the IMEI.
That would be included on the form as well because it identifies the specific iPhone 11 that Jennifer.
Also, I don't think I knew that, or at least I didn't remember that IMEI stood for International Mobile Equipment Identifier. The more you know.
McCabe had, correct?
Correct.
Fanned it off.
The password was provided on that consent form,
Yes.
and the form was signed, correct?
Yes.
By both Jennifer McCabe and by you, correct?
Yes.
And there was
And
also
by
a
you.
second trooper that would have signed the form as well?
That's correct.
With regard to the timing of the signing of that form, Jennifer McCabe dated it February 2nd of 2022?
Yes.
You also dated it February 2nd of 2022, correct?
Correct.
Jennifer McCabe did not list a time, but you did, correct?
I would have to look at the consent form.
Okay, so your memory, you don't remember what time you indicated or if you indicated a time, but looking at the consent form would refresh your memory?
Yes.
May I approach, Your Honor?
Yes.
Waiting for this. Crystal Rose, thank you so much. Don't worry about missing live. I'm glad we were at UMass at the same time. I did end up transferring after I tore my rotator cuff.
And then look up at me when you're
And
done,
I am
Cooper.
still bummed that I didn't do band at UMass, but water polo and band were not compatible as a
Having reviewed that form, does that refresh your memory as to
dual
whether
activities,
you
but-
indicated a date and time?
I loved our band.
I did, yes.
And
football team,
what
not so
was
much.
the date
Band,
and
yes.
time that you indicated?
Rugby
It
team,
was
yes.
February 2nd, 2022, 12:08.
And that would have been 12:08
Living in the towers
PM?
also, yes, yes.
Correct. 12:08 p.m.
The document that I handed you is not an original, correct?
No, it's not.
Does it appear to be a precise copy of the original, however?
Yes.
May I offer that into evidence, Your Honor, please?
Is there an objection, Mr. Brennan?
No, subject to redaction.
Okay. So don't put it up on the...
I will not.
He said he went on the 29th. So yes, the dates from the signed.
Now, Trooper Keefe, as of January 29th of 2022, you were colleagues in the same state police unit as Michael Proctor, correct?
I was.
At that time, was the unit called the CPAC unit or was it called Norfolk County Detectives?
I don't recall when it changed.
Okay. It's been called both, correct?
It has.
As of January 29th of 2022, there were only 10 troopers in the unit, including supervisors, correct?
I don't know.
It's a small unit, is it not?
Relatively small.
Within the CPAC or the Norfolk County Detectives, every case that comes in is assigned to one particular trooper as the lead investigator in the case, correct?
That is something that a supervisor would do, not me.
And have
He's
you
not-
been assigned?
Bro. He's not asking if you assign the case out. Just the question asked is it gets assigned to a lead detective. He's not trying to flame you, sir. He's trying to point out who the lead case detective is so the jury hears it over and over and over. These questions aren't about you. It's not about you. He's not implying anything about you. He's not fighting with you. He's just asking you, hey, how do procedures work when a case gets assigned? And you're all full fucking shaggy this morning being like, it wasn't me. Sir, he's not asking if it was you. He, in fact, knows it wasn't you. He's asking you because he knows it wasn't you. He wants to point out to the jury that they still haven't seen the lead investigator. You just have to answer the questions.
Assigned as the lead investigator in other investigations?
No. Not a homicide investigation, no.
You have not yet.
No.
He joined in like 2017.
The
He's not even 10 years
lead
in.
investigator is the trooper who is responsible for the case, correct?
Yes.
Michael Proctor was the lead investigator for the investigation into the death of John O'Keefe, was he not?
Yes.
If somebody asked within your
Did it
unit,
hurt? Did it hurt to say Michael Proctor was the lead investigator? Because it's not about you. It's about Proctor. We should know this by now, that it is going to be about Proctor.
while this case was going on, whose case is it or who has that case? Your answer would have been Michael Proctor, correct?
Yes.
The two of you have worked cases together in the past, correct?
A few.
You've worked on this case with Michael Proctor, correct?
Yes.
And in fact, within your work on this case, you actually
Where are you going?
partnered with him for certain
You fixing your
assignments within
shoe?
the case, did you not?
You'll have to be more specific.
Sure. So for instance, on
What are
October
you doing?
21 of 2022, you and Michael Proctor interviewed Sarah Levinson together, correct?
No, I don't recall that.
If I may just have a moment, Your Honor.
Vibe. Look, with everything that has gone down with Proctor, I can understand why he's like, I didn't have anything to do with this. Look, the Proctor shit is so bad. The jury doesn't know how bad it is yet. They have no idea, but it is so bad. And he's just like, I want nothing to do with any of this. I want nothing to do with any of this. And he's not an unlikable witness until he's not answering the question that he's asked. So it makes sense to use this witness who works in the same unit to connect more that Proctor's the lead investigator. Jackson tried to do this a bit with Lieutenant Leafblower. What is his last? Gallagher. And Lieutenant Gallagher was like, I don't know who. I think they assign cases in duos and trio. I don't even know. I don't know who's in charge. Like, what does the word in charge mean anyway? Like, it's just, everybody just kind of handles things together. Nobody's really in charge per se. Like, there's just kind of supervisors, but nobody really is in charge. I don't know what they do over at the DA's office. Anyway, Trooper or Lieutenant Gallagher was just, I don't know what they do. This trooper knows this is his unit. This is a small unit. They work assigned to Norfolk. He knows how cases get assigned, even if he's not the one assigning them. He knows how assignments are made. He's not a supervisor. He is a perfect witness to ask all of the inner workings, because the other cross-examinations of other troopers are going to be much more them fighting with each other. This guy, I've got questions about the cell phone extraction of Jen McCabe's phone, but he is lower down in the chain of command and is a perfect person to explain this. He just doesn't want to. He's like, I don't want to be involved. And I get it, but leave me alone. But I get it. He's well aware of everything that's going on in this case. So he's just like, he probably wasn't on the group text. I don't think he was on any of those text change. He is a junior member of this team. So he's just like, I don't want to deal with it. But he didn't avoid the answer of, wasn't the lead detective Michael Proctor? Yes. But he's just like, I know Proctor has become a nefarious word in this case. And I think the longer it goes, I don't know. I might be reading too much into it just because I know too much about this case at this point. But it feels like the more you hear Proctor's name and Proctor's not on the stand, it's like, what now? It was like with Jen McCabe. It's like Jen McCabe. And then she gets on the stand and you're like, ooh. Proctor is looming in this trial at this point, but that also might be me overreading it because I am anticipating his testimony. So I take that with a grain of salt. I know too much about this case. They might not keep thinking about it in the courtroom, but I am.
Interviewing Sarah Levinson on October 21 of 2022 at 12:20 p.m. at the Norfolk DA's office. Is that your current testimony?
Yes.
He said he didn't remember.
If you saw a copy of that report, would that refresh your memory?
To an extent.
I rock the mic like a vandal, light up the stage and watch me jump like a candle. He's like, I don't know, man. I was junior. I just had to go do shit.
No, not at all.
The defense has to show the prosecution what they're going to show the witness. You know, you knew this witness was up. Look, you put this is not hard with a witness that doesn't do a ton of stuff. Here's how you prep a witness that doesn't do a ton of stuff like this witness. In ADB's world, you grab all the reports that this witness was a part of and you put them all together. I tend to put them in a folder, not a 3-ring binder, because I didn't want to clip and unclip 3-ring binders because I would pinch my fingers in
I've
court.
placed a
It's very embarrassing.
document in front of you. I would just ask you to read that.
Once I broke a nail trying to unclip a 3-ring binder in court, and I never did it again. So I put them in folders, just a folder with all the reports this witness had. Sometimes that meant you copied a lot of reports to have trial ready. You put the witness's name on top and you put all of those together in the order that you're going to call the witness, and you pull out the folder, and then you have all the reports that this witness was a part of. And then you have them when you need to ask the witness about them, if you need to ask the witness about them. All of them are just together. That's it. But the DA I worked with when I was a law clerk, that is how that DA did things. And I was like, this makes all the sense in the world. And then everything's in one folder, and you just pull the folder out with the witness name. And then if witnesses get shuffled out of order and you have to do something unexpected, guess what? You're already prepared, and you just pull the folder out, and then all their reports are right there. That's it.
That silently to yourself. Look up at me when you're done.
Because you never know what you're going to need for that witness. I don't think Proctor, a lot of you have asked what happens if Proctor pleads the fifth. Samantha just asked, Buffy, I agree with work smarter, not harder. Look, prepare as much as you possibly can. In shorter trials, that didn't always happen, but in bigger trials, it did. This would be consistent with a bigger trial. What happens if Proctor pleads the fifth? I don't think he can, and it would go question by question, and it would be outside the presence of the jury with a voir dire. But I don't think he can. So, I mean, Trapper Keepers were absolutely bae. Absolutely bae. Yeah. The second I broke a nail trying to open a 3-ring binder, I was like, I'm never doing this again. I feel very strongly about that. Also, it hurts. I have to find a Band-Aid. Embarrassing. He's reading the whole report. Did you? My guy. Didn't you review your reports before you came to court? Like, can't you go into the computer system and search your name and read all the reports with this case number with your name on them? He looks so confused.
Sorry, Trooper Keefe, just so we're clear, I'm not going to ask you any questions about the specifics of what Sarah Levinson
It's
said.
like, just were you there?
You don't have to brush up on that.
I'd just like to refresh. Take
Sure,
a look, sir.
go ahead.
Oh, he doesn't trust the defense attorneys at all. I understand it, but he doesn't know what's coming. And so he's just like, nope, I'm reading the whole damn thing. All right. You, okay. Thomas, I did exclaim, ouch, and the court reporter said, do you need a Band-Aid?
Having reviewed that report,
And the
does
clerk
that
got me
refresh
one.
your memory as to whether or not you participated in an interview of Sarah Levinson with Michael Proctor on October 21st of 2022?
Yes, I don't recall the specifics, but
You were present?
So when you say yes, is it your current testimony that your memory is refreshed that you were actually there?
Yes.
yes.
Okay. And the two of you would have participated in that interview together, correct?
Yes.
But you did not write the report, correct?
No, I did not.
Michael Proctor wrote the report, correct?
Yes, he did.
He was the lead investigator writing the report, correct?
Yes, he wrote this report.
He chose the language to use in that report, correct?
I did not have any input on how he wrote this report.
Right. You had no input. You weren't standing over him while he was typing it, correct?
So uncomfortable.
Correct.
Now, other examples of, and actually, let me take that back from you if you don't mind.
Heather B said this guy could care less. Oh no, he's so uncomfortable. He's so uncomfortable talking about Proctor. Why is he being cautious? Because he has no idea what's coming about
Other examples are the
Proctor.
reports on the videos that you, well, strike that. Let me start by saying this. You, or asking you this, you retrieved videos from both the Waterfall Bar and Grill and C.F. McCarthy's, did you not?
That's correct.
Oh,
You and Sergeant Buchanan retrieved the videos from C.F. McCarthy's, correct?
Yes.
But lead detective or lead investigator Michael Proctor was the one to analyze the video and write a report on it, correct?
he might not know that.
I would have to see that report, sir.
Yeah, he might not know that. Like, legitimately might not know that. Evelyn said he had nothing to do with Proctor's actions, right? I don't think that he did. However, being questioned when you know that Proctor was fired based on misconduct about Proctor and you don't know what's going to come up, it's not like you can be like, oh, I downloaded this phone. He's not quite sure what's coming and is very uncomfortable. This is still where he works. I don't know how the Norfolk troopers feel about Trooper Proctor, because I can only imagine how I would feel, which would be, what the fuck are you doing? Yeah, he should be fired. I don't know how they feel about it. I do know from the text messages how a number of the detectives in this unit feel about this group of defense attorneys. So yes, he looks incredibly uncomfortable to me. So I think it's a good use of this witness on cross-examination. And the more this witness squirms, if I'm the defense attorney, I'm like, oh, you don't like that? Oh, that's unfortunate for you.
Sorry.
But yes, it's giving. I wasn't even supposed to be here today.
Again, if you'd read that silently to yourself and look up at me when you're done.
I mean, I don't know if he can testify to somebody else's report if he wasn't present for any of that, though. I don't think he's getting blamed. I think this witness is purely being used to point out how involved Proctor was. So. This questioning has nothing to do with this witness, truly. I mean, this witness is a proper witness to ask it about, but it's not about him. It's about Proctor and pointing out to the jury how much Proctor was involved in this investigation to start to highlight the fact that, hey, ladies and gentlemen of the jury, y'all haven't heard from Proctor yet, have you? Emily, did you put all your lip gloss on? No. No, I didn't. No, I sure didn't. I should look when I'm doing things. So, Sydney Smith asked in the chat if I think there's any chance they don't call Proctor. I mean, I can't even fathom how they wouldn't. But if anyone has the chutzpah to give it a try, it would be Brennan.
Refresh your memory about Michael Proctor being the one to write the report on the analysis of the waterfall video?
I mean, sir, I only obtained a copy of the surveillance video.
Right.
I did not do any analysis on the video.
That's my question. It was Michael Proctor who did the analysis, correct?
Yes.
And that, by the way, I said waterfall. Is that C.F. McCarthy's there, or is that waterfall?
This is C.F. McCarthy's.
Okay, I meant C.F. McCarthy's. He was the one to review that video, correct?
Yes, again, I only got a copy of the surveillance video.
Sir,
I did not do any
And
analysis.
with regard to the waterfall,
I
bar
wasn't
and
even
grill,
supposed to be
That was
here.
another circumstance where you and Sergeant Buchanan were the ones to retrieve the video, correct?
Yes.
But again, lead investigator Michael Proctor was the one to analyze the video and write the report on it, correct?
Did you chuff? Chuff?
Fall Bar and Grill. That was another circumstance where you and Sergeant Buchanan were the ones to
I had to back up.
retrieve the video, correct?
Yes.
But again, lead investigator Michael Proctor was the one to analyze the video and write the report on it, correct?
Yes, I would have to see that report as well, sir.
Now,
oh boy.
another member of
Oh,
your
boy.
unit was Trooper David DeChico, correct?
Yes.
Within your unit, did Trooper DeChico have a nickname for a first name?
Objection.
May we
What?
approach?
Well, there we are, folks. We're at what the fuck with this guy? Because if there was ever a face that said, what the fuck's with this guy?
Name for a first name?
Objection.
The fuck with
May
this
we
guy?
approach?
100% the fuck with this guy. What up with him? Oh, boy. If Yannetti saw that, this cross is going to get much longer. I don't know why they're asking about DeChico having a nickname for a first name or whatever. I have no idea. But this witness is like, fuck's up with him? The defense is using this witness to highlight how involved Proctor is in this. And I think to illustrate to the jury, hey, you haven't heard from the lead detective yet. Because if you're sitting on that jury, it is really hard to distance from what you know about Proctor. But if you're sitting on the jury, aren't you sitting there going, I mean, we haven't heard from the lead detective yet. We're asking this guy all about it. But he's, oh boy. There's only so much Yannetti can get into, though. Yannetti can get into what this witness did, what this witness knows about how the unit operates, what this witness knows personally about what Proctor did. But if this witness isn't actually a part of other things, he can't just say, well, did you know there was a group text? He can't ask him unless he's a part of it.
Trooper, in terms of the troopers that were in your unit as of January 29th of 2022,
But he's the smirky
which
faces.
members of the unit had the least amount of time in the unit at that time?
I don't recall.
Were you one of the newer members of the unit?
Probably.
As of January of 2022?
Yes.
Yes.
Trooper Michael Proctor had more experience than you.
It's going to get really uncomfortable.
I don't recall.
Were you one of the newer members
I
of
wanted
the
to see his
unit?
face again.
As of January of 2022?
Yes.
Yes.
Trooper Michael Proctor had more experience than you did as of January 29th of 2022, correct?
He could have. He'd been on the job longer.
Okay, well, if he had been on the job longer, then certainly that means that he did have more experience, correct?
It depends.
You attended the autopsy of John.
Sir, if he's been on the job longer, does he have more experience? I don't know what the fuck that guy was doing at work, but honestly, fair. I don't know what the fuck that guy was doing. Honestly fair. Honestly fair on that point. The fact that Yannetti is not asking questions at 1,000,000 miles a minute at this point, as this witness is getting more displeased with being asked about Proctor, is truly a credit to Yannetti. Yannetti has been able to rein in what I imagine at this point is his own glee, because Yannetti's just got a fish on the line at the moment, and you can't get overexcited. You can't start reeling him in too fast. You gotta be chill. But also, you gotta be chill. Oh, Yannetti. Boy, oh boy.
Keefe on January 31st.
Wait, I'm going to back up just a little bit because I missed the question, because there is so much happening in this cross-examination that is not just the questions being asked. And we are seeing Yannetti is going to have to, don't get suspicious. Don't get suspicious. Because there's more to come.
job longer, then certainly that means that he did have more experience, correct?
It depends.
You attended the autopsy of John O'Keefe on January 31st of
I did.
2022. And with regard to other members of your unit, you were the only one to attend that autopsy?
Yes.
That was done at the medical examiner's office?
What?
The medical examiner's office in Sandwich.
The lead investigator didn't attend the autopsy? They had one of the most junior members on the team, no offense to dude, attend the autopsy of John O'Keefe. Are you fucking kidding me? The lead investigator didn't go to the autopsy, which is unusual in a normal case, unless the lead investigator is, I don't know, out on maternity leave or in the hospital themselves. Like, the disrespect. And not only did the lead investigator not go, but the lead investigator's partner didn't go. Like, robbery, homicide would never. I can't even. Not only did he not go to an autopsy, which the lead investigator or his partner should do, but at the end of the day, this is still an unknown. Oh, wait, no, Proctor had already decided what the cause of death was. But by all good investigative techniques, this is still an unknown death that's being investigated of a police officer. And not just a police officer, but somebody who the community is aware of, whose family tragedies were well known. And you don't go to the fucking autopsy? I don't think I could be more mad, and I'm more mad. It's just, I am continuously staggered by how much more we learn of how bad shit is. Just why? Lovable Swampbush said, why would they, Emily? Exactly, because that's the answer in this case. Why would I? Why would Proctor? He had already texted all his buddies that it's, the girl. Oh. I am stunned. I'm stunned. And generally, with the death of an officer, you would often also have a district attorney at the autopsy. There were a lot of times DAs went to the autopsy. And we did a lot more fucking autopsies than y'all did. It's so unacceptable. It's just so
It depends.
I can't.
You attended the autopsy of John O'Keefe on January 31st of
I did.
2022. And with regard to other members of your unit, you were the only one to attend that autopsy?
Yes.
That was done at the medical examiner's office?
The medical examiner's office in Sandwich, Massachusetts.
In Sandwich, Mass. And it was Dr. Irene Scorti-Bello who performed the autopsy, correct?
Yes.
Had you met her prior to that day?
No.
Had you spoken to her prior?
Had you ever attended an autopsy as the only one attending the autopsy?
To that day?
No.
Did you know before the autopsy was performed that your former colleague, lead investigator Michael Proctor, had discussed the case with Dr. Scorti-Bello without telling us what you knew of what was said?
Objection.
With
think
regard
that's a fair-
to Dr. Scorti-Bello's knowledge of what the state police theory was of what happened, did you have to explain that, or was it your understanding she already knew what your theory was?
Objection.
Mrs. Staines, you can ask that differently.
Chicken tender, I did prosecute
What, if
homicide
any,
cases.
conversations did you have with
Not
Dr.
solely.
Scorti-Bello
I did a lot of white-collar crime.
about what your unit's theory was about what happened to John O'Keefe?
There was no theory.
Okay. You did not provide
You were
any
not aware.
theory to her, correct?
I did not provide a theory.
You learned at the autopsy from your observations that John O'Keefe had 2 black eyes and a swollen right eye, correct?
Yes.
You also learned that there was
It's
a...
actually probably better for the prosecution that this is the person that went to the autopsy at the end of the day. I'm flabbergasted. It is probably better for the prosecution that Proctor wasn't there and that Proctor wasn't talking to the coroner, because we have it in texts and we will see the coroner testify about it. But case-wise and prosecution ways, it's probably better that it was just dude.
small cut above his right eye, correct?
Yes.
And there was a small abrasion on the left side of his nose, correct?
I would have to reference the report for the exact words.
Okay. If I may have a moment.
I really like how the defense is using this cross. They are highlighting what the jury doesn't know yet for the jury. They're highlighting who hasn't been called yet. And they're getting information in through this witness that will come in later testimony, but that they want the jury to have in their mind now. It is a very smart and strategic use of this cross-examination.
So I placed another
Ashley asked if I've been to
document in front of
autopsies
you. Just
before.
take a
Yes,
look, read
I
it
have.
silently to yourself
Not
and look up at
my
me when you're
favorite
done.
thing to do. But yes, I have.
And I would direct your attention to the second page for the question I just asked you.
Boy. Brennan didn't ask about the autopsy with this witness, but this witness
Having
attended the
reviewed that
autopsy.
report, Trooper, is your memory
And this
refreshed
witness has been
as
called.
to whether you observed a small
a proper
abrasion on
item
the left side
for
of
questioning.
John O'Keefe's nose?
Yes.
Now, was this the first autopsy that you had attended, or had you attended ones in the past?
I cannot recall.
It could have been the first one?
Most likely not.
When you're attending an autopsy as a member of the CPAC unit or the Norfolk Detectives unit, you are expecting that the medical examiner is going to examine the body, correct?
They do a bunch of other
and
shit.
you're there to witness that examination, correct?
Yes.
At the end of the examination, you are
not-
expecting that there will be a determination as to cause and manner of death, correct?
He's a homicide
Not a-
detective. And in the homicide unit, it doesn't surprise me, because he's probably attended a number of autopsies. It doesn't surprise me that he would be like, this probably wasn't my first. I mean, of all of the things, that is the thing that bothers me the least at this particular moment in time.
In this case,
And he probably went to
when the
autopsies
autopsy ended,
before he joined this
you
unit as
left
well.
the medical examiner's office, correct?
Yes.
When you left, your understanding was that the cause and manner of death was still undetermined, correct?
Objection.
You knew when you left that Dr. Scorti-Bello had seen the scratches.
That probably was undetermined yet, by the way, because they don't do the report at the autopsy. They don't determine that on the spot. The autopsy is, I don't know how to describe it delicately, but the autopsy is kind of taking apart all the pieces to the puzzle. And then they take out all of the organs. They do they send out blood samples for testing for alcohol, narcotics. They weigh and look at the organs, and sometimes they go back and look at them later to see if there's signs of cancer or disease. There's a lot that happens after the physical autopsy is done, and they generally wait for all of the lab reports to come back before they determine a cause and manner of death. There's a whole process that happens after the physical autopsy is completed that day, without getting into too much information. So,
or bites or injuries to John O'Keefe's arms, correct?
Objection.
Ashley, yep.
You knew when you left that in your presence,
Yep.
Dr. Scorti-Bello had seen the injuries to John O'Keefe's arm.
Object to the line of questioning.
Sustained.
It's calling for speculation. That's why it's being sustained. Yannetti's asking, you know that the coroner saw. This witness can't testify to what the coroner saw. I like the strategy here. The questions are going to have to be nuanced.
May we approach?
Okay,
You're asking for speculation.
please
The
feel free to stand up.
jurors, go ahead and stretch. It's going to have to be nuanced. All right. The outrage continues. I'm going to zoom past this sidebar and see what they get into about the autopsy. Diana said, I hope the
Were
jury
you
is
watching
sophisticated.
Dr.
They don't have to be super sophisticated, because this testimony doesn't pass the vibe check with, I think the jury would be like, there's more here, even if they don't know what the more is, just because jurors are so observant in court because there's nothing else to focus on. You don't have your phone. You can't really worry about work. You're not going to work tomorrow. You're in this trial for like 3, 4, 5, 6 weeks. There's nothing else to pay attention to. So you're going to look at the witness's face, the fact that he's messing with his sock, the water bottles that the defense attorneys are drinking out of, whether this water with this witness is Fiji or a water bottle he brought, what shoes people are wearing, what they've got on their desk. They are paying attention to everything going on in the courtroom because there is nothing else to pay attention to. And so they are just like, the brain is looking for stuff to do.
Scorti-Bello, as she was conducting the autopsy,
Yes.
did she appear to be looking at John O'Keefe's body?
Yep, that's an autopsy.
What direction was her?
Yannetti, did she appear to be looking at the autopsy? Did she conduct the autopsy? These questions have to be nuanced. You can't ask him what the coroner thought or saw. He doesn't know. He can't jump into her brain. Did you watch her perform the autopsy? Did you watch her make notes on a paper that has an outline of a body on it?
Were her eyes facing when she was examining John O'Keefe's body?
I don't recall.
Okay. Was she looking at the ceiling, Trooper?
She was doing her job conducting the autopsy.
And in order to do
The
that,
body.
I'm sorry?
She was looking at the body, I assume.
Thank
I'm
you. Thank you. And looking at the body, you saw her looking at the body, correct?
Yes.
And looking at the body included an arm, correct?
Yes.
And it was at the arm was not covered up during the autopsy, correct?
Nothing's covered up during an autopsy.
It was open for you to see, correct?
Yes.
And you saw the injuries to John O'Keefe's arm, correct?
Yes.
You didn't see any bruising on his arm, correct?
He's looking. Does he have
I
photos?
don't recall.
Oh, he was.
You
he was
didn't
looking at
notice any
something.
obvious broken bones, did you?
I'm not a medical expert.
It's a fair answer because you can have broken bones that you can't see.
It is common practice for the state police to attend autopsies. when
He had been
there's,
given the autopsy
an
report. He
undetermined-
had been given the autopsy report by Yannetti, and so I don't know if he was looking at it, but there are things he really can't answer. Did you observe any broken bones? Could he have said, I'm not a medical expert, but I didn't see bones sticking out of skin? Maybe, but
and death, correct?
Yes.
he's going to stay in his lane, and he should. Yannetti, we're going to jump the shark on this line of questioning
And it
real
is common
soon.
practice for the state police to attend autopsies when there's an undetermined death, correct?
Yes.
It is not at all common for the defense to attend an autopsy, correct?
I've never experienced that.
Right. And there was no defense attorney or defense expert at the autopsy of John O'Keefe, correct?
Not when I was there.
You were there, correct?
Yes.
And there was nothing that prevented you from giving input to the doctor as she examined the body, correct?
We don't give input. We give the facts that we know so far in the case.
Okay. Well, giving the facts is giving input, is it not?
It's not input.
Okay. Did you talk to Dr. Scortibello during the autopsy?
Yes.
And you gave her information, if you don't want to call it input.
Information's
correct?
fair.
Yes.
And
Input's loaded.
At the end of it, you left without her ruling it a homicide, correct? I have nothing further.
Coroners don't make that determination
Thank you.
during the autopsy. I'm surprised Brennan didn't clear that up. Coroners don't make that determination during the autopsy. Also,
Jurors, this break we're going to take now.
the court's making a face. We got to get back to the court's face in just 1 second. Coroners do not make determinations until they have finished with all their reports. They always wait for the testing and what have you to come back. I've never seen an autopsy where they do the physical autopsy and make a determination before toxicology and all of the other testing comes back. I mean, maybe coroner armpits would. Like, never say never. But it's interesting to me that the prosecution didn't do redirect at all. He was like, yeah, it's fine. It's fine. Well, that was a surprise. I am stunned. The court is making a face at the jurors. Let's see what's happening.
So, jurors, this break we're going to take now. All right, we're going to take a break. The lawyers and I have some work that we have to do, so it's a little bit longer break than we normally take, and it's a little bit earlier, but we did get coffee for you, so we'll take a recess now for the next half hour, maybe a little bit. I want counsel-
30 minutes or more?
All rise for the court, please.
Legal issues.
No one follow me.
Legal issues incoming for everybody who doesn't know the coroner armpits reference. It's from the Murdaugh case, and the coroner said, I determined the body temperature by putting my hands in the armpits. I thought I couldn't be more surprised. I appreciate the court being like, I know I've got to deal with shit with the lawyers, so we got you coffee. This judge is not pleased with whatever is about to happen with the lawyers and that this needs to be dealt with because it is wasting the jury's time. And the judge has been incredibly mindful in this trial and the last trial of the jury's time. And wasting the jury's time is a one of the top things that is going to piss off any judge you'll find. The second members of the public are there waiting, the judge is like, we're on the fucking clock. Do not waste my time with this shit. And generally, if there are issues that need to be taken up, and this is not always something that you can do, but if there are issues that need to be taken up, trying to time that with the court and saying, we have legal issues, can we have the jurors come in late, tends to go better if you can. The chat's asking, who do I think she's mad at? Well, we're in the prosecution's case in chief. So my guess is that she is upset with the prosecution because if this had to do with the defense case in chief, we wouldn't be dealing with it today. So let's see. I'm not going to speculate beyond, but it sounds like the attorneys are still in court. All right. She said 30 to 45 minutes. Let's zoom.
We talked about it.
They did go to sidebar this morning before they came on the record. So let's see. The jury is out.
So I want to talk a little bit more about what we talked about at sidebar. And I read the decision from Maryland, just cursory while we were waiting for the witness. And that was a March decision. And I can't stress enough that this should have been brought up before today. So I'll hear you about your concerns, Mr. Alessi. I'll hear the Commonwealth's response, then I'll go finish reading everything else you gave me. So what are your concerns about?
This should have been brought up before now. New decision from Maryland from March. All right, let's see.
Jessica Hyde. I don't know if she's Dr. Hyde or what, but I remember she testified the last trial. So
Your Honor, it's Dr. Jekyll. Jessica Hyde is a tech expert for the prosecution.
Transcripts.
Understood, Your Honor. I first want to just get quickly the evidentiary basis. This is straightforward judicial notice. There are two separate decisions which require two separate...
One's a Massachusetts case, so that's easy enough.
Okay, so, and that's a shall...
It's an SJC case, so yes.
Yes, okay. So now to the Maryland case. So that's governed by Massachusetts Rule 39A, and that is records of courts of other states or of the United States. The Act provision is the records and judicial proceedings, and of course a court is a judicial proceedings, of a court of another state or of the United States shall be competent evidence in this Commonwealth if authenticated by the attestation of the clerk or other officer who has charge of the records of such court under its seal.
Okay.
So I have with me, Your Honor,
So what's the issue?
that State v. Herrera, Maryland case. I have the certified copy with me from the clerk.
All right, so we can mark
Alessi,
that for
you've gone
identification.
above and beyond on getting a certified copy.
Yes.
Probably because it's so new. State versus Herrera,
It's CC for ID.
Okay.
Maryland.
Thank you.
So
Alessi, since we're all just learning from you, law professor, sir, next time can we get a cite for the whole class? Because now I'm just curious.
assuming Your Honor determines that the seal is the seal, it
That's
is
not gonna be an issue.
mandatory under the rule that it shall be competent evidence, it shall be in evidence. And to the extent the Commonwealth seeks to argue relevancy or materiality, that argument is precluded, Your Honor. And the best evidence of that preclusion is the immediate section below in Rule 39, which is notice of foreign law, which is not this, but it says there, the court shall upon request take judicial notice of the law of the United States or of any state, territory, dependency thereof, or of a foreign country, whenever it shall be material.
What?
So the drafters of this rule knew how to put in a qualification or condition when they introduced materiality in B.
Hang on, chat. We're going to get to
but
the end of his
they didn't
argument.
do it in A.
Okay, so focus on what it is you think Jessica Hyde should be prohibited from testifying about.
That's-
Your Honor,
that's
I am
the issue.
not seeking to prohibit her from any testimony under this rule. What I want to do is to have it admitted in evidence, have it published, and question her on what she presented to the court in the Maryland case, what was presented, her report, because it was deemed not reliable.
Oh. That's where we're at. Let's back up. He's like, no, I want Jessica Hyde to testify. See, we had to let him get to the point. It sounds like Jessica Hyde, the Commonwealth's expert, testified in a case in Maryland, and Alessi wants to be able to examine her fulsomely about a determination in a Maryland court that her report was not reliable. So when another court found that an expert's report was not reliable, he wants to be able to question her about it now. That's from a March case. It sounds like of this year. And he wants to bring that in to question her about it. So I backed him up a little bit as he's making the point. The court said, so what do you want her precluded from? He's like, I don't want to preclude her from shit. I want to bring it all. Alessi wants to mention it all. He's like, receipts, screenshots, timeline, fucking everything. Mention it all. Your Honor, I don't want to preclude anything. Let's ask. All right.
Okay, so focus on what it is you think
So that's
Jessica
the point.
Hyde should be prohibited from testifying about.
Oh, Your Honor, I am not seeking to prohibit her from any testimony under this rule. What I want to do is to have it admitted in evidence, have it published, and question her on what she presented to the court in the Maryland case, what was presented, her report, because it was deemed not reliable. And that is what...
In one area, right? One specific area?
Well, you can call it... one
The
area.
decision.
Right. Oh, yeah, just what's in the decision. But there's two parts to that decision, two areas. It's FLH, frequent location history.
Right.
But what the court also got at was Apple source codes. That she didn't have the Apple source code.
Nobody in the country has the Apple source codes, right?
Point exactly, Your Honor.
What is it that, so you want to put in her report and question her about a proceeding in Maryland? I need to know exactly what you're asking
If I could
me
proceed
to allow.
and give you the answer, Your Honor, I will
ahead.
explain it. It's a very short answer.
Oh
Okay.
boy, oh
What
boy.
I want to do is, with regard to her 227 timestamp and her anticipated testimony on that, where she uses a tool, Celebrite,
A tool.
to determine and
BRB.
come to a conclusion about that timestamp. She is not using Apple source code to find where that's located specifically in the phone and what it means. She is
that's
using
fair.
a surrogate to do that. And I want to cross-examine her on the topic using this decision to say, in Maryland, you tried to do the same thing with regard to FLH. You tried to use a surrogate approach and make an opinion about whether that is, in fact, what's in the phone. She can't do it, and that means her testimony on 227 is not reliable. I'm not looking to exclude it. I'm looking to cross her on her reliability for the conclusions I anticipate she's going to make on 227.
So if she is not asked about that, then what?
Oh, if she's not asked about the 227,
Then how's she relevant?
And I want to think about it, but I'm 99% certain I am not going to pursue that at all.
I mean,
What do you say, Mr. Brennan?
This is an attempt to try to...
all right, Mr. Brennan, I'm going to let you pop off because it sounds like you're gonna, but Alessi wants to go beyond the cross-examination. He wants to admit as evidence the court opinion, which is unlikely that the court opinion will come in as evidence. It doesn't mean it won't be allowed for him to question her about, but the opinion, the text of the opinion itself is not evidence in this case, but it can be impeachment. All right. Brennan is already like all just spicy.
malign a witness with something that's wholly unrelated.
He wants to malign a witness with something that's wholly unrelated. All right.
About the 227, and I want to think about it, but I'm 99% certain I am not going to pursue that at all.
Okay, what do you say, Mr. Brennan?
This is an attempt to try to malign a witness with something that's wholly unrelated and not relevant to what she's going to testify to or the basis for her opinion. It is not a law that is admissible. It's an opinion. It wasn't even about a specific case. It was about a peer review. And so in a Daubert hearing, the court did not allow testimony on significant location. That's not the case here. Try to conflate the argument saying it has something to do with Apple 227. There is absolutely no basis for that argument. They want to say that another court rejected something about you, therefore the jury should reject you. There is no relationship between what she is going to testify as a basis and that opinion. That opinion did not say she was wrong. It said that it was not admissible under Daubert, unrelated. Nobody has the Apple source code. No expert can testify about Apple source code. It's only owned by Apple. And so using the words like surrogate is a way to try to cheapen her testimony in front of the jury. This here, number one, what he said, I really can't follow him. I don't understand, other than he's trying to draw some type of relevance and materiality. There's none. There's none. This is not a denouncement. She hasn't been found incredible. There's nothing about her methodology that has been rejected by a court. This is on significant location.
It sounds like they've limited her testimony.
Opinion whatsoever. And so because another court didn't allow something under a Daubert, has nothing to do with this case. Nothing.
If it's only on significant location, then that's fair.
What is it that you expect her to testify to, Mr. Brennan, regarding the
Brennan is saying the issue that was not allowed after Daubert hearing, and courts do that and say, in this case, you are not testifying about whatever it is. Brennan is saying it's about significant location only. If that's what the case says, and that is not what she's testifying to here, then it is unlikely that it will be proper opinion or proper impeachment, because it's not about what she's testifying to here, which is why the court wants to read the entire ruling on that Daubert-Lanigan hearing.
207 stamp. We did not have this issue with Mr. Whiffen, right? This was not raised with
This was not raised with Mr.
It
Whiffen.
was. The 227 timestamp would.
No, that
Significant location wasn't raised with Whiffen. Not having Apple source code was.
that was raised, but this, what was problematic in Maryland, the same thing that was problematic in Arrington.
That's correct, Your Honor. It wasn't raised because Mr. Whiffen has not been Daubertized with regard to source codes. And if I could, Your Honor,
Okay.
Mr. Brennan has made a relevance argument. He keeps anticipating my cross, which he has incorrect, by saying it's not relevant. That doesn't go to the admissibility in my cross. I'm entitled to cross her on her reliability. And if I could,
As
Your
to
Honor,
the things
in
she
the
testifies
Herrera
about.
decision, if Your Honor would look at page 3, please, at the bottom, the paragraph, it says, in assessing the reliability of an expert's methodology, I get to do that on cross. It's not limited to a Daubert hearing. Every expert can be crossed on their
Fair
reliability of their methodology. And lastly, with regard to the Apple source code, if Your Honor would please turn to page 6, the last paragraph, it says the issue raised in this case stems from the fact that Apple's algorithms are proprietary and the expert did not have access. That's exactly the situation here and what I want to
But
cross her on.
that doesn't make her per se unreliable. It means that the information she is trying to get cannot be obtained because of the way that Apple has proprietary information, because no one can have access to it.
So in conclusion, Your Honor, the fact that how she tried to get around the Apple source code, her methodology in the Herrera case, she got Daubertized on because it wasn't reliable. That's exactly what I want to cross her on, is her reliability, how she's trying to get around them. In this case, it's just basic cross-examination.
Well, then why do you need to admit it?
You can see the plan to dehumanize somebody, Daubertized, to use a term.
Brennan, the drama. to dehumanize someone. Okay.
Just basic cross-examination.
You can see the plan to dehumanize somebody, daubertized, to use a term to suggest some type of conclusion that has no basis in fact is an attempt to just dehumanize her and limit her testimony and credibility without any basis in fact. In that case, it did not deal with the search of a tab and a suspended state in Safari. It didn't deal with
Just
the timestamp.
stick with that argument.
It was an entirely different issue.
Without the
By
drama.
their analysis, if a expert goes into court on a motion on anything to do with data forensics, and the court says that issue is not admissible, they should be impeached when they go and talk about a totally different issue in forensic data analysis at another case.
If
they
they've
have
been
not
found
shown any
unreliable,
evidence
that can happen.
this issue has anything to do with her effort in the timestamp. They just used the word methodology. Her methodology was questioned in an opinion in a different court.
It actually doesn't sound like it
Has nothing to do with her opinions
was.
here. What information do they have that her methodology in this analysis has been rejected by any court? What evidence do they have?
It sounds like what the court in Maryland found is that the extrapolation was a bridge too far. That's what it sounds like the argument is here, that it was just, you know, one step closer to the edge. And that was too far because you don't have access to the Apple source code. And the court said, no, we're not taking that step towards this analysis with regard to significant location. But this just came up today. I'm sure the defense will have filed something. And if they do incite this case, we'll talk about it another day. But the drama of the fighting over the word daubertized is just... And the thing is, Brennan has a good argument. The argument is this is on a completely separate subject in a completely different area. So that case doesn't get admitted as evidence. It's not evidence in this case. But he steps all over that argument by starting with the drama.
The methodology used in this case is unreliable or improper. They don't have any. In fact, they called an expert themselves in the last case who tried to provide what he believed to be methodology, and they presented that. They proffered that evidence as reliable. No different on this subject. Herrera case is a totally different subject.
Your Honor, first of all, as the court has noted, the first trial is the first trial. This is this trial. I wasn't at the first trial.
New trial, Your Honor.
The most important and probative aspect, Your Honor, is I don't want to have to give away my entire cross in this argument.
No one's asking you to. I'm not asking you to.
There
Which is
is
fair.
parts of Ms. Hyde's slide that go to location. There's a good part of her slide presentation. I don't want to depart from the 227, but the good part of her slide presentation that she's going to present is on location. It is with regard to
Well,
outdated
that's
stats.
more important.
So there are certainly aspects directly relevant. Here is the issue with the 227 in addition. There is, for her methodology, she's claiming a certain conclusion and opinion about the 227. There is no peer review. There is no article that she can cite to support her methodology to come to the conclusion that the 227 timestamp, one, doesn't exist anymore, or two, doesn't mean that the search occurred at 227. That's what she's opined on in her reports pre-trial, and that's what I anticipate she's going to opine on when she takes the stand. I'm entitled to cross her on that. We can't be saddled. It's irrelevant what our witnesses said in another proceeding. It's what this witness is going to talk about in this matter, and I'm entitled, and my client's entitled to have me confront this witness on what she's going to testify and her methodology. So my point is, Your Honor, this decision, how do you impeach an expert? But one of the fundamental ways you do it is, and I don't mean to dehumanize her, I won't even use the term daubertized anymore. She's been deemed unreliable.
Oh, Alessi, Brennan's being dramatic on that. The dauberting is the least of our concerns in this courtroom.
Experts all the time, that's the verb you use to shortcut it, but I won't use it. I have no intention to dehumanize her. What I intend to do is to impeach her on her reliability. So in conclusion, Your Honor, the Herrera case, she was deemed not reliable. That's competency. you and any expert that's been deemed that, you get to attack that. If the Commonwealth believes the case is not relevant, if Ms. Hyde believes it's not relevant, let Ms. Hyde defend that on the stand. Let Mr. Brennan make that point on redirect. But I can't have my client's constitutional right to confront her on the very subject matter she's going to testify on by anticipating what I'm going to provide for cross. I've given it, and I respectfully submit, Your Honor, this is basic cross of an expert witness, particularly when their methodology on data forensics has been deemed not reliable by a court. And one part is the location. She has in her PowerPoint she's going to testify.
Do you intend to introduce that, Mr. Brennan?
It's not significant locations. There are locations in the database that develop the opinion that the timestamp for 227 is not related to the search. They're conflating the issue. She has not been deemed unreliable. It is the issue of the significant locations by that court that they found insufficient. There's no opinion from a court that she's an unreliable expert, and this is how they're going to distort it. Invoking the Constitution and invoking the client's rights has nothing to do with the analysis. That is a totally separate subject, or an opinion simply wasn't let in a different court out of this jurisdiction. It wasn't this opinion, it wasn't this methodology for the opinions that she's going to offer in this case. And so if you look at the case, it is a totally different related report, different related item. It's as if a reconstruction expert went into a court and attempted to give an opinion about a medical diagnosis, and the court wouldn't allow that medical diagnosis in. In another court, in another jurisdiction, they would not be.
He just cited back what the court did in the last trial. Like if an accident reconstructionist was going to get into a medical diagnosis and it was not allowed to be given, he just flipped it back to ARCA. I mean, okay.
To be cross-examined that in some court,
it doesn't mean they're unreliable.
That was deemed inadmissible.
A fair argument.
Unless they were talking about the very same methodology and the very same point. This has nothing to do with her opinion whatsoever. It's just an attempt to try to endorse the defense's attempt to suggest she's not credible by hiding behind the shield of a different judge and distorting the fact that it's two different methodologies, it's two different issues.
One last word. Go ahead.
Thank you, Your Honor. You just said credibility. This isn't a credibility issue. This is a reliability. This is the essence of what
they're different.
You have to show that your methodology is reliable. It's a red herring to bring up credibility. The court opinion.
And this is the equivalent of a Superior Court opinion, right? It's not an appellate decision.
It is, Your Honor. It is the equivalent.
Right.
I respectfully don't think that the level of the court is at all relevant. Any
it is
court,
to this
unless
court.
you get it overturned on appeal, then this would be a different matter. But this is the a valid case, and even if it wasn't, it shall be in evidence. So there's two issues here, and I don't think
you're going to get it in evidence.
Conflating that.
I think you get to ask about it.
First for the court
I don't think it comes into evidence.
Is this admissible? Can it come into evidence? To me, that's a non-issue. Rule 39 says ipso facto, yes, as long as I've got a certified copy. So it is in evidence. Bing, bing, bing. I don't know why we're perseverating respectfully on whether I can question her on something that's.
You can't hit us with an ipso facto and then a perseverating immediately following it. Back up and let his argument go. But I love the way Alessi argues, even when he's being dramatic. I don't think he's going to get that case, the case itself in evidence. I think he gets to question about it.
Can it come into evidence? To me, that's a non-issue. Rule 39 says ipso facto, yes, as long as I've got a certified copy. So it is in evidence. I don't know why we're perseverating respectfully on whether I can question her on something that's going to be in evidence about her.
Because you asked to admit the certified case into evidence, and that is an issue. You should be able to question her about it. I don't think you can put the case in evidence. I think it gets split in the middle.
Final point. Mr. Brennan incorrectly says that this wasn't about her. The final sentence, the decretal section on page 7 says, accordingly, defendant's motion to exclude expert testimony regarding the significant location data obtained from the forensic cell extraction is granted. She's the only expert, and her name is mentioned throughout this opinion. It's all about...
That happens in other cases where the expert's not allowed to get into an area, and it goes to the nature of the case and not necessarily the nature of the expert. But we'll see what he has to say.
It's hot. And I'll conclude my last point, Your Honor, where I started, and that is Ms. Hyde's methodology with regard to her PowerPoint. You heard Mr. Brennan's answer. He is going to include, he has included in her PowerPoint locations, steps, etc. It's exactly what was at issue here. The 227 timestamp, she has no, and this will be developed further on cross, she has no peer-reviewed article to say that how she is determining that that 227 timestamp should not be in the data. She has nothing to support that, just like she had nothing in this case with regard to data forensics. Final point is, if the Commonwealth believes that this is irrelevant to what Ms. Hyde did, let them come back on redirect on that. I shouldn't anticipatory have my cross-examination struck before I even get to pursue that with the witness. And I believe once I pursue it with the witness, it will become evidently clear that it's a proper basis for cross-examination.
All right, and Mr. Alessi, have you thought about if the Commonwealth does not get into the 227 timestamp, whether you think you're still
They might
entitled
just
to
need
do
to
this?
voir dire on it for the judge
Your answer,
feel
my answer is I wouldn't
comfortable
be
with
entitled,
that.
but I would say this. If they don't get into 227, I won't go after it. I won't pursue it. I won't pursue use of this opinion.
There's really no point to this witness if they're not getting into
would
227.
have to on some basis, because in order for the witness to explain to the jury her opinion that Ms. McCabe did not delete any Safari browser searches, she would have to identify the search, where it is in the databases, and how she can tell, how she knows that it wasn't deleted by a user. The same with the second part of the phone calls, but if I could avoid talking about 227, I would, but it is necessary for the basis of her opinion. There's just no way around it. And again, this is
Obviously,
something
it's
that,
necessary.
after a defendant expert may or may not testify, could be addressed at that point. There is no burden on the defendant. I'm not being presumptuous, although there was a offer of proof earlier on similar evidence. But not knowing the court's wisdom on whether I'll be entitled to rebuttal, I do not want to lose the opportunity to address points that were made in the opening that have absolutely no basis in fact and have not been proven in any way to this point in the case.
So I asked earlier whether the defense intended to call Mr. Green, and you believe that you do, right?
Your Honor, we have not made a decision on what data forensics expert we're going to call, but if I could just 10 seconds.
Okay, but then answer my question after your 10 seconds.
I will.
Okay.
Mr. Brennan can't have it both ways. He can't say, yes, I need to address the 227 timestamp, and then deny me the ability to cross-examine fully on this expert's methodology and to impeach her and to get at her reliability and her competence, which is a key issue of crossing an expert. Her competence has been determined in this decision. And it is her, because it was her report that was the basis for the court to not allow her to testify. They can't have it both ways. You can't say, I need to do it in direct, but no, I want to handcuff the defense on cross-examination. Now to answer your question, Your Honor, we are going to have a witness that is going to address the 227 issue.
Okay.
Whether it's Mr. Green or somebody else, we haven't determined. My point on that, Your Honor, is we shouldn't be limited in our cross-examination of the Commonwealth.
No, I'm just thinking it in terms of whether this might be appropriate for rebuttal. That's...
Yeah. And Your Honor, my point would be that's obviously going to be Your Honor's decision ultimately. But again, the Commonwealth can't have it both ways. They're the ones who are triggering this issue, and I say triggering in a legal sense. They are putting at issue the 227 timestamp with this
Look,
issue.
don't get it
with
twisted,
this
Brennan.
If they weren't doing that,
This came
I
up
wouldn't
because
be
of what
having this
you're seeking to
discussion at
admit.
all. But they're putting it
Right.
at issue. I have the right, respectfully, to cross-examine on the issue that they're putting in issue, and they shouldn't get rewarded with sort of having a pre-authorization of rebuttal to deal with it. They should have to meet their burden of rebuttal depending upon when the evidence comes. But I don't believe just because we may call a witness, that should dilute my ability to cross-examine this witness on an issue they're raising. I'm not raising it.
You can see why I wish I had more notice on this, right?
Your Honor, I have no good answer for that.
So I will do what I can in the next half hour. I might need more time on this, frankly, but we'll
Can
see.
you call another witness?
She's here?
Your Honor, may I ask one
What? Wait,
I
is
just
she
want
here?
to know, is she here?
He is, Your Honor.
Bring her in
Can
and
she
question
stay
her.
another day if need be?
I think she'll do what the court directs her to do. She would have to leave by Friday. She cannot be here. Well, may I approach?
Yeah, why don't you come up?
Oh boy, oh boy. Well, I guess Miss Hyde is the next witness for the Commonwealth. And we've got a number of issues going on in court. So, as they approach, hold on, let's see if we can zoom past. No, let's not zoom past. Let's kind of take a break and explain what's going on. It seems that the Commonwealth's next expert is one of their tech experts, Jessica Hyde. The defense brought in a case from Maryland from March where Jessica Hyde was the expert in that case. And during a Daubert hearing, the court narrowed the scope of Jessica Hyde's testimony. The court made certain findings. Alessi has represented, I haven't read the case yet, but Alessi represented that the court made certain findings that the information regarding specific location that Jessica Hyde wanted to bring into the case, because she did not have access to the Apple source code, was not reliable information, because the only way to get to that information is through proxies, I think is the exact word Alessi used for it, because you don't have access to the Apple source code. Alessi gave the court a certified copy of that ruling and asked the court that he be allowed to bring that ruling into evidence and question her on it. I think there are two different issues here. One, can that ruling be brought into evidence? And two, can she be questioned about it? And I think that the differentiation there is that the ruling is likely not proper evidence. Even if it's used as impeachment, it doesn't mean it comes in stamped so that the jury can read it later. But it doesn't mean that he can't ask about it. You can bring in a lot of information for impeachment if it's relevant to this witness, and it seems that a limitation by another court on what she could testify about is something she can be questioned on, and then she can explain or not explain, saying the court found that the not having access to the source code meant that she could not testify about that issue. One of the issues here, though, is whether or not that is the same type of information that the prosecution is seeking to admit with this witness here. And the court is saying, what I need you lawyers to do is explain to me if the court's ruling in Maryland about specific location is part of the underlying foundation, basis, or testimony that she is giving here. If it's on a completely different subject matter, then maybe it is not proper grounds for cross-examination. But if it's on the same subject matter, maybe it is. And if the issue really is that you can't get to the Apple source code, so some of these things can't be determined, the defense should be allowed to question about that. How accurate is the way that you get this information, depending on what information is being used? So the court said this really should have been brought to my attention earlier, which it should have. Alessi said, I have no explanation for that. But what the court didn't say is, and I will not consider it, you brought this up too late. She did not say that. The jury is here. The court is taking not only more than a half an hour to explore this with the attorneys and let them argue, but taking time to take this ruling back into chambers and determine it. The court's like, I might need more time because it is nuanced. It is a multi-part, nuanced determination, and that witness is there and ready to go. But the court is taking the time probably to go read the entirety of the ruling, and then we will see if the court determines that what needs to happen is to bring Jessica Hyde in for a voir dire outside the presence of the jury and try to get to the heart of this, which is not preferable for the defense, I would imagine, because then the witness has a heads up. But the witness is going to have a heads up anyway, because Brennan is going to say they want to ask you about this case, so you're going to need to be able to explain it. So let's see if we can zoom past this court break and catch up in real time. I don't even know if we have enough zoom room for that today. Oh, we do. We do have enough zoom room. Oh, look at us today. We have enough zoom. I am so curious to know what's going to happen. I am so curious. So let's see what the court does. I want to know everything. Erica's Way asked, why would the judge deny this? There are a number of different parts here. I don't think bringing in a certified case from a different jurisdiction is proper evidence. We would have to see more in court for me to change my mind on that. It doesn't mean you can't question about that subject matter if that subject matter is interrelated to what this witness is testifying to and the determination. So with that, let's go back to court. Let's go back to court. I want to see everything. I want to know. I want to know everything. I want to know. I want to know.
Enter your participant. Please enter the pass. You have joined the meeting as an attendee and will be muted throughout the meeting.
The judge has all of the books. The judge has all of the books. We got evidence in there. We got all the things,
and will be muted throughout the meeting.
Look at all of the things.
The host would like you to unmute your microphone. You can.
I don't know. All right. I appreciate
don't know what the WebEx nonsense.
The time. I appreciate people's patience. So, in reviewing the rules, I look at Rule 2. So, Mass Rule of Criminal Procedure, Rule 2, Purpose and Construction. And so, upon reflection and consideration, it says, these rules are intended to provide for the just determination of every criminal proceeding. They shall be construed to secure simplicity in procedure, fairness in administration, and the elimination of expense and delay. Also looking to Commonwealth versus Durand. I don't have the site. I know it's from 2016, 2017.
Is that in the annotations?
Robert Kane was the trial judge.
Yep.
So because none of the purposes here in Rule 2 are served by the admission of the Maryland trial judge's decision, particularly were offered without notice to the court previously, I'm excluding that decision. Your rights are saved, Mr. Alessi. We've got that decision marked for identification, and you certainly are free to cross-examine Ms. Hyde regarding her methodology.
That makes sense.
That's my decision. So, bring the jurors in, please.
Okay.
You are unmuted.
That's
Christy, do you want this under that?
actually what I thought was going to happen. So, and I think that's the appropriate ruling. The ruling itself, just so we're clear, the ruling itself is not going to come in. I don't think the ruling is proper evidence. The stamped copy of the text of the ruling is not coming in. I agree. I don't think it's proper. But he can question on cross-examination about it, which is really what he wants to do anyway. So that's really the heart of the thing. He can ask her about it on cross-examination. The jury cannot read the ruling from another case. Why? It's just going to confuse the jury. It's not proper evidence. I don't disagree. So he gets to ask about it on cross. I think that's the fair and proper result. And if the court had had more time, I think you would still get to that result. And I also think that bringing the case in as evidence is never going to happen. Impeachment materials don't come in to evidence like that. Even last trial when we saw the EMT Katie McLaughlin impeached with regard to photographs, she was shown them, but they didn't come in as evidence. And that's not surprising. So he'll get to cross-examine about it. I think that's the absolute right result on that. And the court did it fairly quickly. So Jessica Hyde, it sounds like, is the next witness. Okay. So let's see. Flamewine said he quoted the statute that said the case shall be admitted if it's a certified copy. It still has to be relevant, though. Being a certified copy doesn't make it relevant. Being a certified copy means it's a way that it can be admitted. It doesn't have to be a business record. You don't have to lay foundation for it. You don't have to bring in a witness to say, yes, this is the case, but it still has to be relevant and proper evidence. The certification is only one piece of it. And I agree. Let's fast forward as we get into, it seems, Jessica Hyde and the jury coming back into the courtroom. So let's see.
Next witness, Mr. Brennan.
The Commonwealth calls Jessica Hyde.
We only fast forward them all waiting for the court's ruling because we had Zoom room. So now we're getting to witness Jessica Hyde. All right, what witness are we on? 23? All right, as Jessica Hyde walks in, the last trial, there were camera issues and all the things, and she ended up testifying with like a nose cam on like a Zoom. It was the weirdest thing ever. So we'll actually get to see this witness testify without the weirdest nose cam angle. It was so unfortunate and it was so distracting, but there was a brief period last trial where the pool cameras got punished by getting like the pool cameras got sent into timeout, and there was like a little webcam stuck at the bottom of the witness stand. Like, it was terrible. It was just so rude. All right. So witness 23, Jessica Hyde, is on the stand.
All right, Mr. Brennan, whenever you're ready.
Thank you.
For
Good afternoon.
More tech.
Good afternoon.
Could you please introduce yourself to the jury and spell your last name for the record?
My name is Jessica Hyde, Jessica space Hyde.
What do you do for a living?
I'm a digital forensics examiner. I'm also an an adjunct professor at George Mason University, where I teach mobile device forensics in their graduate program. I also own a digital forensics company that does training, services, and research.
In addition to teaching at Georgetown University, do you teach in other ways?
Correction, I teach at George Mason University, not
sorry.
Georgetown. But thank you. I also teach, my company writes and develops training courses. I teach a mobile forensic analysis course and a data structures course there to law enforcement, civilians, etc.
Do you engage in any other type of academics or research?
I do. I do other research as part of some volunteer activities I do in the digital forensics field. So I'm the chair of DFIR Review, which is a body that reviews practitioner-created research so that it can go through peer review. I often do reviews as a member of a reviewer for Forensic Science International Digital Investigations Journal, which I was a previous associate editor of.
What does peer
Oh, I'm
review?
so sorry.
The court reporter's like, ma'am, it's okay to speak up and slow down. Just take a breath. Like, just take a breath. Just take a breath. Just take a breath.
What
Just
does
take a breath.
peer review mean?
Peer review means that when a study is done or a research paper is done on a topic, that an assessment is done of it. There are three types of assessments that can be done. One is a methodological assessment, where you read through the methodology of the academic or practitioner-created paper and state if it is acceptable or not. The second is you conduct your own testing using the same methodology to conduct a peer review with your own generated data sets. And the third is if the original author has shared their data sets, reviewing their data sets and checking that against their work.
Has any of your work been peer-reviewed in the past?
I've had 2 peer-reviewed journals. I've had an article that was peer-reviewed and published in Forensic Science International Digital Investigations regarding the standardization of file classification of recovered items. The layman's term of that would be talking about what deleted means. And then I have another paper that's been accepted.
Lyndon's like, I
that
read
a
that.
co-author on in terms of timelines and correlations of forensic evidence.
You mentioned you work in forensic data analysis. Generally, what does that mean?
It means that I look at evidence of digital forensics devices, be them mobile phones, computers, Internet of Things devices, and do analysis to provide meaning and context to the data that's recovered from them, as well as performing data recovery of those same computer-related devices.
Did you have any specific education or training to learn about forensic data?
Absolutely. I have professional training both from courses I've taken as well as I have a master's in digital forensics from George Mason University, a master's degree in that. I've taken multiple courses, advanced mobile analysis, iOS forensics courses from SANS, computer forensics courses from SANS. I have multiple certifications. I hold the GIAC GCFE, which is the GIAC Certified Forensics Examiner. I also hold
That's a lot of
the
letters.
NWC 3CFE, which is a Certified Forensics Examiner.
Do you, through your company, teach other forensic examiners how to study forensic data?
Correct. I teach government agencies, both federal and state and local, how to do digital forensic analysis, as well as private sector digital forensics examiners.
How do you teach private digital forensic examiners? What's the method?
I've developed an online virtual course that we teach virtual live, so I'm always there when I'm teaching. But I also have a team of instructors. So, for example, the mobile forensic analysis course that I developed right now this week is being taught to a police department in Texas right this moment.
Forensic data analysis seems like a broad field. Is there certain parts that you focus in?
I personally specialize in mobile phones and Internet of Things devices.
I want you to just give us some very
Internet of
basic,
Things
very general
devices.
and brief background.
Okay.
When you're looking at a forensic device and you're analyzing it, do you rely on any tools?
That is a really interesting question. Reliance on tools is not precisely what we do. We utilize tools to extract data from a device, and then we utilize a variety of tools to attempt to parse results from those devices. But the forensics examiner has to take
very
the
much into
additional
words
step
have meaning.
to both understand, validate, and provide meaning
The forensic examiners
to those results.
are very particular
Is there any
about
shortcomings or dangers
how
in
they
simply
do their
relying
work.
on a forensic tool for a result or an opinion?
There is absolutely a danger in just relying on parsed results. When an algorithm is used to determine what data
I
is.
don't remember her talking about Internet of Things last time, but I appreciate that is part. I just remember her doing mobile phones, but yes, all of the connected terms. I was just like, okay, I had forgotten she did that, but it is, well, a growing area because everything is connected, isn't it? We'll see that more in the Koberger case, I'm sure.
Stored as, it doesn't tell you what that data
She explains
means,
things well,
and that's where you need
to
a
the
forensics
jury.
examiner.
Is what
Tools
I remember
don't
from
necessarily
last time.
understand
But
how the data got there and what causes the data to exist. And that takes deeper and further.
She and
human
Alessi are going to be
analysis,
all New York
as well
accents
as,
all the time.
You know, if you think about it, if on your phone you can go to the Google Play Store
Ma'am, the Quazzas
or the
gave you
App
away.
Store, and you can actually download millions of apps. There's like 6 million apps between the two stores.
That was the rudest pause. Okay. You can. There are like 6 million apps on the App Store, and I just feel like Jessica Hyde gave us the greatest opportunity to remind you that the Lawnerd app is one of them at lawnerd.com. to keep you in the loop on everything going on in this trial. And when the witnesses you want to see most take the stand. Thank you, Jessica, for that opportunity. Let's get back to our regularly scheduled trial.
Digital forensics tools maybe support generously 1,000 applications. So in order to be able to parse and understand the data from applications that the tools don't know how to support, you need a forensics examiner who knows how to dig into that data, conduct testing, and determine the meaning of the data.
Brennan, I need your help. Can you just ask her about coffee so we can determine all of the New York vibes?
Were
I just
you
need to know.
asked
I just need
by
to know.
the Norfolk County District Attorney's Office to look at and analyze a phone that was related to a person by the name of Jennifer McCabe?
Yes, with a very, very specific scope to a specific date range.
Were you asked during that scope and date range to analyze it and provide an opinion about whether there were any user-initiated deletions of any web searches or Safari-type searches?
Yes, I was asked to look for deletions of Safari searches within the scope of the time frame that was dictated by the purpose of the exam.
Were you asked to look at the phone device and determine whether or not there were any user-initiated deletions of phone calls on the device?
Yes, I was asked to look for deletions of phone calls in that same date range.
And did you do both of those tasks?
Yes, that's correct.
Did you ultimately have opinions on both of those issues?
I do have opinions on both of those issues. That's correct.
And in
Wait.
engaging in the efforts to answer those two questions, did you necessarily have to review and analyze a web history that included searches on January 29th, 2022 at 2:27 a.m.?
I did analyze web searches that occurred at 2:29 a.m. on local time here in Norfolk on January 29th, 2022 from the device that was provided, yes. Not the device, forensic image, for clarity.
So before we get to the two opinions that you were asked to consider or what your opinions were after analyzing the data, I want to begin by giving the background and having you share with us your analysis and your
It
observations.
seems like she's having
and
a hard time
opinions
hearing
about
him a little
the
bit.
search on Safari relative to this 2:27 time.
This question's also really long.
Before we begin that, let me just ask you one question. Did you do anything to ensure the integrity of the data?
She was tracking everything you said, and then you're like, but before we get to that, because it was the longest question ever, but before we get to that, let me ask you this. And it's like, what?
That you were looking at?
Upon receiving the forensic image, the first thing I did was I did what's called a hash of the image. So a hash is an algorithmic representation of a file. So a forensic image, all the data from the phone, it comes in one file that can then be extracted and have the rest of the data. That singular file that's received, there's actually three, but focusing on the one that has all of the data, that archive file, you can run what's called a hash algorithm against it. There's actually multiple hash algorithms. And I hashed it, and then I validated that hash to the document that was provided along with the image file that contained the hashes that were contained in. Those hash values matched. Now, just for clarity, if you change one bit in a file, it will not have the same hash. So the hash provides integrity, and having used both hashes, which are available in that report, and ran two different algorithms, they both matched. Additionally, I reviewed the PDF that was received for signs of alteration. The PDF that comes with a Great Key report is not signed by Adobe Acrobat. However, I was able to take that PDF and then examine it just like I would a phone. So I'm using the same techniques on the phone. Using a tool called EXIF tool, I was able to learn a lot about the creation of that particular PDF. And what I was able to learn about it was that it was created by, it's labeled it as being produced by Grayshift using a particular code-based application to create the PDF called PYF PDF.
Not PYT?
Standing for Python Framework PDF. It is on...
We almost had an anaconda, but no, a python instead, because we were so close.
It's a
We were so
program that you
close.
can download, and developers who create tools, like Magnet Forensics, who owns a Gray Key, utilize that script, which is why it says it's produced by it, to create the actual PDF. That's what the evidence there in the data tells me. It also contains a time of when that is created, and that time was February 2nd, 2022, at global UTC, that's the global constant time, think what's in the UK, at 22:49, which
UK 's like we would
local
like to be
time would be
excluded.
5:49 p.m. So that says that it was created approximately 2 hours and 45 minutes after the document said the image started, and it correlated with the document information. So that provided some level of certainty that that document was factual, and on top of that, I further opened the file of that PDF in what's called a hex editor, which lets me see like every byte, every 1 and 0. And from doing that, I looked for tag markers that are made sometimes in
We've
some
gone well
modifications
beyond
of
what the
PDFs
jury even wants to know about the
called
PDF.
XMPs, which is
We're just
Adobe's
well
format
beyond.
of markup, and I did not find any evidence of those tags.
When you're trying to determine whether there's integrity in the data, are you able to tell whether or not there's been any alterations or tampering before the item is put on the Gray Key machine to make the extraction?
That would be when you're talking about if the physical device had been manipulated, is that
Yes.
correct?
Yes.
I cannot tell if the physical device has been manipulated prior to it being imaged. I can only validate if the image was correct. In theory, all of the data of anything that you did on that device would still show in the evidence of device logs and whatever locations that were touched or communicated with. But at that point, it's the same as any user interacting with the device itself.
After the phone's extracted, or at the time it's extracted, does it have the history of the device on that extraction?
Could you rephrase?
Yes. At the time
like,
the
"That
phone
question's
is
not
extracted
accurate."
And the copy is made in the PDF and the digital copy, does the digital copy and the PDF contain the history of searches and calls and other items on that phone?
The
Better
forensic
question.
image itself contains a variety of different artifacts or traces that are left behind by activities that a user does on a phone. Yes.
You use the term artifact. What does that mean in a basic sense?
An artifact is any type of evidence that is left behind on your phone of an action. So, for example, if you receive a call, there are multiple places in the phone that show that a call was received. That can be in the call log, that could be in a notification, that could be in a unified log that tracks the activity that the phone's doing. There's multiple locations, and each one of those residue of the fact that the call came in, that's what I would refer to as an artifact. So you could have an artifact not just about a call, about a web search, about taking a photo. Any action you take on your phone may create an artifact.
Before we get into those two questions about any alleged deletions from Safari, a Google search or an internet search, and any alleged deletions of phone calls, I want to start with your explanation or your sharing how the timestamp works relative to that search beginning at 2:27 a.m. on January 29th, 2022.
So for clarity, there's more than one search that happens actually at 2:27. There is some activity that's looking at, and I don't want to mispronounce the name of the town. I'll try Hockomock Sports, looking at activities for the sporting events at that school system, I assume, or county location. There is a timestamp for the search Haas Long to Die in Cold. However, that timestamp isn't about active searches. It's about the time that a tab was either opened or moved to the background. So Haas Long to Die in Cold is the most current search in the tab that you opened at that was opened at 227. So if you're using your phone and you go to your browser, you have some choices. You can just open an existing tab, or you can open a new tab. A new tab was opened at 2:27 a.m. and that search was done there. Another
easy to
tab,
understand.
actually at 2:27, was moved
Which I
to the
appreciate.
background, and its last search at the time it was moved to the background was for, I believe it's Raining Men, the YouTube video.
She's
So
like,
those two
IDK.
searches both exist as what's called browser state searches, but that's browser state isn't about the time that it was searched. It's about the time that the browser tab that you opened either went to the background, or if it's never been moved to the background, the current search. So the time in the instance of the It's Raining Men video is
I
the
appreciate
time
that.
that
It's
that
Raining Men.
video was moved to the background and the new tab took over as the tab that's active. And that tab, the last search done in that tab is How's Long to Die in the Cold, because that database holds the current search. It constantly gets updated, and the time that the tab was either opened, if it's the first time it's opened, or moved to the background if it's an existing tab.
Did you put together an exhibit that would help explain some of
I
the different
did.
databases?
I did put it together
She's
in an
like, I
exhibit that would show
did.
that.
She's like, I've illustrated it one way, and now I'm going to illustrate it another way. I find that she's easy to understand when she explains as an expert. We are going to see the defense tech expert as well talk about this. We are going to talk about this a lot.
I do. This is table 1 from
Not as
the
much as we
first
did last
report
trial so
I created
far,
on this case on
which I appreciate.
the phone that I was told was for Jen McCain.
Is that the exhibit that will help you explain
It will.
and move this to evidence?
Here's why I would be a terrible digital forensic examiner. I would never get stuff done. I'd be like, what are you Googling? Why are you Googling that? What does that mean? What is a hockamock sport? I'm too nosy. However, if you are inherently nosy, digital forensics might be for you. It's why I liked white collar crime so much. Digging through people's bank records, you're going to know all the things. You get the bank records, the emails, phone searches. You're going to know everything you need to know. It's fascinating stuff. But again, tangents. You don't need tangents. So let's zoom past this. There's a new view of the fan. I feel like the fan is not getting proper care with that crack in the ceiling. I have concerns for our only fan in that ceiling. Let's zoom past this extended sidebar. Why? I wonder if Alessi's asking again now that they're talking about 227. Are we back? Are we not back? What are we? I was like, are we back? Oh, beautiful messy ball said you could never be a bank teller. Oh no, I'd want to know people's whole life.
Before we look at any...
But I was also like that when I worked at like sporting goods stores. It's like, oh my God, you're going camping. Where? No way. Where's your favorite place to go? What kind of car do you car camp? Do you not car camp? Do you have a favorite campsite? Like, what's the best time of year to go there? Do you love it? Oh my God, you're going skiing. Tell me everything. Tell me all the things.
chalk, I want you to explain the entire basis for that chalk and your ultimate opinions that are reflected in the chalk. So let's start from the beginning.
May I look at my copy of the chart? Or
The backup was to lay the foundation for they call it chalk, which is the demonstrative or the demonstration exhibit. And she said, can I look at my chart before we do that?
Why don't I just ask you to...
See if you can answer the questions.
I appreciate that she ignored Hank and went, Your Honor, may I just...
yes, Your Honor.
I love it. Your Honor.
When you looked at the phone to analyze it, were you trying to determine when a particular search was made, specifically the search, How Long to Die in Cold?
Correct. I was looking for two searches, both How Long to Die in CIKD and How Long to Die in Cold.
So as a forensic examiner, how do you begin the process to try to identify and determine when that search is actually made?
So the first thing we would want to identify is what application was being used at the time to make the search. So looking at that date time stamped, it was able to on that date be able to determine that Safari was the application that was being used as the Google browser. And then you would begin looking at the artifacts for Safari, both those that are parsed by the forensics tools, but then further looking into the data structures that hold that data itself, and then ultimately conducting testing to determine why a certain artifact exists.
So you mentioned the beginning step is the forensics tool or tools. Did you use forensic tools to get information or parse any data regarding this potential search of 227?
Yes, I use multiple forensics tools.
Can you share with us the multiple forensic tools that you used?
Absolutely. I used Celebrate Physical Analyzer. I used Magnet Axiom. I used just the tools I used at first. I used iLeap. There are further tools I used later, but those were the three that I started with.
What tools did you use later?
Later, I used specifically, I've used Sanderson's Forensics Toolkit, the forensics browser in Sanderson's Forensics Toolkit, which helps exploit SQLite databases. And then I further reviewed in a tool called Rabbit Hole.
To begin with, Celebrate, is that a...
Was the tool called Rabbit Hole just made for people with ADHD who want to learn an entirely new skill at 3 o'clock in the morning? I have so many questions. I'm also being only moderately sarcastic, but I've seen a lot of questions in the chat. Isn't she just bringing up exactly what the other expert did? Yes and no. The no is that she is here to testify specifically about whether these were user deleted, because the search is one thing, but if you deleted the search, it's like, that seems shady. Why are you deleting it? She is here specifically to talk about the deletion more than to talk about the search time and the tabs being in the front versus the tabs being in the back. So deletion of the search, and they said phone calls, is what they're going to ask her primarily about. So then we'll get there. So that's why it's not rebuttal, because it's about a separate topic.
A tool that you're familiar with?
Yes.
Is it a commonly used tool in the industry?
Yes, commonly used mobile forensics tool.
Is it reputable?
Highly reputable.
Why did you use Celebrate?
I use Celebrate because on any mobile exam, I'm going to validate what is captured by Celebrate and Magnet Axiom because they have the most robust parsing of what is in my tool arsenal. And then I would also follow up with iLeap closely behind, because iLeap has a lot of artifacts that aren't supported by either of those tools. Using a variety of tools is going to give you different coverage, and each tool has a different perspective on how they view and display data.
I like the way she explains that.
Magnet Axiom?
That is correct.
Is that a leading forensic tool as well?
Yes, that is also a leading forensics tool.
Are you familiar with that company?
I'm very familiar with Magnet Forensics. I was actually their director of forensics for 5 years, then continued to consult for them for an additional 2 years under my company Hexordia, and my company continues to be a reseller of Magnet's products.
You mentioned
She's
different
like, well,
tools
actually,
may
yes,
present
I'm well familiar.
information a different way. Do those tools change the underlying data at all?
That's a great question. So when we're talking about the results that a tool shows, the tools maintain the integrity of that original forensic image, and that's actually something we verify as we continue through our exams to make sure that the underlying data hasn't been changed. There are some tools, I did use some other tools, I apologize. I also used ArtX and Mushy. But I'm sorry.
Is Mushy part of the rabbit hole? I'm loving the tech terms.
ArtX is capital A, lowercase rt, capital E, lowercase x, and then Mushy is M-U-S-H-Y.
I'm just delighted.
Yep,
I'm
you're
just
welcome.
delighted. One of my favorite things about practicing in trial work was getting to learn all kinds. It's the perfect thing for ADHD, right? You get to learn all kinds of new things through your expert, and you're like, tell me everything about your area of expertise. I want to know it all. So I just am delighted by the experts and all of the things that they do in their workday. I'm fascinated. I'm fascinated. I'm delighted. enjoy the experts very much unless they are.
I'm sorry, can you repeat the question?
Dr. Spiegel.
I was the spelling.
She's like, where were we again? Delighted. It's rare that I'm put off by an expert. I'm here for all the nerdiness.
Artex and mushy. But the, I'm sorry, ArtX is capital A, lowercase rt, capital E, lowercase x, and then mushy is mushy. You're welcome. I'm sorry, can you repeat the question? I got this, the spelling threw me off.
I mentioned, or I asked you about using multiple tools and whether or not
Bring that back up later, Mindy Mouser.
the use of different tools changes the actual underlying data.
So the actual underlying data is always maintained, and we do validate that. Some tools allow you to see parsed results and then allow you to dig deeper into looking at the actual files and data structures. Those would be tools like Cellebrite, Physical Analyzer, and Magnet Axiom. Some tools show you the parsed results and tell you where they got them, like iLeap. It shows you the parsed results and tells you the file location, and then you would open that up in an external tool. And then some of the tools I used are not tools that parse the results, but are tools that allow me to manually look at the data structures. So they directly allow me to look at the data structures. And all of the tools I use in this instance are tools that do not change the underlying data.
Is it important or critical to go beyond the tools, presentations, and actually analyze the data yourself?
It is absolutely critical. Actually, in the NIST Scientific Foundation's paper from the National Institute of Science and Technology that states the foundations of digital forensic science, it states that it is the examiner's duty to not only verify and validate tool results, but also to provide meaning to forensics parsed results.
Does software update regularly?
The software updates all the time. Typically, we get an update about once a month, and to be
all the time. Let me. I'm just living. I'm living. Burning Sensation asks, will she show the outputs? The screen name is giving, but I think we will see some of that in her PowerPoint.
To be honest, it's not enough to keep up with how many new apps are developed and how many new phones come out and how many of your applications get updates, new features, for example, maybe in Instagram or Facebook. So the tools update very, very regularly.
When you use the Cellebrite tool to analyze the 227 search, did the search How Long to Die in the Cold have a timestamp on it?
There are actually multiple artifacts for How Long to Die in Cold. Remember earlier we defined an artifact and we spoke about it was one of the types of traces. So there are multiple traces.
I love that she's speaking in like lesson structure. Remember earlier we defined what an article was and now we're calling back to that definition. It at least the jury, even if they feel like it's a bit over their head, will enjoy listening to the way she is trying to help them understand. Some experts, unfortunately, especially incredibly intelligent experts like this expert, can talk over the jury's knowledge level, even without meaning to and without intending to, just because their basis of knowledge is so high. And she does a really good job of having a high level basis of knowledge, but explaining it so that the jury can understand without being demeaning or belittling. And some experts can feel like when they're trying to explain to you, they're talking down to you, and she doesn't. And so I think that the teacher mode helps because there are experts that just know too much and cannot explain what they know well. That's why there's a middle person, because the engineers don't talk to the customers. So she is, I think, very good at explaining without, I don't know, demeaning is not the right word, but being kind of condescending and, difficult to listen to. So I appreciate that.
For that How Long to Die in Cold, only one of them is associated with the 227 timestamp, but there are other instances of evidence of that was parsed by Cellebrite.
Is there any danger for an untrained eye to rely simply on the software?
It's a good question.
When looking at a search like this, how long to die in the cold, and seeing the 227 timestamp?
Absolutely. There's a really scary danger that an examiner who has not dug into the artifact and tested to see what it means may assume erroneously that that 227 timestamp is the time that what is there is searched. The search in that field of that artifact is going to always be the most recent search in the tab, but that timestamp actually means either the time that that tab was backgrounded, or if it's the first time the tab's been opened, when it was opened. So you could erroneously implicate a search was done hours or some time period or even days before it actually occurred. Some of us leave our tabs open forever.
And you're teaching.
Ma'am, are you creeping on the chat? Some of us leave our tabs open forever. Hold on. We should do a tab check because we did it the other day. Let me go ahead and check the Safari tabs. I feel like we're there. She's like, some of us just, I think we're still at the same amount, which is pretty impressive because I've been doing lots of noodly Googling, but I'm still at 169 tabs. We're still at 169. We're still at 169 tabs. I think we were at 169 tabs before, but some of us leave our tabs open forever. I don't on my desktop. I do on my phone. I close my applications. I don't close the tabs. It just is what it is. Again, I think the jury will be delighted by her. She's like, sometimes it happens. The thing that I still do not understand well is if we are looking at the time that the tab is in the foreground or in the background or opened or whatever, why can't they find the time that a Google search was done? Does that information not exist somewhere? Where can we find just when Googling was happening? And why is the time of the tab the only thing we have? And where do you go to find the information of when the search was done? And did they just not get that information? That might be it, is that the information lives with Google and they just did not request it. But like, where is that information then? Just where does that live? Because I have to imagine that somewhere you can find at what time someone was searching things. And I think we'll see it in the Corey Richards case about when she was searching it. But I'm curious.
Examiners and students, do you teach about this specific concern and concept?
I like the light moments about
I teach
the
about
tabs.
this concern both in my mobile forensic analysis class, my mobile forensics course that I teach at George Mason University in their digital forensics master's program, and in the data structures course where we specifically learn how to analyze these databases in question.
In your experience, how common does an untrained examiner make this mistake?
I wouldn't be able to speak to how common an untrained examiner does it, but regularly my students get those questions wrong on earlier examples I give them in class to kind of indicate to them that they could easily make mistakes without understanding meaning, and I use it as a teaching aid. So teaching, 90, 100 easy students a year, I regularly see that in untrained examiners that I'm teaching in my class, but I wouldn't be able to say that across the discipline.
You mentioned that Celebrite showed the search on the report.
Beck said, Emily, she called you out. I think she said same.
Is it
she said
2740?
Yes, that's correct.
Do you know whether or not Celebrite has updated its software?
In May, Celebrate of last year, Celebrate made an update to their software actually to remove this artifact because of its ambiguity and the risk that an examiner may overstate or misstate what it is.
Is this ambiguity reflected in other types of software?
I think that's the wrong
Could you
question.
rephrase, please?
Sure.
That's a
For
bad
example,
question.
when you did a report in Axiom, did it have
Does this
similar
artifact show up elsewhere?
reflection in the report?
Objection, Your Honor.
Ask it differently.
Yeah, does this artifact
Did you
show up in
run
other
a
reports?
report regarding this time frame through Axiom software?
I did process the image through Axiom, yes.
When you did that, was it the same or a different result?
Axiom and Celebrate really show their data very, very differently. So Celebrate takes a perspective of alerting people to possible deletions by annotating either a question mark or a red X next to artifacts that come from different areas. Magnet instead marks if the artifact was parsed or carved. I feel like now I need to explain to you parsed or carved.
Yep.
So parsed means that the data was where it was expected to be found, and the algorithm was able to cleanly see that this is there. Carve means that it had to run that algorithm.
I didn't realize we were having a competition in the chat for how many tabs are open, but I think 1341 might be the winner if that is the amount of tabs somebody has open, because I've definitely seen in the 200s in the chat. But I think, Judith, I think with 1341, winner, winner, chicken dinner in the chat, I don't know if anyone is going to have more than that. So A, congratulations, and B, now you will remember everything. I'm here for it. Chat, we listen and we don't judge. Because look, that is a whole like history of all the things that need to be kept in the foreground of one's mind. We listen and we don't judge. But winner, winner, chicken dinner, I love it.
Against the data structure as a whole, and found it as a partial result. So it carved it out and went and found it instead of it just sitting there exactly where it was expected to be, and shows you both the results.
Hilarious.
So it'll show all of the results of, in this instance, the sessions, tab sessions, but the data browser DB, the tab state, it's going to, instead of telling you this has a red X, it'll instead say it was carved. So it's a different presentation of the same data.
So I want to talk about deletions in a little bit, but I want to get back to the 227 search.
Sure.
So when you produced or you looked at the report for Celebrate and it showed
The
this
long and
time
short answer was between the two different softwares, there are different presentations of the same data.
stamp, as well as the
We were
phrase,
talking
how's
about
long time,
tabs.
Nicole. Where did you look? How did you make an analysis to determine whether or not that search was actually made at 227
Ben,
or
you're
another
close.
time? What was your next steps for us?
So in looking at that timestamp, the first thing I did was actually go and look at
need
what
to feed my
literature
Snorlax.
exists on the artifact, if anybody had reviewed this artifact before. I also created my own data set and tested how we could get what that timestamp means. So if I make a search in a tab and then I make another search in the tab, which timestamp is it? If I make a search in a tab and then open a different tab, what changes? I also looked at the documentation in the artifact reference guide for Axiom, which does state, it describes that timestamp as the time in which the tab is backgrounded, and it gives a stipulation that in certain circumstances, the timestamp can be earlier than the search.
Did you specifically look in any databases or for artifacts in the data to help make an analysis of when this search happened?
Of when the search happened as a whole, absolutely. So there are multiple databases that I looked at that show search information for Safari. So I looked at the plist, mobile Safari plist. I looked at the browser state database. I looked for the history database. I also looked at the Knowledge CDB. The Knowledge CDB is a little bit different. That isn't a database for Safari. It's a database for all of Apple, so it can predict your behavior. So takes in information that Apple wants to take in, including browser history. And it saves that information so it can make predictive information. I also looked at the caches in the Safari, which is the things that Safari is trying to make quick reference to. This would include suggested terms for commonly searched items.
When a URL or a search through Safari is typed in, or if it connects, does it leave a trace in different parts of?
Is he ever going to get back to her?
Yeah, so when you actually do any...
I wonder if Brennan is going to question her until the lunch break and then come back to the PowerPoint after lunch.
Search, you're going to leave traces. Now, it does depend if you are in private browsing or non-private browsing. So non-private browsing is what most of us use regularly. Private browsing might be what you elect to use. Well, some people would elect to use it if they're doing searches they wouldn't want their spouse to see, like maybe they're looking at porn, or maybe you're doing something secure like looking at your banking information.
Ma'am! She's just like, we're just going to go there. Do not call out my second Audible account and where we are searching for book. Ma'am. She's just like, whoop, there it is. You might use private browsing if you're... I mean, fair enough. If you don't, you might use private browsing for this, for that. And the jury must have just been like, wow, okay, cool. I mean, again, sure. Also, no judgment, but let's continue.
You may intentionally use a private browser. For Google users, this would be the equivalent of incognito.
I like that she was like, it's like incognito mode. You might, porn or banking information. I'm surprised we didn't go to OnlyFans. In this trial, nothing would have been more appropriate than if she had said OnlyFans. Nothing would have been more appropriate. Nothing would have been more appropriate. Nothing at all. Nothing would have been better. Does Emily have some 50 Shades law books? They're not law related, but better than 50 Shades. We'll
to see, like maybe
we'll talk spicy
porn,
books another
or
time.
Or maybe you're doing something secure like looking at your banking information. You may intentionally use a private browser. For Google users, this would be the equivalent of incognito in Google Chrome.
Nobody needs to be in private mode when you have a second Audible account.
And so the artifacts for that are more limited than the artifacts for non-private searches. So some of these artifacts only exist for non-private searches, and
yes,
some
chat,
exist for private searches.
Browsing
in this
isn't
case, this
truly
phone,
private.
Was it on non-private or private?
So specifically the two searches we're talking about, how's long to die in cold and how long to die in CIKLD, excuse my differentiation there. Both of those searches were done in non-private browsing.
So they weren't hidden?
They were, I don't understand the question yet.
Okay. Was there any applications?
She's like, I appreciate that this expert is very kind in the way she indicates to counsel. That's not a good question. Like, that's not a good question. That's not an accurate and specific enough question for me to answer. So these weren't hidden. She's like, that's not what that means.
I don't understand the question yet.
Okay. Was there any...
I think she just joined in Alessi's objection. I think her face just joined in Alessi's objection. She's like, not a good question.
Applications
I think
to
so.
mask those searches?
Not to the best of my knowledge. I did not see any.
We began
I'm here
with
for
the
all of it.
22740 timestamp. The next recording on that tab, do you recall what time that was?
I believe the next, and I'm trying to remember the chart from memory, if that's correct. So I believe the next thing we're looking at is the 623 suggestion from Apple search terms for how long to digest food. Am I matching what you're seeing on your chart?
Well, let me ask
Am I
you.
matching?
Okay.
Are we
when
there?
you saw that, do you look on the
I think the 6:23 suggested search at 6:23 a.m. is helpful to the Commonwealth's view of how this search happened. I just don't know if the jury is going to understand it. And I don't know how lost in all this they will get, or if they will even care by the time we get to some of the medical testimony. But I think the 6:23 suggested search helps because it indicates that somebody was trying to search how at that time. and then it filled in the search. So how to digest food was not a search that was made. The artifacts were starting to populate that search because they were anticipating what you might search with most common search terms. So somebody was typing in, or this is what they're extrapolating, somebody was typing in how at 6:23, and that's why those suggested search terms were starting to populate.
Same tab or a database? Where do you find that information?
Fair. Understood. So all
Kaylee,
of
app
those
is completely
databases
free.
I was just mentioning before, we're looking at all the parsed results from all of those, and I was looking in the entirety of the scope from the time of midnight till noon. That was the time frame of my scope of all of the content that was done in the tabs for BrowserScape DB, Cloud Tabs artifacts, History DB, Mobile Safari plist, Knowledge C, each one of those, and then I was combining them to timeline out the activity.
At 6:23:51, did you look into how long TIDIE in CIKD?
So that would be the next thing that we see after the Apple suggested term of how long to digest food. That's the next thing we see an entry of that. There's two immediately next to each other. I don't remember the precision on the seconds of which one's first off the top of my head, but one is in Knowledge C and one is in the Mobile Safari plist.
Can they appear in different rooms in the data bank, in different places, the same search?
Searches appear in many different places. They can leave traces,
Fred, really?
such as that Knowledge CDB. I love that Apple calls that knowledge. It's like what it's trying to learn. So the Knowledge CDB, what Apple's trying to learn about you, as well as in that Mobile Safari plist, as well as at the moment of that search, which I don't have the device in that moment, but just so there's an understanding, that open tab, the URL would have been updated, or URL is the website, would have been updated to that search at that moment. Had we imaged it at that moment, it would have been how long to die in CIKD.
So what she is saying is the predictive search that came up, how long to digest food, came up, and then you see the how to whatever the rest of that one is with cold misspelled, and then the how's long after that. That's my understanding of what she is saying. So it'll be interesting to me if on her PowerPoint it breaks that down by time, because it's very different if the how's long search happens and then the how to digest food and then the other one. I think the order of when those things populate in the artifacts matters quite a lot.
Finally, at 6:24:47, did you identify any artifacts with that search that appears with the timestamp of 2:27:40? Did you find the same?
Correct. At 6:24, we have two timestamps in the same two locations for how's long to die in cold, the Knowledge C and the Mobile Safari plist.
So based on your analysis in that issue,
what is your opinion?
Did you come to an opinion whether or not the phrase how's long to die in cold was actually searched at 2:27 a.m. on January 29, 2022?
There are no artifacts.
So the answer is yes or no.
Can you repeat the question?
Did you come to an opinion?
And so based on your analysis of the phone and the data using all of those softwares, did you come to an opinion whether or not the phrase how's long to die in cold was searched at that timestamp tab of 2:27:40?
Yes, I came to an opinion.
And what is your opinion?
Rephrase the question as to the opinion.
What?
I'm sorry?
Yeah, I'm sorry.
I see you at side also, Mr. Ledger.
What? I'm also surprised because normally you ask, did you form an opinion? What is that opinion and what is it based on? I'm as confused. But okay. They're going to sidebar. And for all of you in the chat that said, I hear your analysis instead of your analysis. Yes, every single time. I do too. It's not just you. All right, let's zoom as they go to sidebar. And I could have held some of my Tamara, that's my opinion screams, but I did not. So we're going to just, all I want to do is zoom. All I want to do is zoom. I am not sure what the objection was because we don't have them. And because the court does not have them make their objections with a basis. So I'm not sure what the issue was because it seemed like your normal course of, did you form an opinion? What is your opinion? So I guess we'll see. What the question is.
You've explained to us the analysis you
Foundation?
engaged in and the process you engaged in.
Maybe foundation.
In forensic data analysis, is there a methodology that you use, not just looking at the
Foundation. It goes directly to foundation. And Sarah Berry said it in the chat. If she hasn't stated an approved methodology, then any opinion can't be stated to a degree of scientific certainty. And he is going right back to the foundation to ask her about her methodology.
printout of the programs, a methodology you use that is accepted
Which is a
in the
very good catch,
industry
Sarah.
for experts to analyze this data and come to your opinion.
Absolutely. Beyond looking at what was in the tool results, I further looked at those databases independently and conducted testing of the artifacts.
And in addition to what you did, can you share with us how and why this methodology is accepted in your practice as forensic analyst?
This methodology is accepted by NIST and by organizations like the Scientific Working Group of Digital Evidence. I'm intimately familiar as both a member of the Scientific Working Group on Digital Evidence who helps work towards the building and development of these consensus-based documents of procedures to be followed in digital forensics analysis, and as a member of the National Institute of Science and Technology, NIST, Organizational Scientific Area Committees, OSAC, Digital Evidence Subcommittee, where we also produce guidelines such as the data set guidelines for generation of the guidelines for data set generation, which is how you do your actual testing and creation of data sets. And I was also a part of the subcommittee that drafted that. So I'm intimately familiar with the accepted policies and procedures because I am also a member of the groups that help author these, as well as review them and look and
write the
use
methodology.
them.
The thing that's confusing to me about this court at times is that the ordering is different and they don't have to offer the expert and have the expert accepted by the court. They do not do that on the record. I do not know why. You saw that a lot in Depp v. Heard when it was background training, experience, methodology, and you go through how and you say, I am offering individual as an expert in the area, and then the court asks if there's any objection, and then you go from there and accept the expert. They do it. They do not do that formalized asking to have the expert designated as an expert. And so the ordering gets out of order, and it makes it easy to not back up and say, okay, this is your training, this is your background, this is your experience, this is your methodology, this is your area of expertise, and then go all the way through that. So it gets very out of order. And Alessi's like, not enough methodology for me.
Articles.
And now we're backing up to
and
that.
guidance in the industry about this particular practice of analysis.
Because they did do this a bit earlier, but not in this way.
Analysis, just for clarification, you're talking about for analysis of Safari artifacts, of mobile forensics, of browser state DB, just for clarity on the question.
Let's work our way through it. How
Sure.
about through Safari?
For Safari, there are multiple different blogs that talk about Safari, as well as I have analysis of Safari through classes I took, such as SANS 4508, which is 518, SANS 4518, which is the Mac and iOS analysis course, which I took.
How about the specific guidance regarding searching the different databases for artifacts?
In terms of methodology for digging into databases,
Yes.
is that correct? There are
she absolutely said
multiple.
blogs.
I've taken courses throughout my master's program, courses on how to analyze digital forensics artifacts, including mobile device forensics. Throughout my GIAC certifications, I've taken multiple instructor-led courses on how to do these, as well specifically that cover mobile Safari history in mobile forensics at GMU in his master's program as part of the SANS 4518 class. And in terms of data structures, I've taken study on how to analyze databases like SQLite and PLIS are covered in those courses.
There are books on study on this methodology?
Books on study?
There are multiple books on digital forensics, many of which I've read, and including books specifically on analysis of SQLite databases, such as Sanderson's SQLite Forensics, which is probably the most authoritative, because not only was it written by Sanderson, who
Jessica,
makes a
I
tool,
appreciate
it was tech edited by 3
your
renowned forensics
expertise,
examiners,
but also
as
I
well
haven't
as
finished
Dr.
breakfast.
Richard Hipp, who created SQLite itself.
Dr.
The
Richard Hipp,
methodology,
who created
the technique
SQLite.
you use to look past the reports and actually look at the data to make your determination and arrive at your opinions. Is that methodology regularly accepted within the forensic data community?
Absolutely. Again,
There's the
using the
last
methodology from the consensus-based documents from the community, from the Scientific Working Group Digital Evidence on best practices for analysis, as well as specifically for the SQLite databases I was looking at. I do that deeply verifying and in accordance with the understandings
this part,
from
the jury's just
Sanderson's
like,
book.
What?
Now you share with
They're
us that
moving
you
it
had an
quickly.
opinion regarding the
And yes, when I did expert testimony, I always had a checklist at the top of every single page to make sure that we went through all of the steps. But again, those steps had to be gone through before they could be moved in as an expert. So it was pretty easy to go through that checklist at the beginning instead of getting it all convoluted. But you need a little checklist to be like, I need this step, this step, this step, that step. That's how lawyers remember it. Hank was able to back up. Lally was much more of checklist. But again, Hank has been an attorney for a long time. So it doesn't surprise me that he's like, okay, fine. We'll back up and do it again.
timestamp and whether that it was applicable to the search term, how's long to die in cold?
That is correct.
Now I want to ask you to a reasonable degree,
There's the
forensic
question.
data, scientific certainty, what is your opinion about whether the phrase how's long to die in cold was made at the time of the timestamp 227?
Wonderful. Alessi's already standing up. Correct. Alessi's already standing up.
On this issue, okay?
Whoop! The court said that's the last one, Mr. Alessi, on this issue. All right, let's zoom past this sidebar. Alessi is not going to be put off by the court saying that's the last one. He is tenacious, and he is going to continue to be tenacious. It is what his job is, to be a zealous advocate. But that's where we got to the your opinion to a degree of scientific certainty or scientific degree of certainty. It's not just an opinion for fun.
All right, go right ahead, Mr. Brennan.
I'm now going to ask you for your first opinion. So
Okay.
you shared that you have an opinion about whether that timestamp
You left out the
22740
scientific degree of
was,
certainty.
whether or not that was the time the search how's long to die in the cold occurred. Can you tell us to a reasonable degree of
Oh, there we go.
scientific certainty your opinion about whether that search, how's long to die in the cold, occurred at 2:27:40 a.m. on January 29th, 2022?
Same objection, Your Honor.
Okay.
Noted for the record.
What I can state to a scientific degree of certainty is that that search occurred at 6:24 a.m. and was the last search in the tab that had been opened at 2:27.
Do you have an opinion to a degree of scientific certainty whether there was any other searches similar to how's long to die in the cold that evening on that tab?
Your Honor.
I'm going to allow it.
It's an odd question.
May I first inquire, you meant morning, I
I'm sorry,
assume?
that morning, yes.
Just clarifying, I did not look at evening searches. And can you repeat? I apologize. I disrupted my own train of
You
thought.
have an opinion to a reasonable degree of scientific.
Yep. She buffered because of the way he asked the question, which is completely reasonable.
Just clarifying, I did not look at evening searches. And can you repeat? I apologize.
She's like 404.
I disrupted my own train of
You have
thought.
an opinion to a reasonable degree of scientific certainty whether there were any other searches on that tab before the final search at 6:24:47, house long to die in cold.
Overruled.
Just ensuring that I have the question correct.
Please.
You're asking if what else occurred in that tab prior?
Yes.
That I cannot say with a clear degree of certainty.
Okay. Did you develop a chalk that I showed
did.
you earlier?
I appreciate her for being like, that is not a clear question, and I cannot tell you with certainty everything else that occurred in that tab.
Yes.
Again, I show you. Same document. You recognize it?
Yes.
What is it?
It is the
I tend to believe that
exhibit
this
that
is
I
a
created that was
Brennan
labeled Table 1 in the
questioning
first
issue
report
and
I
not a
delivered.
witness issue.
Provide information that will assist us in understanding your opinion.
Yes.
I've moved subject to redaction.
You have to ask
Your Honor, I
precise.
have no issue with regard to the redaction aspect, but consistent with my prior objections, I would object to that.
You have to ask
I'm
precise
going to allow this
questions
into evidence. You're right
of
to say this.
Thank you, Your Honor.
the experts.
Exhibit 82.
Madam Clerk, 82.
Exhibit 82.
Thank you. With the court's permission, I'd like to show Exhibit 82 to the jury.
Okay?
Which is why, oftentimes in a trial, you will see that there will be specific attorneys that just deal with the experts. Emily, it sounds like you spent a lot of time being second chair talking about the tech stuff because everybody else was like, you like phones. Yeah, I like, yes. We'll tell those stories later. But yes, I was often the person that was like, you can do the tech stuff. So I ended up doing a lot of expert witness stuff because they're like, you like this stuff. Sure. I'm nosy. All right, let's get to her reports that they have put in or marked for evidence subject to redaction.
Could we enlarge the first two?
And again, this will be a battle of the experts,
We're
but
gonna
I
need to get
think
the right
that the
column
jury
in if
will
we can,
understand
please.
what she's saying. The defense experts going to dispute
Chad,
it,
can you
but
see it from there?
I can.
we'll see.
Thank you.
If you can walk us through how this exhibit assists us in understanding your explanation and the basis for your opinion.
Exhibit A.
This exhibit shows the Safari artifacts and artifacts of Google searches in Safari related to the two searches in question, How Long to Die in CILKD and How's Long to Die in Cold, that occurred on the morning of November 29th, 2022 on the device under examination.
If I look at this chart and I see in the top left it says 2:27:40 a.m.
I'm going to
and
move
then
me
under the
out
search
of the
term it
way.
says How's Long to Die in Cold.
My
How do
question is, when the Google search and application, I want to see the tab. I want to see the fields under the how long TIDIE in CIKD. I want to see the searches under that because I think the way that they're presenting it is that at 6:23:49, Apple pulls into like the foreground of the memory, the how long does it take to digest food as a suggested search term, as how long TI die in CIKD is being typed in, and then how's long is after that one, is my understanding.
I understand your opinion that that search didn't happen at 2:27:40.
This document is showing you the data that is the parsed result. The source of that artifact that you see in the last column is a little bit cut off, the browser state db-wall file. That database does store, how the data is stored, the search term "How's long to die in cold" with an associated MAC absolute epoch timestamp that translates to 2:27 a.m. That is what is physically stored. That does not annotate the meaning of that artifact. That was determined through testing following the NIST OSAC data generation guidelines for testing.
In the second row, we see a timestamp on the left-hand column, 6:23:49. And it provides artifact, the cache record. What is the term, and what does that mean under the search term?
iOS Safari cache records. A cache refers
cache
to something that a computer program wants quick and easy access to. When we search on our phones, anything, a lot of times, be it in Google or in Safari, depending on what type of phone you own, it'll suggest what it thinks you're going to type in, right? So you can click it. It's trying to be helpful. In this instance, at 6:23:49, we have a cache record that indicates that Apple suggested the phrase, "How long does it take to digest food?"
And then under that, 6:23:51, it appears it says a recent web search.
I wish they would give us the whole page.
How long, TIDIEINCIKD.
It would sure help to just have
So
the whole
this,
page.
in reference to these two search terms, this is the first actual search that occurs at 6:23:51 a.m. Upon beginning the typing of that phrase, Apple provided the suggested search, and the
that's much more
person
clear.
inputting into the
that's
phone at
helpful.
that time continued to type out a phrase and finished it as "How long, TIDINCIKD," which that is available to us in the Mobile Safari P-list, which tracks recent web searches. And then we'll see 6 seconds later, we get that reference in that Knowledge C database that I mentioned before. That's the next line. So that's the Knowledge C database is Apple's way of keeping knowledge about what the user's doing. It sees and holds your knowledge. It's an easy way to remember it. That's what I teach my students. So that Knowledge CDB tracks a lot of things for predictive purposes. And so 6 seconds later, it's logging that same search. So that search is being tracked in 2 places.
And so one search can be left as artifacts in different locations on the database?
Correct. There can be multiple traces or artifacts of the same user action in different places on a mobile device.
And if we go down to the bottom, the last column, at 6:24:47, we again see "How's long to die in cold." And if you look in the first column, it's the same phrase. Is that a coincidence that it appears at the bottom at 6:24:47 and also appears up at 2:27:40?
As mentioned before, through testing of the artifact for Browser State DB, that artifact will hold the most recent search that happened in the tab. So it is logical that how's long, HOS long to die in cold, was searched at 6:24:18, tracked in that Mobile Safari P list, repeated in Knowledge C, Knowledge made its tracking in Knowledge CDB, and then that table for Browser State DB, which again has the time that the tab was opened, or the last time it was backgrounded, and updated just the website that was visited. So the website, that is why we get that 2:27 time. That's actually, as far as the data storage is, the first thing I have in there, because I want to put it in chronological time order for exhibit purposes, is actually the last thing to happen, because it's the update
It's
to
okay.
what's in the tab.
We will go through
You
it
offered that the "How's
again
long to
when
die in cold"
well,
is
we
the
get to
last
the
thing
lunch
to
break.
happen. Do you have an opinion to a reasonable degree of scientific certainty the time when that search was made?
Objection, Your Honor.
To a reasonable degree of certainty, I can say that "How's long to die in cold" was searched at approximately 6:24 a.m.
Now, moving on from the 227 search, there are 2 other issues that you were asked to analyze. We talked about them at the beginning. Let's begin with whether or not you looked at the data and analyzed the data and came to any opinions about whether that phrase, how long to die in cold, was user deleted on that device?
So there's two really key elements as to if that was user deleted. If the question is, did I come to opinion? Yes. Do you,
Can you explain how you came to
She's
that?
like,
to an
yes, I
opinion
did.
That we'll ultimately share with the jury.
The first line in that exhibit, the ending of that, if you remember, it said browser state.db-wall. That's important. So we'll talk about that in a second. But the first thing I want to bring up is kind of how the database works, because I didn't just look at the tool result. I extracted that database and I did a deeper analysis on it using Sanderson's tool, because that information was in that dash wall file. So when a SQLite database, which is a specific way of storing, very, very common on mobile phones, actually one of the most common, when that database stores data, it has two versions. The most recent version, and the version in use here, uses what's called a write-ahead log. So before data is committed, it is written to a write-ahead log. I'll kind of explain it. So let's say we're in a restaurant and we're sitting at a table and we're ordering food. Our table is the table. Data is going to come to the table, and that's going to be our food. So when we order food, let's say we've got a chicken sandwich, a burger, and a pizza coming to the table.
Ma'am, the chat has requested corned beef hash and cake
the
so
pizza,
far
the
today.
kitchen puts it in the warming area.
I mean, it may be a gummy at this
The
point.
write-ahead log.
Just
The server grabs it from there. It's where data sits before it goes to the table. Just like your food goes to that serving station before your server brings it to your table. Server brings it to the table.
By the way,
that table's got
those types of mobile games give me the most anxiety. I cannot give me the most anxiety, and I cannot play them. You've got to decide where things, the most anxiety, the most ever. Just as we're getting back to. Ashley in the chat said, Stacy, the cake is a lie. Oh. Some of the chat will be like, what? And some of the chat will be like, if you know, you know.
It's burger, it's chicken.
You know. Trisha also, sorry, we had to address the perfection of Trisha's comment in the chat that said, yellow cake, milk chocolate frosting. 10 out of 10. 10 out of 10. 10 out of 10. 10 out of 10. 10 out of 10.
And it's pizza. Another table orders waffles and pancakes. They think it's breakfast.
Chicken and waffles. Also, it's always brunch. Babes, it's always brunch. It's always brunch.
To the table, that table's got its burger, its chicken, and its pizza. Another table orders waffles and pancakes. They think it's breakfast. The waffles and pancakes are made by the kitchen. They're put on the serving area.
I do miss,
Waitress
since
comes
moving,
over.
by the way, Roscoe's Chicken and Waffles was nearby one of the courthouse I worked at. It was such a good lunch spot. It was such a good lunch spot. It was such a good lunch spot. Okay. I miss
This
Roscoe's.
pizza has pepperoni. I don't eat pepperoni.
Same.
Can you send it back? Waitress picks up that pepperoni and sends it back. That's a deletion. Pepperoni pizza was just removed from the table, right? We're deleting it. We're moving. We said it's not what we wanted.
I bet the jury's like, got it, 10-10.
She brings it back to that serving area. At that moment, that serving area has the deleted pizza, but also the waffles and pancakes that are waiting to go out to the table. That's how a write-ahead log works. Any changes that are happening sit in the write-ahead log until
It's a great analogy.
The database is closed, and then when it's reopened, all those changes are made, both additions and deletions. So often when a phone is imaged, when we make a forensic image, the
It's just something the jury can
applications are
understand.
still open, so we have those wall files.
I know.
When
Everybody's
we
like, is it
look
lunch?
in our
Can we have
Safari
lunch?
browser,
I want lunch.
the database knows to read it to you in its current state. So it tells you where the waffles and pancakes are going. They're going to that table. So it shows it as if it's in the table. But it's not in the table yet. So if when we parse the data and we look at the restaurant and we don't look at the back kitchen, we would only at that time see the chicken and the burger, right? Pizza got sent back. Waffles and pancakes haven't come out yet. So when we get the data, we get two files. We get the restaurant, that's the database.
The pizza
and we
was
get the
rehomed.
serving area, that's the wall file. just because it's in the WAL file does not mean it's deleted. It means that that record
been sent
wasn't where
back?
it naturally sits yet. It could be that WAL file can contain deleteds and food or data that hasn't yet been delivered to the database. So the WAL file consists of both. So an assumption that the data was deleted just because it's in the WAL file is actually not true. And the peer review paper.
To the windows, to the walls. Sweat drop down my mouth. All your patients crawl. Okay. Just the jury doesn't have a summary and they're sitting there going, oh, it's almost lunch. She is saying essentially, to the best of my ability to distill, that the WAL file is kind of a holding area and it doesn't necessarily mean something's been deleted, and different software interprets what they find in that area differently. It could, in her analogy, it could be waiting to go back to the kitchen, or it could be waiting to go back out to the table. A change is waiting to happen because a change will do you good. So a change is waiting to happen, but it doesn't necessarily mean that deletion is the thing that's happening. That is where the analogy is getting. The WAL file is holding the changes, and then the software that interprets those artifacts makes assumptions about the artifacts, and that's why different software interprets artifacts differently. Exactly. Niche, exactly. Yes. So that is what she's trying to explain to the jury about what's going on in the wall. The window. We're just going to sing. Because again, the jury has to distill this for themselves, or say, because the jury can 100% say, don't care. They can 100% be like, fine, whatever.
That I had accepted in Forensic Science International
So, fine.
actually has a section that explains this.
I see the court's hands It's got to be almost lunchtime. The court is backing up the chair.
Exact
It's got to be almost lunch.
For SQLite databases.
Mr. Brennan?
About how we refer to that as recovered and not deleted. Actually, through that entire document, we don't use the phrase deleted. We refer to things in statement of recovery because we need to determine why it's there. So we can't say that it's deleted just because it came from the WAL file. Some tools will automatically indicate to the examiner that they need to dig deeper into that. I did do further analysis by looking at the WAL file.
With your eyes.
Particular
Call
item
back to yesterday.
and it's a little bit more complex, actually exists on multiple pages because it moves as the database is being created, but all of them have the same unique identifier. So it's the same entry. It's not more than one search of Haas long to die and cold. If there was more than one search that had occurred where it became the top element in that database, we would see that. There are, as I mentioned, other carved from the database, from the WAL file elements such as the search for the YouTube video, It's Raining Men. Because at some point that was the last viewed item in a tab when that tab was retired right before, also at 2:27 a.m.,
My
but
tabs are
a couple of
retired at this
seconds
point.
before the Haas long to die in
As are
cold
half of
search.
law enforcement
so
in this case.
we can see that that table is put to the rear. The newest tab that's open, which is why it's in the WAL file, it's the most recent thing because it's like our waffles and pancakes, hasn't been delivered to the table yet. So it can sit in the WAL file for that reason. It doesn't indicate it's deleted. The second reason is there is no user interaction in the interface to delete a tab. You can open and close a tab, and open and close tabs are tracked in that database, but you cannot delete a tab. There's no, if you were to pick up your iPhone, I know you don't have them right now, but if you were to pick up your iPhone and look, that wouldn't be a physical option you have in the interface. So it could not be deleted by a user through the interface for that most basic reason.
So a user, could they delete a tab if they wanted to?
There's no actual option to delete a tab. For your web history, you could clear the cache, for example.
You can close it.
Most of us are familiar with clearing the cache in your web history. You might do it because you don't want your kids to see what you searched, or maybe your kids don't want you to see what they searched, so they'll delete it. But you can't delete the tab history. It's just what tabs are there. The device is tracking that.
When you looked at the software, whether it was Axiom or Celebrite, when you look just at the report, not the data itself, do either of those reports have any indication noting that that web or that Safari search is characterized as deleted?
Tools, Celebrite denotes it with a red X, which means that it is recovered. Axiom indicates that it is carved. In the same paper that I referenced earlier that I authored, there's a chart in there that shows the distinction between how different tools, some will use red X's, some will use question marks, some will list carved or parsed, so every tool chooses to do that differently. That does not mean deleted. It means it needs further analysis.
Should an examiner who looks just at the reports of the software assume that if it is marked as recovered in Celebrite or carved in Axiom, should
an examiner should never assume something's deleted without doing a manual examination.
The manual examination, is that a method that's used, that's generally accepted in the forensic data field?
The NIST Science Foundation paper, as well as the dataset generation guidelines, both speak to conducting testing to verify and validate, and it states clearly that an examiner is to verify and validate findings and to determine meaning.
So given that you've used multiple tools to look at reports regarding this phrase, how
No
long
comment said, what the heck are y'all searching?
and
Don't
have
worry about it.
seen indications or characterizations of recovered
Don't
and
worry
carved.
about it.
And in addition to the fact that you actually analyzed the data, did you arrive at an opinion to a reasonable degree of scientific certainty?
It has nothing to do with
whether or
wingspan,
not the
I promise.
user deleted, any user deleted the phrase, "How's long to die in cold"?
Yes, if it's how's long to die in cold. Sorry, trying to clarify.
Pardon me. Did you come to an opinion to a reasonable degree of scientific certainty whether any user deleted the phrase, "How's long to die in cold"?
Yes.
And what is your opinion?
My opinion is there was no deletion that occurred by the user because it is not something a user can delete.
Finally, I want to ask you about your analysis of the phone records on this phone attributed to Ms. McCabe. Did you go through an analysis of the phone logs and the phone records on the phone?
I analyzed the call logs and the phone logs on the device that I was given, that I was told belonged to Ms. McCabe, yes.
Would a suggestion
others.
or a claim that a user deleted irregularly a number of phone calls, would that be accurate or inaccurate in your experience?
It is inaccurate in this instance.
Can you explain to us why and how you came to that conclusion?
Yeah, this is actually really interesting.
Oh boy.
Because of what it appears in the forensics tools.
When we get to, actually, this is really interesting, I'm like, oh no, this is going to get technical.
And additional artifacts that I looked at that are not parsed by the forensics tools. So the call logs, when you look at it, it appears, I don't remember if it's 8:57 or 8:59 a.m. in my mind at the moment, but approximately either 8:57 or 8:59 is the earliest phone call we see on the 29th of January. We see no call logs before, but we do see FaceTime logs before. So if an examiner, again, was making assumptions without testing or reviewing, the first assumption might be, well, things must have been deleted because there's data that exists before, but not current data. So then you have to go, how do phone logs work? And again, create test data and review. What the situation here is that there are 3 types of call logs on this particular phone. There's regular calls, incoming and outgoing. There are FaceTime video chats, incoming and outgoing, and FaceTime audio chats, incoming and outgoing. The storage for that is actually 200 records. So you can only store up to 200 of each. Now, if you were a user of, let's say, WhatsApp or Signal or Telegram, those would each count too, and they'd get their own logs. So when we look at the database for the number of calls between 8:59 a.m. or 8:57, again, I apologize, I'm not looking at that precise time, on the 29th of January in 2022, there are exactly 200 calls still in that record from then until the imaging of the phone. There are 199 FaceTime video calls and only 27 FaceTime audio calls. So the question is, how do you validate that that's what's happening? So we actually have call logs that we can pick up in other places for recent call logs in the last 7 to 30 days, depending on the exact version of the device. And
I mean, the one thing we do know from this case, if we know anything, is that Jen McCabe will blow up a phone and just make all of those calls. Interesting to hear that the different types of calls will only hold 200, because I think where we're going to end up with this testimony is they should have gotten the phone earlier. Because if you get the phone earlier, then you're not going to have databases overwrite because they're full. But because Jen is just like FBI open up. The FBI! She's making as many fucking calls as you can imagine. I mean, she's not going to tell the FBI about all of them, but she's just call. I'm interested. I don't remember the date from even earlier today when they extracted Jen's phone. I'm going to have to go back and look. So much has happened today.
And how the biomes are running. We can actually see incoming call logs, the number they go to, and if they're incoming or outgoing in the biomes. So we actually can see the history going back for the entirety of that day on January 29th till midnight. Again, my scope was from midnight until noon. So we can actually see all of the calls. They're just not all in the call history state DB. Now, the call history state DB, from a user perspective, that button on your phone doesn't say call history. It actually says recents. And what it's determining as recents is the most recent 200 of each category. Now, how did I determine this further? There is a running log that exists in a phone. It lasts about 3 days. It's called the unified log. The unified log tracks multiple things that are happening on the phone. In manual analysis of the unified log,
thank you, Madeline. Madeline in the chat said February 2nd. A number of you in the chat said February 2nd. I think so too. Would it shock me that between January 29th and February 2nd, Jen McCabe made over 200 calls? With everything that we've seen, that really wouldn't surprise me. With her. With others, maybe, but with Jen McCabe, maybe not. And I guess the easiest way for them to know that would just be to grab her phone records from Verizon. I think she has them. But it would not surprise me, given what we know of how Jen McCabe was using her phone at other times, that she made 200 calls in that period of time with her phone. Or her butt made some of them. That really wouldn't surprise me.
Each time a 201st call comes in, the 200th call gets deleted. So it's constantly just the last 200 calls. It may not be typical that we see 200 calls in 3 days, but on this device, we do see 200 regular phone calls in the 3 days between 8:59 a.m. on the 29th and when the phone was imaged.
Do you have an opinion to a reasonable degree of science?
So she's saying that the last call that they have in the record was from 8:59 a.m. on January 22nd. Now, again, for another user of the phone, I would be like, but for Jen, with everything we've seen, I 100% believe that in 3 days she made 200 calls. Now, do I think that's a difficult fact for the defense? No. I think that's a really good fact for the defense. If the defense is focused on Jen deleted these calls to be sus, they can focus on that. But if the defense focuses on these overwrote because she made 200 calls before she gave the phone to police, and her phone records show that she called John O'Keefe. She says that she didn't delete those. Fine, you didn't delete them. Let's talk about the fact that you are making 200 calls in 3 days. Who you talking to? What you talking about? Why you talking so much? You talking to everybody? You talking to Tully? You talking to Proctor? You talking to the Alberts? You talking to your sister? You talking to your sister's husband's best friend's hairdresser's, dog walker's mechanic? Yup. And I think the 200 calls in 3 days is actually a better fact for them to argue than that she deleted. And I don't remember the 200 calls in 3 days from last time. I think it's a better fact for them than that the calls overwrote. If they overwrote, it'll still be in her Verizon records or whatever. It'll show those calls were made. John O'Keefe's phone shows those calls were made. And she said, I didn't delete them. Okay, you didn't delete them. They overwrote because you made 200 phone calls from January 29th to February 1st. I think that's actually more in line with what the defense theory is than whether or not she deleted those calls out of her recents. What do you guys think? Do you think the 200 is the bigger deal? Or do you think that were those calls deleted or not deleted is the bigger deal? What do you think is the bigger deal sitting here hearing that information? You let me know in the chat. Because it's a shocking number of calls. It's a staggering number of calls. And if what's she doing? Putting together a timeline? If I'm the defense, I am at closing talking about every witness that mentioned Jen McCabe's name, including Karen Reed. In clips you heard Karen say, Jen said we came over. And I am saying, you have Jen telling Proctor, Jen telling Tully, Jen telling this, Jen telling that. My argument, Jen is wrong and everybody relied on her information. And then to make sure that it didn't look like she was wrong, she made 200 phone calls between January 29th and February 2nd. And everything points back to what Jen said. And if you have bad information from what Jen said, this whole investigation is based on bad information. But she didn't want you to know that it was bad information. So she called 200 phone calls, including to Proctor. The FBI is knocking at Jen McCabe's door. FBI would sure love to chat with you. And she's like, I need 10 minutes to brush my teeth. Makes 5 phone calls, discloses 2 of them. Why? And if the entire case is based on everyone relying on what Jen McCabe said, if the jury does not find Jen McCabe credible, the defense can say this entire investigation is built on a house of cards on what Jen McCabe said and to who. And if you do not find her credible, then that entire house of cards falls. You pull that card out, everything falls. And you cannot rely on this investigation that did not question what she said. 200 calls. You pull that card, everything falls. And the jury has room to find her not credible based on her statements about the FBI. 5 calls in 10 minutes. She might have misinterpreted a question here. She might have misinterpreted what she said there. She might have, coulda, shoulda, woulda. 10 minutes, 5 calls. She disclosed 2 of them. Period. 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 And if I was the defense, I might get snappier about it. It just depends on where the jury is with them. I might get snappier about it and be like, she's just a regular mom. She's just a regular mom. And she thought she had figured it all out. And law enforcement relied on her instead of doing their own investigation. Who told Trooper Proctor about Karen Reed's health issues? She doesn't like Karen Reed. You saw her on the stand. Jen. There's no love lost there. She wasn't trying to protect Karen Reed. She was calling everybody up to talk about what Karen did. And law enforcement just went with it because they didn't do their own goddamn investigation. The investigating officer didn't even bother going to the autopsy. You pull that card, the whole house falls. And everyone in law enforcement listened to it. Everyone. If you listen to this testimony, Jen McCabe said, Jen McCabe said, Jen McCabe said. And they didn't verify it at all. They don't even need to argue third-party culprit. They can just argue that one person inserted themselves in the middle of this investigation and that person was wrong and that person's not credible. And therefore, how do you determine that this was a good investigation? And if you have doubt about that, how can you find any of those charges? Regardless of what Karen said, because half of what Karen said is Jen said. Karen said, I left him at the waterfall until Jen said, we saw you at my sister's house. And isn't it then consistent that Jen is blowing up John's text going back and forth to the window? John, where are you? John, where are you? Where are you here? Are you here? That's completely consistent behavior with 200 fucking phone calls in 3 days. You don't have to argue that there's a cover-up. You don't have to argue that more people are involved. You just have to argue that Jen McCabe is not credible and everything is built on her information. And pull that card. I don't remember hearing about the 200 phone calls from the last trial, but it is striking to me. I don't remember that at all. But for the defense to get to doubt, all you have to do is argue that everyone based it off of Jen. And Jen made up her mind. But I don't remember those 200 phone calls from last time. It's, I think, significant information. Anyway, let's get back to court. Sorry for my soliloquy, random closing argument. It's I think, important, really important information. And that's true. The chat pointed out that's a minimum of 200 calls. Karen, that's 100% right. A minimum of 200 calls. So, all right, let's continue. And yes, chat, I wrote my closing arguments in my brain as I was working backwards on the evidence of my cases. They would change, but I always started at the close. It's my favorite part, not to be dramatic, but 200 phone calls. It's a lot. It's a lot.
Calls in 3 days, but
We're gonna just back that up. 200 calls in 3 days.
3 days. It's called the unified log.
All right. We're going back to the phone logs. So what she said is there are 3 different logs for the phones that keep records, and they overwrite at 200. There's one for FaceTime video, one for FaceTime audio, one for regular calls, and then other calling apps would have their own Signal, WhatsApp, whatever. But they all hold 200. And so they are saying that the call history is overwriting, like new one in, last one out. So when the new one comes in, that 200 leaves. So the reason there are missing calls on the log that they are looking at is because they've simply overwritten in the 3 days it took to get the phone logs. And then the defense can get back to who's interviewing with Carrie? Jen. Who's there at the grand jury with Carrie? Jen. Who's calling law enforcement? Jen. Who's organizing to have law enforcement come interview other people? Jen. Who's going over to Lank's house? Jen. Who's talking to law enforcement on scene? Jen. And if you pattern your closing like that, the jury's going to sit there being like, Jen.
Sense is the most recent 200 of each category. Now, how did I determine this further? There is a running log that exists in a phone. It lasts about 3 days. It's called the unified log. The unified log tracks multiple things that are happening on the phone. In manual analysis of the unified log from this phone, I can clearly see each time a 201st call comes in, the 200th call gets deleted. So it's constantly just the last 200 calls. It may not be typical that we see 200 calls in 3 days, but on this device, we do see 200 regular phone calls in the 3 days between 8:59 a.m. on the 29th and when the phone was imaged.
Do you have an opinion to a reasonable degree of scientific certainty whether there was any user deletions from the phone call log that morning?
Yes.
And what is that opinion?
The opinion is that I can see that it's done by the device itself utilizing unified logs, that the system is deleting the 201st call every time a new call is received or outgoing.
Thank you. I have no further questions.
All right, can I see counsel at sidebar regarding scheduling and a few things?
I think they're going to lunch. We paused our lunch a little bit. It's time for us to go to lunch too. We paused our lunch a little bit because I do not remember this discussion, and maybe I missed it last time. There's so much new information. Again, it's so much easier to look at this a second time than the first time, but I do not remember that volume of calls because it stands out. But it also makes sense the way she explained it to me. It makes sense that those are not user deleted. Do I think that's bad information for the defense or prosecution? No, I actually think the 200 calls are in line with the defense's theory and are kind of neutral to negative for the prosecution's case. Let's see when the court releases the jury. But I think there's a way they can use that information to their advantage. Let's see what she says to the jury. We're going to have the jurors take lunch.
Thank you.
45 minutes.
All rise for the court, please. Jurors, close your notebooks, follow me.
All right, jurors are out. Let's see if they go back onto the record at all with the lawyers. I don't think that they will. I think we're just going to end up at only bulb, apparently. All right, court is still at lunch. I'm going to take just a few. We're going to do just a few questions, and then we're going to zoom. But one of the ways they can clear that up, and the defense has them, are Jen McCabe's call logs from the cell phone carrier. They also have John O'Keefe's phone. So any calls from Jen McCabe's phone to John O'Keefe's phone, they can register. I'm going to try to summarize the best that we can, and we'll go from there. Jenna asked, is FaceTime considered a call? The expert said that FaceTime calls, FaceTime audio, and regular calls all have their own logs. And she said that there were 199 FaceTime calls that were in the log. She didn't say over what period of time. And so they had not overwritten, and that there were more than 200 calls because those were overwritten, and did not say anything about FaceTime audio, but each mechanism has its own log. So a lot of you are saying you think the 200 is a bigger deal. Let's try to summarize as best we can. And then I'm going to grab some lunch real quick, and then come back, and then well, we'll see what the rest of today holds. I will probably not do a ton of, I did that terribly. I will probably not do a ton of questions at the end of the day, because it's birthday things, and what are we gonna do? Well, eat dinner, have a little bit of cake, hang out with the kids, and go to bed. Why? It's AP testing week. It is May-cember, and we have court tomorrow. And we went to Metallica. Metallica was great. That was what we decided to do for our birthday. So that's what we will be doing today, because another year older and another birthday spent covering the Karen Read trial with the Law Nerds, just like last year. Do I get to just call it an age backwards? No, maybe. Emily, what did you buy for your birthday? Concert tickets. We bought concert tickets. We bought concert tickets. Why? Well, because it's my favorite thing to do. It's other than spending the time with the Law Nerds and the family and the kiddos, it's going to live music. let's try to do a summary. Also, Rick Hoke texted me today and asked, and wished me a happy birthday and made a little bit of a joke that I share a birthday with another YouTuber. I'm sure there's more than one. And I was like, Rick Hoke, that particular YouTuber, sir, not that I'm salty because my kid teases me about this every year. That particular YouTuber was born in 1998. He shares a birthday with me because I was most assuredly in college in 1998. In 1998. So I don't care if he pops up first for May 7th on famous birthdays. I'm still on there somewhere. Let's try to do a summary of the morning. And I was teasing Rick about it, but I thought it was very, very sweet. And it's always nice to chat. I look forward to, I get to see him later this month, and I'm very excited about it. So let's see where we're at. Who do we start with? Oh, Connor Keefe. How have we already forgotten? How have we already forgotten? Well, we learned some new information on day 11 of the Karen Reed trial, and somehow I find myself continuing to be more and more perplexed, even though we have seen this trial once before together, or some of us together. We have seen the pretrial motions, and yet new things are illuminated. The morning started with Trooper Connor Keefe, who is a more junior state trooper, it seems, but was real salty, in my opinion, when asked about Trooper Proctor. I think that Yannetti did a good job on cross-examination in using the cross-examination of this particular trooper to highlight how involved Trooper Proctor was, to highlight again that Trooper Proctor is the lead investigator. I wonder if the jury's asking. We haven't heard from Trooper Proctor, and highlighting how involved Trooper Proctor was. They also brought in the physical evidence collected at 34 Fairview during the search on January 29th, 2022, after that was found after 5:45 p.m., the pieces of taillight and the shoe. There was an objection because one of the evidence bags was marked as 2 pieces of taillight, and there was like itty bitty little piece. Brennan was asking if it cracked off of something, and the defense is like, no, that evidence bag says 2 pieces. This is now 3. I remember that coming up last trial, but this trial, Brennan was like, can you just take it back and secure it into evidence with you? And I'm like, what's he going to put in his pocket? So the court reporter handed them an envelope, and they marked it for identification as marked for identification BB. And I was like, it's a little bit. It was the tiniest little thing, but how the heck did it get broken? If it got broken, once it was in the evidence bag, they're going to have to ask the lab about it. But we have those pieces of taillight that were recovered at the scene on January 29th, and then the shoe that was recovered. Those all were shown physically to the jury today and are now in evidence. And then we got into questioning about John O'Keefe's autopsy. I do not remember this line of questioning previously. And Connor Keefe, the kind of more junior detective on this team, was the one who attended John O'Keefe's autopsy, not the lead investigator, Proctor, and not Proctor's partner, Trooper Buchanan. Neither of them attended John O'Keefe's autopsy, and I had not remembered that fact. And if they talked about it last time, because so much came in with Trooper Proctor that was new information to me, that it did not register with me that one of the more junior members of the team was sent to the autopsy like, just go watch the autopsy. In a lot of homicide cases, it is the lead detective or their partner. And when you have an unknown death of an officer, it's surprising to me that the lead investigator would not attend the autopsy. After we get into Trooper Proctor's text messages, though, that might be a better fact for the Commonwealth. We'll see. It was surprising to me, though maybe it shouldn't be surprising to me, the things that have gone on in this investigation. And then the Commonwealth's next witness was Jessica Hyde, or is Jessica Hyde. They are just finishing direct examination at the lunch break before we get to cross-examination with attorney Alessi. But before we got to that witness, there was a break for argument with attorney Alessi Brennan and the court over what Jessica Hyde could be cross-examined with. Alessi was asking to introduce a, brain stopped, to introduce a certified copy of a court ruling after a Daubert hearing where Jessica Hyde was the expert in Maryland. The argument was that that ruling should be able to come in as evidence. That physical certified copy of the ruling should come in as evidence in this case, and that he should be able to question her about it on cross-examination. At the end of that argument, the court went and read, I think, the entire opinion, came back out after a substantial break in the morning, and then made the ruling that Alessi would be able to question about it on cross-examination, but that the case itself, the physical case, would not be marked into evidence, which I think is the right call because it's not evidence in this case. It is proper grounds for cross-examination. And then Jessica Hyde, who we saw last trial, took the stand to talk about the tab activity and search activity on Jen McCabe's phone, and to talk about whether or not searches were deleted off of Jen McCabe's phone and whether or not phone calls were deleted off of Jen McCabe's phone. And that's where there was some new information for me. But as we got to the breakdown of how the tab time works versus search time, they brought up a chart that showed that Apple predictive search was activated with a, let me take a look real quick. I'm just going to pull it up so I can see it because I screenshotted it because I wanted to be able to see all the times, but pulled up the predictive text, and that predictive text was starting to populate at 6:23:49. When the defense expert testifies, we will hear more about that cache record of the Apple suggested search term. And the Apple suggested search term at 6:23:49 a.m. was, how long does it take to digest food? And then we see recent web searches pulled up after that, showing recent web searches at 6:23:51, 6:23:57, and 6:23:56 that are all from different artifacts and put together. She explained which artifacts they were from, but those were different artifacts in different databases on the phone, and all of those at that 6:23 time frame were the how long TI die in CIKD search, and then went into discussing the how's long search, which came from two different artifacts in the phone at 6:24:18 and 6:24:47. So they say from Google search and recent web searches, the timestamp on those searches is 6:24:18 to 6:24:47 a.m. and that the 2:27 is the time of the tab, which we have heard from the prosecution's experts before, and we know that the defense experts refute that. This expert says the time when the tab is opened and when the other searches were happening, like Hockamock Sports, etc., that if it stays open and the tab is left open until the tab is closed, it does not write. And when it writes into the file, it writes the time that the tab was open. So that is consistent with what the prosecution has said and what their other expert has said. I believe that we will see different testimony when we get to the defense expert. And then we got into the whether it was deleted or not. This expert said that the user could not delete that how's long search, that it goes into the wall file, not the windows to the walls, but the wall file, and different programs can express things that are in or removed from the wall file differently, and was explaining how different programs express that differently. And when you dig deeper into the records, that is not a user deletion. And her expert opinion was that that was not a user deletion because that is not something that can be user deleted. Again, I think we will see a different explanation of that from the defense expert, but I find this expert easy to follow and understand. Whether or not the jury ultimately agrees with her opinions or not after they see all the tech experts is up for them to decide. The thing that was most notable to me with the discussion of Jen McCabe's deleted calls, and we know from Jen McCabe's testimony, the defense is talking about what Jen McCabe called inadvertent calls or butt dials to John O'Keefe in the after midnight hours of January 29th, 2022. The explanation for those not being deleted from this expert is that the phone stores 200 records for different types of calls. A FaceTime video call will store up to 200 of the most recent records. A FaceTime audio call will store up to 200 of the most recent records. And phone calls will store up to 200 of the most recent incoming or outgoing phone calls. And from January 29th to when Jen McCabe's phone was imaged on February 1st, Jen McCabe's phone had made over 200 calls. So as the 200th call came out, or the 201st call came out, the last one in time of that 200 was overwritten by the system. And the last of that 200 that they had at the time her phone was imaged was from 8:29 a.m. on January 29th. So between 8:29 a.m. January 29th and when Jen McCabe's phone was imaged on February 1st, there were over 200 incoming, outgoing phone calls. I thought that number was significant. I think that it is a lot of phone calls. And I think if the defense is going to argue that Jen McCabe was at the center of who was talking to who, 200 phone calls in a bit less than 3 days is a significant number, and might be more significant than arguing about whether there were user deletions of those calls to John O'Keefe. I don't know if the defense will see it that way or argue it that way, but I found that 200 phone call number to be notable and surprisingly a lot of calls. Should I have been surprised? Maybe not, because we know that in Jen McCabe's testimony, she said when the FBI wanted to talk to her, she said, I need 10 minutes, and promptly made 5 phone calls in under 10 minutes and only disclosed 2 of those to the FBI and said she forgot to tell them about the other 3. That's a lot of phone calls. So when the defense gets into their tech expert, I wonder if they will bring up Jen McCabe's call logs, phone logs, or phone records from the cell phone carrier if they have them. Alan Jackson, in his cross of Jen McCabe, said that the reason they knew about those calls to John O'Keefe were from John O'Keefe's phone. So I do not know if they will have those corresponding call log records, but 200 calls, I think, is a significant number, and we will see if the defense argues that. But also, it might go to the prosecution's point. She did not use or delete those phones, which is consistent with what she said. In fact, she was so talkative on the phone that they manually deleted off the phone because there was literally not enough room in storage for the amount of phone calls that were incoming and outgoing in the days immediately following John O'Keefe's death. Cross-examination of Jessica Hyde will take place after lunch with Attorney Alessi. I'm very curious to see where we go with that, especially after the argument that he made before lunch that there was a court finding when Jessica Hyde was the expert, finding that some of the proffered expert opinions were not allowed in to evidence in another case in Maryland because the specific location did not have access back to the Apple metadata and the Apple algorithms, not the metadata, the Apple algorithms and the proprietary Apple data. And because that was not accessible, the court found that that information could not be testified to by by Jessica Hyde. We will see how that comes up in cross. I'm very interested to see how Alessi approaches it. But for now, we should go to lunch. Miss RCM said newcomers don't know yet that Mr. McCabe is a tech guy. Mr. McCabe hasn't testified yet. So the jury does not know that either. You mean phone calls automatically deleted by the phone instead of manually deleted? I do mean that, Miguelina, and if I inverted it, I apologize. Brain is definitely tired. Koniko Perfection said the oil slick tumblers are beautiful. Thank you. They feel like I don't know, emo unicorn oil slick vibes, and I love them. Katie, I don't think Mr. McCabe will be called at this point either. But the defense can. The defense can call him. So I'm going to take 10 minutes. I'm so glad we had the Zoom room this morning. We're going to need it this afternoon. I'm going to take 10 minutes. I'm going to star some question for all of you. Thank you so much for the gifted memberships, the super chats. I will be gifting some memberships. Thank you for the birthday wishes. I appreciate it. Tina, thank you for the birthday wishes. Where the law nerds get to spend the day together in trial. So I appreciate it. And, you know, it's May, so everybody's in school. It's great. You know, we're having a law nerd day, and then we'll get to spend time with the family. So for all of you, thank you so much. You are truly incredibly generous and kind. And I, A, very much appreciate you. B, I love that I get to do this, even when it's frustrating, because I'm not frustrated with y'all. We're all just frustrated together. We're just like, what are we even watching? But I think it's important to cover cases and see what the jury sees the best we can. In this case, it's harder because it's a retrial, but to see the witnesses that we have questions about, the witnesses that we're like, I can see how a jury could understand that. We'll see what happens next. And talk through the law, the process, the jokes, and the song lyrics with all of you. Melanie, thank you so much. My niece wants to know about your earrings. Can you talk about them when you have a chance? They are linked. I'm sure the mods linked them. I linked them on my Amazon store. They are, oh my God, my brain is totally blanking. I know exactly who they are. The chat is going to tell me, and I feel terrible for blanking. But Kendra Scott, thank you, moderators. I appreciate you. They are Kendra Scott, and I picked them. I love a hoop, but hoops do not work with the shape of my face as well. These work incredibly well with the shape of my face, and I love them. And I have them in multiple colors, and they have Kendra Scott at Target and stuff. So you can find all kinds of cute Kendra Scott stuff, but I love these. I also have a small little diamond pair of them. I love them. So these are my favorite, and they're lightweight. They don't like pull my ears. It's just great. Peyton asked a great question in the chat. When the jury's deliberating, will they have access to jury transcripts? No. They will. The jury will not have access to witness transcripts. It is their memory of what was said. And I don't even know if they will get read back. In a lot of jurisdictions, you can ask for read back, which means I need to hear what this witness said again about this. And the jury comes back in and somebody reads the transcript back to them, but they don't get it to take back with them. That has to all be done in open court. So that is a great question, and I appreciate it. We will get to more super chats. Don't worry. I'm going to take a minute to go to the restroom to get some food, and then we will be back. Some of you were saying she didn't allow read back last time, which is so weird to me. If the jury wants some read back, let them have read back. Like, courts get salty if the jury wants 5 days of read back, but when the jury is stuck on an issue, I think part of the problem is how short closings were. I hope the court rethinks that ruling in this trial. This trial is going to be over a month. An hour for closing is just not enough. Casey Cat, thank you so much for the super chat. As my bestie B2 said, happy birthday, EDB, a little whiskey. It's going to need to happen. Little whiskey for EDB and beer for the horses. Always beer for the horses. Let's take 10 minutes and let us get snacks, hydration, bathroom. Let us put our brains back into our skulls after the 200 calls and the lead investigator didn't go to the autopsy because what's even happening? Like, what's even happening? Yeah, I don't know either, chat. I don't know what's happening. Nothing makes me matter. It just the disrespect. I'm so stuck on that. It is 12:45. We will be back at 5 to 1. So 10 minutes. Court will be back. We'll have a little Zoom room. Everything is awesome. I will see you guys in just a moment. Let's get to some of our, hold on. Let's get to some of our vibes. Wait, we're too far back in the vibes. We got to start at the beginning of the vibes. There we go. Beginning of the vibes. Let's go. I will see you guys in 10 minutes. Let's take a quick lunch. We need it. We need to hydrate. Move your laundry, chat. Finish whatever you were working on that you put down when you lost your mind over the 200 calls. Go get it. Finish it. You've got 10 minutes. How much can you get done in 10 minutes? You got time. Go get it done. We'll be back. Hey Law Nerd, court is still on break, but don't forget to download the Law Nerd app so you know exactly when we're back from break, and you can get a notification from us when witnesses take the stand that you've been waiting for, when something unexpected happens in court, and during verdict watch. The Law Nerd app has all of your live court notifications to keep you in the loop. LawNerdApp.com, free for iOS and Android. And while we're on break, don't forget to hydrate, get up and stretch, and take care of yourself. Trial days are long days. trying to stay in the loop with this trial? I know sometimes it's hard if you miss a day. That's why I've got daily case briefs dropping over on the Emily Show YouTube channel and the Emily Show audio feed on your favorite podcast app, so you can stay in the loop even when things get busy. Court is still on break, but don't forget to download the Lawnerd app so you know exactly when we're back from break. The Lawnerd app has all of your live court notifications to keep you in the loop. Take care of yourself. Trial days are long days. Hello, chat. It's time to go back to court after I got my in-ears on. Emily, did you make responsible choices? No, I didn't. I decided that because I hadn't had time to finish breakfast because I was talking, that the only appropriate decision was to just make a cold brew and to finish breakfast because it's brunch. That was the only acceptable call for lunch. So it's not really lunch. Breakfast just continues. Why? Because I'm an adult. We do what we want. Did I eat yet? No. I went to the bathroom and answered a text from my mom and made a cold brew and tried to find the last protein bar, which is a crisis. I'm going to order more as we are talking, but it's all good. But Chad is asking me, did I remember to go grab Grogu? No, but I will. It's upstairs in Griffin's room. So I'm going to have to go grab Grogu at some point. Do not worry, either today or before tomorrow, because I did not run upstairs because I wanted to get back. And the cold brew took a minute. So cold brew was the focus, truly focus. And then finishing up the croissant that we made for breakfast. But look, chat, they're just so good. All right. So needed to answer mom, but no, we did not give subscriptions yet. I am going to do that now. We're going to member gift, but we're going to get into cross-examination with attorney Alessi. Oh, there is a brand in our grocery store that is spelled the exact same way Alessi's name is spelled. And I'm like, Dr. B, how would you pronounce this? And he was like, Alessi. I'm like, right. Not Alessi. Did I delete any tabs though? No, I did not. No, I sure did not. Nope, sure didn't. So, and now we have plenty of time, hopefully, for Zoom Room. Let's get to court, shall we? It's time. The jury, well, we'll see if the jury's been brought in, but it's time to bring the jury and get to court. So hopefully we will. Oh, wait, sound, Emily, sound. We're going to back up. Did I open the birthday cards today? No, I'll do that later.
You are unmuted.
All right, jurors. As you know, I think I told you in the beginning, one of my functions is to make sure that a case is tried fairly and efficiently and not to waste anybody's time. So if I get frustrated at lawyers about something, I try not to, and I don't think I need to. If I seem to cut somebody short, the lawyers are just doing their job. When they request sidebar conferences, they're just doing their job. I am going to try and keep all sidebar conferences to a minimum, but the lawyers are just doing their job. Okay. All right, go ahead, Mr. Alessi, and the witness.
It seems that the defense is like, Your Honor, you have to stop making comments, because she made a comment to Mr. Alessi when he asked for a sidebar. And she said, this is the last one. And there have been a number of times she has done that. And so she addressed the jurors and said the lawyers are doing their job. I imagine the defense complained. So that's my guess, is that the defense said, Your Honor, you keep making comments in front of the jury. What happens outside the presence of the jury is different. But in front of the jury, earlier today, Alessi had asked for another sidebar, and she's like, Mr. Alessi, last one, or something of that nature. The reason I think the two are connected is she said, I'm going to try to keep sidebars to a minimum, but the lawyers are just doing their job. I think the defense asked her and said, Your Honor, you can't do this. A number of you are asking, did the jury complain? That's really unlikely, if they even clocked it and if they interpreted it in any way, which is unlikely. Jurors just kind of look at judges like doing their judge stuff. Lawyers will interpret that in a different way than jurors will. And lawyers will worry, I think, more that jurors will be like, oh, they must be doing something wrong, than I think jurors actually interpret, if that's fair. So I think this was, I think the defense complained. I think the defense complained. And I'm not surprised, because it's not the first time that it's happened, and it's probably not going to be the last, but I think the defense probably complained. And I can understand if Mr. Alessi complained when she's like, another sidebar. So she said to them, look, and It doesn't sound very loud because she's not at the mic, but she said to them, look, the lawyers are doing their jobs. I want this case to move forward and move forward smoothly. And I want to keep sidebars to a minimum. So, all right. Who do you complain to about the judge? Well, the defense can complain to the judge. So the defense can complain. The attorneys have mechanisms for that. The jurors do too. I worked with a judge who was incredibly rude, and jurors would write in about their experiences with jury selection. So if it's generally not well taken unless someone has direct contact with the judge, someone who's been on jury duty, someone who is in the courtroom, a defendant, a plaintiff, what have you. So people who have had interaction. But the worry in a high profile case is always if the internet writ large complains, then any complaints from those that engage directly with an individual will get drowned out. Because oftentimes, especially like regulatory bodies and what have you, when it's the internet complaining or just like, miss me, it's a lot more noted when it is those directly involved in a courtroom, being courtroom staff, which is rare, but jurors, etc. I had a judge who was so rude to a member of the Board of Supervisors when we were picking a jury that I was not surprised that the member of the Board of Supervisors went absolutely ballistic and wrote letters to everyone, was so fucking pissed. And I was just like, I mean, I know it, but I would keep jurors she was rude to because she was always rude to me. So when she was mean to somebody in jury selection, I'm like, you're on my jury, you're on my jury, you're on my jury, because she mean to all of us. And that judge just, oh boy, rude to everybody. Oh, there are examples I wouldn't even give on the internet because some of them are so offensive. It's not a worry. The members know a little bit about this particular judge. We've talked about it. Let's get to it. I'm not surprised that she said, look, ladies and gentlemen of the jury, I feel no kind of way. We'll see. The jury can believe it or not. The internet's not going to believe it, but the jury can believe it or not. I think the jurors really like this judge because she is mindful of their time. And I wonder if the jurors read any comments as her being mindful of their time. Lots of judges can be untouchable. V said, so judges are mostly untouchable. It depends on if they are elected or appointed and if there is an electoral process. Because I did have there was another DA that I worked with quite a lot who got so tired of a judge. She was like, you know what? I'm fucking sick of this shit. I'm going to take your job. I'm going to take your job. I'm going to take your job. And ran against him because judges are elected. And ran against the judge and won and unseated him. It's like, fine. I'm sick of your shit. I'm just taking your job. With appointed judges, it becomes a little different. We can get into that another time. CEG texting judge. It takes quite a lot. Let's get into trial this afternoon. And again, in California, when judges are appointed, they are appointed, and then when the election cycle comes up, they have to run. So even if they're appointed, there is still an electoral process. And there is still an electoral process. Massachusetts runs stuff differently. So
I just need a witness.
Can I get a witness? Emily, stop. I just need a witness.
Yes.
Trying to unseat the texting judge took quite a lot of work. And the behavior was appalling. It was wild, and it took a lot of work. It is not easy. It is not easy. So. I know, chat, you can clock the songs in my head.
Sure.
You can. I know. And I think it's fair. Can I get a witness?
Afternoon, Your Honor.
And it's funny.
May I, Your Honor?
Yes.
Because, again,
Good afternoon.
of the defense team, I think Alessi is the most personable in court. I think there are times that both Yannetti and Jackson's style can be off-putting. Sometimes jurors are going to be like, they're doing their job for their client. Sometimes jurors are going to be like, are you trying to like pull one over on me? It's too much. Alessi's demeanor is not like that. I think he's much more affable. But let's see if we get any new vocab words today. And how this goes, because I don't think Alessi is thrilled with this expert, but Alessi's also very smart, and I think he's very jury cognizant. So I'm real curious to see how this cross is going to go. Sir, I've got an iced coffee and a croissant.
Good afternoon, Ms. Hyde.
Let's roll.
Good afternoon.
I notice you have some documents with you. Could you just state what is in front of you so I know that I might be able to help expedite this
have
if
a
I
favorite
know
bagel
what you
place?
have in front of you?
Absolutely.
What's the
I have
go-to?
the first digital forensic analysis report I completed for the previous trial.
Do you have a date? You have several of them.
I do. It's the first
out
one.
there
I
now.
apologize. This is the one.
Prior
I
proceeding?
believe it's May. I don't remember the
May
day
of
off the top of my head.
2023,
May of
perhaps?
2023, obviously. Then I have the second one. This was the one that was used in the pretrial motion.
December 2024?
December 20. Yes, that's correct. Very nice. Then I have the third one. This is the final one regarding the phone that was identified.
He's stoned. She's like very nice, and he's like, he is not. He's in full go mode.
Is Miss McCabe's.
Yes.
And then I have the fourth one, which is the phone of Mr. O'Keefe. And then I do have the opinion from State versus Herrera, but if we don't need that, that's fine.
Okay, very well. I appreciate you telling me that. In March, and you recall on your direct examination, Attorney Brennan asked you questions going to your experience and qualifications. Do you recall those questions?
Yes, I do.
You were involved in a case, is actually a murder trial in the state of Maryland.
We're getting right into
called
it.
State v. Herrera, as recently as March of 2025, correct?
Correction, it's an attempted murder.
Attempted murder. And
boy.
in that particular case, you had attempted to offer various opinions to the court, correct?
I object.
You have to move along from this case, from what you're talking about.
What?
You have to move along from that Maryland case.
So with regard,
What?
do you recall another?
You said he could cross-examine about it. I think the way to cross-examine about it, and we'll see if he goes back round. I think the way to cross-examine about it is you've given opinions in other cases, right? How many? You've given opinions about the tabs. You've given opinions about times. You've given opinions about this, and get into the nature of opinions she's been given, and then ask if all courts have accepted opinions and go through the different topics. I think he needs to go a different way to get into that line of questioning.
Case from the state of Massachusetts, Arrington case, in which you submitted a pro se amicus. Do you recall that case?
I do.
Ooh, and what's the
And
lippy?
is it correct that in that case,
Emily, riveting
you
legal commentary.
submitted,
Yeah, but we want to know.
Arguments
We
on
do.
behalf of the prosecution in that case?
I submitted an amicus brief, which is not on behalf of anybody. It's as a friend of the court.
Right, but the friends of the court, you took a position in that quote friends of the court brief, correct?
Took a position on the evidence.
Right, and the position you took on the evidence was that the frequent location history data is reliable and should be used. Is that correct?
The statement is that frequent. I do not have that amicus in front of me. It has been a year and a half since I've read it. But that amicus does discuss frequent location history records, and I want to be clear, it speaks to both bias on both sides and negative and positive of submitting it. It was an unbiased writing, and it was not specifically in support of the prosecution.
So you are testifying in this case on behalf of the prosecution, correct?
In this case, I was hired by the prosecution.
Right.
That's correct.
And
Amicus brief, and an amicus brief is a friend of the court brief. We've read a few of them on the channel in other coverage when we're not doing trial work, and different organizations that have an interest in the case or companies. Her company might have written the amicus with her being the writer for the company, saying we're interested in this case because of using this data, not using this data, what have you. We covered one by Mischief where they actually did connect the dots to the Supreme Court as a friend of the court on the topic of parity. So we've covered a few of those. And you have organizations or individuals that are interested in a case or an outcome of a case might impact them. And they say, I'm not here for the plaintiff defendant. I'm not here for the prosecution defendant. I'm here because this issue impacts me and matters. So amicus brief, not amica cream. But I get it.
And the prosecution is paying you for your services in this case, is that correct?
Yes.
And with regard to this case, you have been paid and have been on this case since May of 2023, correct?
That is correct.
With regard to the various reports that you have submitted in this case, you have mentioned one which is a report with regard to the iPhone of John O'Keefe. Is that correct?
That is correct.
And you have, in that report, you have made a statement,
you're welcome.
have you not, that from 12:20:50 a.m. on January 29th of 2022 and after, there is no indication of interaction with the device. Is that correct?
There is no indication of user interaction with the device. There is all received until about 6:04 a.m. when there is again Apple Health data that picks up.
I'll ask it again. And you can feel free to turn to page 1529 in that report.
1529.
Page 1529.
The report is.
Would you like the
50
page of the
pages.
report or the page NDA number at the bottom? I can do either
Oh,
way.
I'm sorry.
Oh, the bait
I'm sorry.
stamp
I thought
number.
you were saying page 15 in the report.
No. It's
I
NDAO
apologize.
1520.
She's like, it's a 50-page report. How are we getting to page 1529? I interpreted it the same way you did, Jet, with like, is it 1,500 pages long? Fuck. But there are bait stamps numbers and then report stamps numbers, and the bait stamp numbers would be for the entire case, not just for the report. Fair enough.
29 or page 7, whatever way.
Page 7. Okay, Roger.
Okay, so page 7, you see there's a heading interactive phone activity, correct?
Yes.
And at the top
Oh my
it
goodness.
says, using a variety of different artifacts, we can see active interaction with the mobile device up until 12:20.
Yeah, you have to
Slow down.
I have never heard Alessi talk that fast. Ever. I have never heard Alessi talk that quickly. Oh boy. He's just like, grrr. No wonder the court reporter yelled at him.
Report.
No. It's
I
NDAO
apologize.
1529 or page 7, whatever way.
Page 7. Okay, Roger.
Okay, so page 7, you see there's a heading interactive phone activity, correct?
Yes.
And at the top it says, using a variety of different artifacts, we can see active interaction with the mobile device up until 12:20.
Yeah, you have to
Slow down. Okay, sorry about that.
Breathe, Alessi, breathe.
I'm just trying to move it along, but I will be
Don't-
slower.
Just breathe,
I'll
dude.
repeat. Using a variety of different artifacts, we can see active interaction with the mobile device up until 12:20:50 a.m. ET. You see that statement?
Yes.
And then if you skip down, I'm going to skip a couple sentences to the paragraph under the chart, and this is the key part.
Skip a few.
Okay.
It says, from that point, and I'm understanding that point to be the 12:20:50 a.m., correct? You need to say yes or no, I'm sorry.
Yes.
There is no indication of interaction with the device. Did I read that correctly?
That is correct.
So I am going to, and you believe that statement is correct?
Until 6 something a.m.
No, I'm sorry. I'm just asking if that statement is correct. Not if you have other information, but is that statement correct?
I object.
Can you answer that?
The statement is correct that there is no other interaction with the phone until 6, whatever it is, a.m.
Did I read that correctly?
You read it correctly.
Continue to read
If
that
we
correctly.
could, Your Honor, have a document that is put up already in evidence and publish Exhibit 39. And it will be, thank you. And if we could go to slide 82, please. And Ms. Hyde, if I could draw your attention to the entry that is, it says.
Just to orient, because A, I've paused as I'm going to. But B, we are talking about John O'Keefe's phone, and that orientation got lost a little in how quickly Alessi was running through that, because now we are getting to a different report with John O'Keefe's data. She is saying the last user interaction with the phone in her report was 12:20:50 a.m. And now we are getting into the other data from John O'Keefe's phone. And this is showing the health data. And it looks like a device unlock with Face ID at 12:32:04, which is exactly what he wants to get into, and is probably why he is speaking at 1,000,000 miles a minute, because 12:20 and 12:32 are significantly different things. And if John O'Keefe's not unlocking his device with his face, who was unlocking his device with his face? Right.
3209 under app lock, but we know that the 00 is a 12. So it's 12:32:09 a.m. on January 29, 2022. And I'm going to read what it says in red, and this is a timeline of Mr. Whiffen. You know Mr. Whiffen?
I do know Mr. Whiffen.
And so he put in red, not us, he said device locked with lock button for the last time. Do you see that?
12:32.
I do.
And you know that to lock a phone, you actually have to hit the side button with regard to an iPhone to make it lock. Do you know that?
Yes, sir.
Oh, we got a tech
and that
timeline
is an
issue.
interaction with a phone, is it not?
I concur.
So that means that that interaction with the phone occurred at 12:32:09, correct?
I did not review that specific artifact. I cannot attest to Mr. Whiffen's exam, only to my own.
So do you have any reason to believe that what is in evidence in this case that Mr. Whiffen
He sounds pissed.
has produced, and that do you have any basis to contest the fact that the device was locked with a lock button for the last time on the phone of John O'Keefe at 12:32:09 as you sit here?
I cannot contest it because I do not recall looking at that specific artifact.
Don't you think it would have been appropriate
I don't know
to
what
be
she was
accurate
asked to do.
as a digital forensic analyzer on the topic of the last of an indication of interaction with the device? Don't you think it would have been appropriate to look at that 12:32:09 in any of the tools you said you used on direct?
I did not correlate that artifact in my timeline.
I understand you did, and
So
my
no.
question is, you make a statement. Well, let me back up. Do you understand that in this case, as in many cases,
She might not.
that matters of seconds in activity can be determinative of a case? Do you understand that from your experience?
Absolutely.
So it's important, therefore, to get activity right in any for.
I like this witness a lot. I do not love when we get into the absolutely's. You know how I feel about it. When we get into the absolutely's that are kind of like, don't try me. I do not love the demeanor change on cross. I do not love it. I do not love it. And once we get to absolutely, I don't love the absolutely's. I don't. I want to know what she was asked to determine. That's what I'm interested in. But the demeanor is just like, oh, now everybody's pissed in court. Okay.
For any data forensic examiner when they're issuing reports about activity, particularly of a decedent. Is that important?
Absolutely.
So isn't it correct that the statement that you make on page 7 of your report, that from
She's
that
just
point,
like, bring it.
12:20:50, there is no indication of interaction with the device, is incorrect?
I cannot make that without going back and reviewing and validating the artifact you just produced from Mr. Whiffen. I would need to validate that in order to respond to that.
But as you sit here, you have no basis to contest what Mr. Whiffen has stated, that there was a lock button on the side of the phone of Mr. O'Keefe a full 12 minutes after you say there was no interaction with the device. Is that correct?
I don't. I would have to review that portion.
Is there anything that had prevented you from reviewing that
Oh, that's a
in
good
that
question.
data before you wrote this report?
Not that I can think of. I would have to go and re-review that.
My question is,
I don't know if that artifact, I have not reviewed that artifact, so I cannot speak to an artifact I have not reviewed, and I did not, that is not my report, that's Mr. Whithen's report, so I cannot speak to that without going back and reviewing that evidence.
The next question is, so your review of the phone is incomplete. That's the next question. So your review is incomplete. Okay.
the interaction with the device, a lock button, readily available to you in the data that you have and had in your possession when you wrote this report?
Yes.
Thank you.
So she could have reviewed it and didn't. The question is why. We'll see if it comes back on
If you could please
redirect. She
turn
does
to,
look mad.
in the same report, page...
Go in the chat said she looks personally offended, like she feels like she's being attacked. Cross-examination very much feels like you're being attacked. It is the job of experts to overcome that. I think we will, well, go back and watch the Brennan versus Arca voir dire. It is part of being an expert, is to be cross-examined vigorously and to withstand it. And so that is your job. Not everybody would want to be an expert witness. Not everybody would like the way they're going to be questioned on cross, but it is your job as a neutral expert to answer the questions you're asked. And then you also have to trust the lawyer that brought you to court to ask the proper questions on redirect. And a lot of experts have a very hard time trusting the attorneys. It's different in civil a little, but trusting the attorneys to do a proper redirect, especially in criminal, because they don't have a lot of time with their attorneys, and they, not their attorneys, but the attorneys that hire them, and they don't know them well. In civil, experts tend to have more time to work with individuals than prosecutors would. So it's definitely not for everybody. It's definitely not for everybody. That girl who says things, how can Brennan fix this mistake? I don't know if there's a mistake to fix or if the scope of what she was asked to review is narrower. Was her scope narrower? He said, did anything prevent you from looking at it? She said no. So what was the scope of what she was asked to do? And why didn't she look at it? We'll see. Maybe it's just because she didn't look at it. And that is something that can go to her credibility to the jury. Oh, so you didn't look at it all. But you have to trust the other attorney to ask the right questions. And you have to trust that they're going to ask the right questions for the case, not necessarily for you to defend yourself, because it's not about you, which is miserable if you're sitting there as someone who's proud of your work, if you can't explain. So her report says the last user interaction was at 12:20, and Whiffen's report says that the phone was locked with the locked button and face unlocked at 12:32. That's a big differential. It's a big differential.
1528, which is your page number 6.
I'm curious to see where the rest of this cross goes, because
And I
that
just
is
want you, please,
12 minutes, I think, is a big difference.
Go to the, just put a placeholder in that. And if you could now just go to the conclusion, which is your page 50.
Missy said using two Commonwealth witnesses against each other. 100%. 100% to undermine the reports of both.
Let me know when you're there.
I'm there.
So in the conclusion, you state that starting at 12:01 a.m. on January 29, 2022, the mobile phone was in use with activity of Waze navigating to 34 Fairview Drive, Canton, MA, active interaction with the screen, steps audio playing text messages and calls until 12:31 a.m. EST on January 29, 2002. Did I read that correctly?
Yes.
You continue to read that correctly, Mr. Alessi. I'm just going to say it
That
every time because
statement
it
is
brings
also
me joy.
incorrect, isn't it?
On what basis?
Do you believe that statement is correct or incorrect?
She believes it's correct, obviously.
I believe that the statement is correct regarding those artifacts that are mentioned in that statement, yes.
Okay, if you could please, if you could turn to page 1535 of the same report.
Can you give me my page number, please?
I will.
Okay, thank you.
You're welcome. If you could turn to your page 13.
13, Roger. Yes, I'm there.
And do you see an entry that says 12:31:56, which is the same time in the conclusion, but I'm going to develop it.
I believe I know where you're going.
Hold on. I'm sorry. I need to ask the
apologize.
questions. I appreciate you looking to help, but if I could, I'd appreciate it.
Absolutely.
Thank you. So it's got health steps, and it has steps.
Ma'am, he's not being friendly. He's not being friendly. Just let him develop it.
36, duration 20.9 or 20.398 seconds. Did I read that correctly?
That is absolutely correct.
So if you
read that correctly.
Look at this data point in your report on page 13. The steps began at 12:31:56, but they ended 20.39 seconds later at 12:32:16. Is that correct?
That is correct.
So therefore, your statement in your
It's cross-exam, ma'am. You don't get to explain. It's the worst thing when you're an expert and you're like, but I can explain. And they're like, you don't get to explain. I get to ask yes, no questions. I'm in charge now, Phasma. And then we'll see if the prosecutor can let you explain or remember to let you explain. But I get to ask a bunch of yes, no questions. And then we get to get back. She's like, yes, but nope. 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 Nope.
Your conclusion, if you could go back to 50, and this is in your conclusion, your statement there is that the steps, the mobile phone is used with activity, including steps, until 12:31 a.m. EST.
Alessi, just let the sirens pass.
That should read until 12:32:16, correct?
It depends on your interpretation of interaction. As a user is walking, they're not actively interacting with their device. It's their movement that is. It's not direct interaction with the screen. But I would agree to your view that that could be interpreted as needing an additional 20 seconds.
Isn't the more correct way to state the conclusion that the active interaction when it comes to steps is not calibrating using the screen, but the phone is calculating steps taken. Isn't that correct?
That is correct, but that's not interactivity with the device.
I understand,
Yes.
but the sentence reads includes steps, and the more accurate way to have stated that would have been to put 12:32:16 instead of 12:31 a.m., correct?
I'm
She
sorry,
disagrees
you just
that it's
said
more
12:30.
accurate.
I did this to the minute, not to the second. Could you rephrase what you were stating?
Well, I'll state it again.
I appreciate that.
You're welcome. So isn't the more correct way to state this important
She's not gonna
data
agree to
point
that.
in your conclusion, instead of saying active interaction with the screen and steps, etc., until 12:31 a.m. EST, the 12:31 should be 12:32 because the steps that you have on your page 13, by what you concede, is the duration of 20 would have brought it to 12:32:16, correct?
I would state that depends. I believe either is a correct way to state that. Based on interactivity, based on your interpretation, your definition is more correct.
Okay, thank you. And it's not my interpretation. I'm reading from your report, correct?
Your interpretation
Of
that
interaction.
1232 is a more correct representation of interaction is based on your theory that interaction concludes when the steps end. And I'm saying both would be acceptable.
Okay, so let's follow up on this.
She expresses it differently.
Isn't it correct that it isn't my theory when the steps ended?
Oh, it's
if I
agree.
could just finish,
Please,
because if
absolutely,
we
sorry.
talk
Ma'am!
over each other, the stenographer's not going to get both of us. Thank
Agreed.
you.
And she's going to get mad at everyone.
It's not my theory. It's just the simple math from an entry you've made on page 13 that the steps began at 12:31:56. They ended 20.398 seconds after that, which just doing the simple math is 12:32:16. Did I do the math correct?
would
That
need
is
paper.
correct.
Okay,
I'm not
thank you.
debating that.
Thank you very much. So now what I'd like to do
I would need paper.
is to go to page 15.
Mother of Bagel said, is this how
28
nerds
of
fight?
your report.
Yes. Also the neurospicy, because at my house, we have to define everything. It's like, well, what is your definition of better? Like, how would you define better when we're talking about Limp Bizkit versus Ice Nine Kills versus Metallica? Like, how are we defining better? Like, what does that word even? Yes. Yes. And so she's like, the way you are saying interactivity and the way I'm using interactivity are different. So we need to define how we are talking about interactivity first, and then we need to back up and then talk about it. Yeah, you got to define the things. Rex88 asked, who won the fight, EDB? It is an ongoing debate. But at the end of the day, music is all good. Our family has our ranking of the order of performances that we enjoyed. So it was a long conversation with Travis, and it expanded to some of his classmates that were also at the Metallica show. But let's continue with how we define interaction with the phone. And I understand her point. Her point is interaction with the phone is user interaction, like when you're feeding your Snorlax or merging things. But he is saying, but interactivity with the phone and the phone having interaction is the steps from your step data with the phone writing onto the phone. And she's saying, but that's not user input, so she didn't consider that to be interaction. And we're talking about John
Do you have my
O'Keefe's
page
phone
number for that?
still.
I'm sorry.
Yes, and I appreciate that you go page number, so I just center in on the lower one, then I'll go immediately to the one. So it's your page 6, Ms. Hyde.
Thank you.
You're welcome. Just let me know when you're there.
I'm there.
If you could please go to Apple Health Data Steps.
Mm-hmm.
And we've been talking about steps because they're important enough that you put them in a report, correct?
That is correct.
So let's go to an important data point, therefore, in your report, in the chart, which is the second entry, which is, as you've stated, 12:21:10 a.m. Do you see that?
I do.
And you note,
It's so rude
under
that
the
none of us
data
have the report.
that
Like, they're all reading from the same page, and the jury and all of us are just sitting here going, y'all are reading off the same page, and the rest of us can't see what you're talking about. It is so frustrating. Like, all of us are just trying to listen, and they are both reading off the same page, which just goes way over everybody's head.
John O'Keefe's phone registered 80 steps at 12:21:10. Did I read that correctly?
You did read that correctly.
And those 80 steps constituted 191.253 seconds, as you state, correct?
That is what is stored in that database, correct?
And
You continue
is
to
my
read
math
correctly.
correct? So that the jury understands this perhaps a little better.
Sure.
That 191.253 seconds equals 3.2 minutes,
Approximately, yes.
approximately.
I'm doing the math in my head, so that's why I said approximately.
Right. Understood. So am I reading this entry correct that you're stating what the data shows, that 80 steps were taken by the phone, whomever had the phone of Mr. O'Keefe? There were 80 steps taken at 12:21:10 a.m. on January 29, 2022, for a length of time of 3.2 minutes.
That is what the phone registered.
That's what the phone registered. Very well. Now what I'd like to do
She won't say that's
is
how long
to-
somebody was taking steps because you can't know if they were taking steps for 3 minutes. That's how the phone registered it. We know that the phone, well, she can't know how accurately the phone registers it because nobody knows how Apple does the things that they do. But anyone that plays Pokemon Go knows that things are not always registered accurately depending. So the phone registered this versus that's how long someone was walking is actually a big difference especially for a tech expert. Like saying John O'Keefe did this with the phone, a user did this with the phone. She can't prove whose hand was holding the phone.
Turn to the phone of Jennifer McCabe.
Okay.
And
We
that
moved on from John
is,
O'Keefe's phone. Okay.
For your reports,
Where did we go with
you
that? There was
don't
no
date your
landing.
report,
Did
so
we
I
land
can't
the ship?
give you a date, but it
I know,
says
it's report 3, I believe, is what.
exactly.
Where did we
It's
land?
3.
What?
And there is. Bear with me. I'm accommodating your page.
I'm trying to bear
reference,
with you,
and I'll
Alessi, but
have
did
it
we
soon
land the
for
plane
you.
on
It
John's
is
phone's
your page
stuff?
7, and let me know when you are there.
I am there.
Are
Okay,
you
to Jen McCabe's
aware
phone.
of an issue regarding the time of an interactive phone activity on Jennifer McCabe's phone at 5:07 a.m.? Are you aware of that issue, and particularly a communication to a person named Coco? Are you aware of that?
I would need to check in my report. May I turn to the page for
Absolutely.
that time?
And
I
if
do
it
see
is-
an outgoing call to someone labeled Coco at 5:07:21 a.m.
And you can tell that because in your report on page 11, you list a 5:07:21 a.m. call to a Coco as outgoing, correct?
Correct.
Have you discussed that call with any member of the Commonwealth?
No.
And again, this call is at 5:07 a.m. on January
5:07:20?
29th of 2022, correct?
5:07,
correct.
21 a.m. An outgoing call to Coco.
There is no duration listed for that call. And if you just follow my questions, if you can, yes or no. Is that correct? There's no duration yet listed.
Correct.
So what I want to do is to also note
Chat. Coco is Jen McCabe's sister, Nicole Albert, who lives at 34 Fairview. So this was after Karen Reed called Jen McCabe. There is a 5:07 a.m. call to Coco at 34 Fairview with no duration. Jen was asked about it. Jen was like, I don't know what you're talking about. I didn't talk to my sister. All roads point back to all the phone calls.
that omission is not the only omission of durations from this report, or I'll state it differently, let me withdraw that. There is no population of the duration column for any call from 14:30 a.m. on January 29, 2022, all the way through this 5:07:21 call, and you don't start listing durations until 8:59:34 a.m. Is that correct?
I know why. It's the overwriting that she was just talking about. I want to see if I'm right.
Yes, and explainable. The artifact.
I understand
Yes,
Mr.
okay.
Brennan can
Sure.
handle those on his redirect.
Absolutely.
So there's not a population of duration of calls after numerous early
No durations.
calls and phone, as you call it, interactive phone activity. Nothing populated in this report until 8:59:34. That's correct?
Yes.
All right. Now what I'd like to do is to turn to the 22740 artifact that was the subject of much discussion on direct. And I am going to refer to that as an artifact. Is that a parlance that is familiar to you?
Yes.
And if I refer to that as a timestamp.
Chat, yes. No go Glen Coco is a brilliant comment. So thank you, Angie Girl, for pointing it out, because I am very curious to hear about how you see the calls and why the duration is not there. I'm so curious.
Also, is that a parlance that's familiar to you?
Absolutely.
So I can refer to 22740 as a timestamp, and you would find that parlance acceptable?
Yes.
Thank you. So I'm going to do that. Just to keep it simple, I'm going to refer to it as a timestamp. Now, you've been on this case working for the Commonwealth since May of 2023, correct?
May 4th, 2023. That is correct.
So you've been on this case for 2 years, correct?
It's a year ahead of the first
the entire
trial.
time.
But you started on this case in May 2023. You issued a report in May of 2023, correct?
Correct.
You issued a report in December of 2024, correct?
Correct, after being rehired in November.
Right. And you issued more reports in 2025, correct?
That is correct.
So all of that activity has been on this case, correct?
All on this case, that
and
is
that's
correct.
been all on behalf of the prosecution, correct?
That is correct.
None of that work has been done on behalf of the defense, correct?
That is correct.
So let us now go to...
No, Alessi, the chat needs to go to parlance, parsnip, parsley, parlay. They want to get to parlay. They want to get to parlay, Alessi.
The timestamp of 22740. Your opinions on what is the meaning of that timestamp have varied from May of 2023 until today. Is that correct?
No, that is incorrect.
Let's cover that issue.
Sure.
Let's turn to your May 2023.
Well, her face also has subtitles. So,
isn't it correct that
she's like,
the
absolutely
report,
not, without saying absolutely
your
not.
findings were pursuant to a request from Detective Lieutenant Brian Tully?
Correct.
And how many interactions have you had with Lieutenant Detective Brian Tully on this case approximately?
I really don't know. I'd have to go look back at email and call logs.
Is it more than 5?
Yes.
Is it more than 10?
Yes.
Is it more than 20?
I don't know.
So somewhere between 10 and 20, would that be fair?
Again, I'd have to review my call logs. I'm not going to test.
But it was more than 10?
More than 10, I'm sure.
So
wait, do you still have your call logs?
The issue
that would be helpful to know.
Your use of various forensic tools that revealed a timestamp, 2:27:40 a.m. timestamp on January 29, 2022. Is that correct? Is that a fair characterization of an issue you looked at?
Correct.
So if you could go to page 5 of that report. And I would ask that you go to the last paragraph that starts with "in the instance of the Google search," and let me know when you're there.
I'm there.
So it reads, "In the instance of the Google search, house long to die in cold, that was recovered from the write-ahead log associated with the X-Browser State DB SQLite database with the timestamp of 2:27:40 a.m. was marked by Celebrite as having this timestamp and being deleted." Did I read that correctly?
Fair. Yes.
So you use the words that Google search, "house long to die in cold," was associated with the timestamp of 2:27:40 a.m. Isn't that what your words are in this report?
In that database, they are associated. That is correct.
Right. And in terms of page 3, if you could go back, of your report, under relevant findings. It starts with, there were 2 searches of interest that took place on the iOS device, and we're talking about Jennifer McCabe's device, correct?
The device that was identified to me as Jennifer McCabe's, yes.
That's identified to you as Jennifer McCabe.
Okay.
And it's what you talked about on direct examination as her device, right?
Yes.
It's not a mystery as to whose it is. It's not like you don't know, right?
In direct, I also use the phrase identified to me as Jennifer McCabe's.
Right, but your conclusion is the device you've been working on and analyzing for 2 years is the device of Jennifer McCabe.
She can't confirm that. She was told that, and she's not going to say, I know that that's Jen McCabe's phone. She was told this is a forensic copy of Jen McCabe's phone. She can't tell you if that is Jen McCabe's phone or not. That's fair. She can't say that, and she's not going to. And she has said it was identified to me as such. Fine.
That is how it was identified to me.
Do you have a different conclusion as to whose device it is?
I
She made no
always am
conclusion.
very, very careful that I did not assess the ownership. That was information that was given to me, not information that I personally assessed.
So are you uncertain as to whether the device you've been working on for 2 years is the phone of Jennifer
device
McCabe?
that I've been working on for 2 years is the device that was identified to me by the Massachusetts State Police, Detective Tolley, as belonging to Jennifer McCabe when I began working and received that device, as stated in the evidence analyzed section on this same page.
So let's go, and we're talking about, again, to get back to the center of gravity, we're talking about a timestamp of 2:27:40 a.m., correct?
That is correct.
And when you issued your first report in May of 2023, the timestamp you were looking at was 2:27:40 a.m., January 29, correct?
I was looking at multiple timestamps associated with the same 2 searches.
Right. So what I'd like to do, you said multiple timestamps. What times are in the multiple category?
What I was tasked to do was to look at the times, the search, the Google search history, I'm sorry, not Google search history, the Safari history, which includes Google searches, associated with those 2 search terms within that 12-hour period. That was the particular task, not the task of looking at the 227, just for clarity.
Right, and I appreciate that, but my question wasn't that. My question was, I thought I heard you on direct examination, which is why I repeated the question, what I thought I heard on direct, but I'll ask you the question.
Sure.
You looked at and talked about on direct 2 potential times for a Safari search, which includes Google, one of which was 2:27:40 and the other one was 6:23 a.m. Is that correct?
I analyzed the meaning of those 2 timestamps.
Right. So we're just talking about 2 times, 2:27:40 and then 6:23. Is that correct?
So you are only talking then about the one that we're also talking about 6:24 a.m.
Okay. So we
Eastern
got
time for clarity, because some of these records are in UTC, some are in local.
Fair enough. So you've
Fair
got
enough.
2:27:40. You've got 6:23 and you got 6:24 that you were looking at, correct?
There are other timestamps that exist in the realm of what I was looking at, but those ones, correct, are the ones that are relevant in this report.
Oh,
Exactly. And that's what we're talking about.
Okay,
We're just talking about this report.
Yes.
And so if you look under relevant findings, at the very bottom paragraph, you say, second sentence, a Google search for how long to die cold at approximately 11:23 a.m. and then how long TIDIE in cold took place at 11:24.
That is in UTC. I apologize for not having the timestamp format there, but that is the UTC time. The UTC time equivalent in Eastern local time would be 6:23 and 6:24.
So to be clear, in your report,
Are we going to be
you
clear?
wrote 11:23 a.m. and 11:24, and you didn't put UTC next
Correct.
to it, did
They
you?
should. You are correct. That should say UTC. That is a typo.
And there's a significant difference between 11:23 and 2:27:40, correct?
1123 is UTC, so its equivalent in Eastern Time would be 623. The artifact of 227 is already in local time, so that is in Eastern Time. So what we would be comparing is 227 and 623 and 624 to be appropriate.
Right.
Taking into account the data storage and which ones are in UTC and which ones are in local time.
I understand your explanation now.
Perfect.
But in this report, there is no UTC time down. You have 2 additional times in addition to the 2 times, 2 different numbers added to the 2, correct?
The UTC was a typo. It should say UTC next to those, and the chart shows all of those artifacts in EST and is clearly labeled that they're all in EST.
So you would agree that it's better stated to state it a different way than you have in your report?
I would say that both are equivalent. I should have had UTC there. But yes, it's easier for the audience to speak in EST. I would say forensics examiners typically communicate in UTC, but we translate for our reports. And I should have either communicated that in EST or included UTC. I will definitely contend that.
So
she said
in terms of...
She said overall the chart has them all converted to EST, and the underlying narrative does not have them all converted. Okay?
Your May...
Either way, the jury doesn't know what they're looking at because the jury can't see it.
Report, your first report in this matter.
Yes.
You, on page 5, in the sentence underneath the block paragraph, state, in the instance of the Google search, house long to die in cold that was recovered from the right-ahead log associated with.
The jury will not have this report.
The ex-browser state with a timestamp of 2027:40 a.m. was marked by Celebrite as having this timestamp and being deleted. Did I read that correctly?
You read that correctly.
Now let's move ahead to page 7 of your report.
Which is why not showing them as they're talking about this just gets confusing.
Conclusion. Importantly, at this time, you state, testing shows great inconsistency with timestamps parsed from this file. It is, however, definitive that the page existed in a tab.
Correct.
While a definitive reason as to why the timestamp is listing the time of 2:27:40 is unknown,
okay,
the time is inconsistent with the timestamps associated with the same search. Did I read that correctly?
You did read it correctly.
So as of May 2023, you said the definitive reason as to why the timestamp is listed as 2:27:40 is unknown, correct? I'm just asking, is that what you wrote? Unknown.
I believe that the wording here is, sorry, I know I do use the word unknown. It says, while a definitive reason as to why the timestamp listing is the time of 02/27:40 is unknown. Sorry.
While
so
a definitive.
Use the word unknown, your word in your report.
Yes.
Okay.
Modified by
now
definitive.
What I'd like to do is to go on to the first proceeding in this matter. Do you remember
He left
giving
out the definitive part.
testimony in a proceeding about a year ago under oath?
Yes, I do.
I am now going to go to that testimony, and if at any point you would like to have a copy of that, if it's the honor, if Your Honor would like, I will do it, but I'm going to start and then we'll see how it goes.
You don't just read it in though. Are you going, did it differentiate?
So, bear with me a moment. Do you recall in that testimony stating that you processed the image in several forensic tools. I use Celebrite Physical Analyzer, and then you list many other tools. You remember giving that testimony?
We have a page.
I'm sorry, Mr. Brennan, I thought I'd given it 1-12.
Yeah, page.
My
and
apologies if I
site.
didn't. It's June 14, 2024, page 1-12.
She testified to that here
You're welcome.
too, though.
So, do you recall giving testimony about the various tools you used for this timestamp?
I do.
And do you recall stating that those tools were commonly used digital forensic tools that are very standard? Do you recall that?
I'd have to see the wording that I used at that exact time.
Would it be helpful to refresh your recollection if I showed you that?
It would be great. I would greatly appreciate that because I do not recall the precise wording, but I know that I
Fair
spoke to the
enough. I'll
tools
get
I
that for
used.
you. May I approach, Your Honor?
Yes, Mr. Alessi,
You should have a
offered
copy.
transcript. Do you have the whole
I have
transcript?
the whole transcript if that helps.
It might speed things along.
Agreed.
Okay.
We have one.
Everyone agrees that it would speed things along.
Thank you. I appreciate it.
So, may I approach, Your Honor?
Yes.
Thank you. Mr. Brennan?
Is that, let me turn it over to you. It's going to be 112. Okay. Yep. You're welcome.
Thank you so much. And you said we're on 112?
Yes, please.
Okay.
113, I see it. I see it's highlighted on the copy, so I
Right,
figured
so
that's the
what I
one.
wanted to do, the reason I
Okay.
said 112 is that's where I
Oh,
started with my
sorry.
previous question. So I'm not going to repeat the question, but just to orient you, so you have a fair context for the questioning.
Fair.
So I started at the bottom, 112, now I'm moving to 113, and I'm starting with line 7. Do you see that?
I do.
And it says, yes, they are commonly used digital forensic tools that are very standard for other forensic examiners to use on mobile exploitation. Did I read that correctly?
That is correct.
And then if you go down to line 22, you testified in that proceeding, so it's important to use multiple tools so you can see the results from different data sets, and be able to compare those results and enhance those with manual analysis. Did I read that correctly?
You did. That's correct.
And then going up to page 114, line 5.
Slow down a little bit, Mr. Alessi.
I will, Your Honor. Thank you. Yeah, that's very, very typical for me to process with multiple tools to
Which she
ensure
did
that
here.
I'm getting.
Was that in May of 2020?
I hate it when the feed jumps. She used multiple tools here as well, so I'm not quite sure where we're going with that line of questioning, but the feed has also had enough, it seems, with this line of questioning. So let's, which I wonder if, or I wonder why, but that was not user error on my part. It's, for those of you feeling lost, the questioning in this cross at this point is confusing. We will see where the plane lands when we get there, but it is confusing. I'm going to have to refresh this real quick. Apologies, chat. It's going to take me. It is going to take me a moment to get back to where we were in cross, or a close proximity to it, because I need to get us to where the transcript is, and we have not gotten there yet.
Mr. Alessi.
I will, Your Honor. Thank you.
All right. I think we're here with Mr. Alessi being told to slow down, because that's where we're at. I think we got back to where we needed to be, or at least I hope so. So we'll see. I think that is pretty close. I'm going to just back that up a little bit more. Okay.
Repeat the question, but just to orient
The questioning is confusing.
so you have a fair context for the questioning.
Fair.
So I started at the bottom, 112. Now I'm moving to 113, and I'm starting with line 7. Do you see that?
I do.
And it says, yes, they are commonly used digital forensic tools that are very standard for other forensic examiners to use on mobile exploitation. Did I read that correctly?
That is correct.
And then if you go down to line 22, You testified in that proceeding. So it's important to use multiple tools so you can see the results from different data sets, and be able to compare those results and enhance those with manual analysis. Did I read that correctly?
You did, that's correct.
And then going up to
Continue
page
to read that
114, line 5.
Slow down a little bit, Mr. Alessi.
I will, Your
Exactly
Honor.
where we
Thank you.
were.
Yeah, that's very, very typical for me to process
we
with
going with
multiple
this, though?
tools to ensure that I'm getting the most complete interpretation from forensic tools. Of course, you go beyond that with your analysis, but it's absolutely pertinent to that. Did I read that correctly?
That is correct.
And then lastly, for this section at page 114, 17, the Sanderson tool is meant to look at specific type of data structures called the SQLite database. XQLite databases are very nuanced, and this particular tool allows you to take that database and explore it at a deeper level than the other forensic tools allow. Did I read that correctly?
Yes, you did.
Thank you. Now if we can go to page 124 of the very same testimony.
Okay.
And feel free to go back a page just so you can see to page 123 that the topic
What
is
are we
the
doing?
2740 timestamp associated with how long to die in cold. Do you
Can I
see?
have a moment just to review and get context?
Absolutely.
Thank you so much.
Page 123, 13, but if you need to go back further, feel free.
Okay, I'm good. Thank you.
You're welcome. So what I want to do is start with page 1-23, and this is your testimony. On line 16, I have them in the timestamp order that is associated with the artifact. You use that word associated again, correct? Did I read that
Correct.
correctly?
Yes.
And that's associated with the Google search, how long to die in cold, in a 2:27:40 a.m. timestamp, correct?
That is correct.
Now if you turn the page of the testimony, you state back then that on page 124, line 1, the browser state DB is an artifact that speaks to when tabs are moved. So when you're using your browser and you open different tabs, you may have a search that this time pertains to the time that the tab moved. It could be lots of things. Did I read
Correct.
that correctly?
You did.
Not one thing, you said it could be lots of things, correct?
That is correct.
And then you go on in line 10.
I'm going to start singing
And you
Doofenshmirtz
talk
in a
more,
minute,
and then you go
Alessi.
down to the bottom. You go down to line 20, and you testified, we cannot tell by this particular artifact what time that search occurred. Did
Absolutely.
I read that correctly?
That particular artifact.
Pertaining to that particular artifact that give in browser state DB, that does not tell us what time a search occurred. That is correct.
Right. So you stated, and it was your statement then, we cannot tell by this particular artifact what time that search occurred, correct?
That particular artifact.
Correct.
Okay, so now let's...
Correct. So yes, correct.
Let's
correct.
keep
Correct.
going.
From that particular artifact. Are we going to get to a different particular artifact?
If you go to page 129 of this transcript.
I'm there.
At the top.
Sure.
Line 1. 227 isn't necessarily one time when the tab was closed. That's in my report. I say it's undetermined. Remember we were just reading your undetermined
Absolutely.
in your May 23 report?
Correct.
Because there's a lot of things that can cause that timestamp to be there, including tab being moved, tab being
Which
minimized.
she said.
The next sentence. I don't know exactly what caused the tab to get that particular entry, but it's not, that timestamp is not indicative of the time of the search or any URL that's visited. But the first part of it is, I don't know exactly what caused the tab to get that particular
Right.
entry. Did I read that correctly?
You read 100% correctly.
Thank you. Now, if we could turn to page 130
And that's
of your
what
testimony.
she said. Now it's the same testimony though. He's just like, it's not impeachment. I'm surprised actually the prosecution didn't object sooner, because he's reading in. It's not impeachment because it's consistent with what she said this time. And what she said this time was, it could be the tab moving. It could be the tab closing. There are multiple actions that can be taken with the tab that can cause that. But that's the same thing that she testified to. Did the testimony come in clearer this trial? I think so. But it's not, at this point, we're not getting to the impeachment, but we could be getting to the foundation of where the issue is. So there at sidebar, let's continue on, because we've got a long way to go and a short time to get there. So.
Thank you for your patience, Ms. Hyde.
Absolutely, sir.
What I'd like to do is to go back to your testimony in the first proceeding, and we can go back to page 1-30.
Okay.
I am there.
Thank you. So I am going to go back just because there's been some time and give some context. So we're talking about the 2:27:40 a.m. timestamp, correct?
We are, Jagger. We are eastbound and down and loaded up in
We've
trucking.
been talking about that for several pages. Yes, that's correct.
Ma'am.
You're absolutely correct. We've been talking about it for several pages. And bear with me. I think this may be either the second to last or the last. So there you testified with regard, this was when you're referring to an artifact. You've agreed that timestamp is a fair synonym. You say on line 5, that means it wasn't in the regular database, it was in the write-ahead log. And to Celebrite's credit, that tool actually parsed the write-ahead log and displayed it where the other tools did not. So did I read that correctly, number one?
You read it correctly.
So am I correct that here what you're stating is Celebrite was actually showing the 2:27:40
he's getting snarky, she's getting snarky. They're both getting
at that
snarky.
time during your testimony in the first
On
proceeding.
that date, that is correct,
Okay,
yes.
so I just wanted to establish that, and you were
Absolutely.
giving Celebrite credit
Pam, she
for
said
actually
227 is the tab movement on direct. That's what she said. But he's trying to get to something else with that.
showing that timestamp at that time of 2:27:40 at the time of your
She's like,
testimony
yes,
back
and.
in
Yes,
June
and.
of 2024,
Yes,
correct?
and.
That is correct.
Okay, so now let's go to
Her opinion didn't change
page
yet. I mean,
1-36.
we're not done with cross.
136, you said?
136, yes.
Thank you.
We're like, yes, and.
on line 12, you note that so Celebrite and Magnet Axiom, and then you elaborate, both Celebrite Physical Analyzer, which is a specific tool, right, of
Correct.
Celebrite, and Magnet Axiom, another specific tool, correct?
Correct.
Both have file system viewers that then have SQLite database viewers. And you, skipping down to line 17, you talk about they don't allow for deep analysis of the write-ahead logs, which is why in my analysis I use the specialized Sanderson forensic browser for SQLite, correct? I read
That
that
is correct.
So is it fair to say that what you did up to this point in June of 2024, with regard to the 2:27:40 a.m. timestamp on January 29, 2022, you applied a variety of tools to analyze the issue of when did the Google search occur that you use the words associated with a Safari Google search, house long to die in the cold?
There's a little bit of wording I would correct there, if that's okay.
Right, but so let me see if I can ask the question
That'd be great.
a different, more simple way.
Thank you.
You're welcome. So you used a variety of tools to analyze that house long to die in the cold
Yes.
search, correct?
Plus manual analysis and testing, yes.
Plus manual analysis and testing. Alrighty, now let's
Yes.
leave the testimony
Okay.
and let's go to your next report. And your next report is December 2024. Do I have,
I have
the
it correct.
chronology correct, Ms. Hyde?
That is correct.
So in December of 2024, just approximately 6 months ago, you issued another report, correct?
That is correct.
And you got the request for that report also from the Norfolk District Attorneys, correct?
That is correct.
Monica, I'm
And
still with
you
y'all.
state,
My iced coffee hasn't kicked in, and we're
in regard. Well, that report
repasturating.
regarded the analysis of the same timestamp, correct?
Correct.
To 22740 timestamp. And in that report,
Aggressively
under
repastorating.
relevant findings, you state, and this is December of 2024, so it's
And the
from
reason
your
it's
May
so difficult to
2023
follow is
report,
because they are jumping
it's-
around in the reports that they are both looking at and the transcripts they are both looking at. No one else is looking at them. I mean, all the other lawyers are, but the jury is trying to catch up with them too. And we are all not on the same page at this point because it is jumping around. This will either be tied together at the end of cross or it will be tied together in closing. At this point, he's getting the questions he wants to get in, but it is difficult to follow.
approximately a year and a year and a half. Is that approximately from your May 23rd report? Approximately a year and a half?
Yes.
So a year and a half after what we just reviewed in your May 23rd report, and then just months after the testimony of June, right? So about 6 months after your
6 months later.
June testimony that we just went through, you went and looked at this issue again, correct?
That is correct.
And
That's,
isn't it correct
I think, where we're getting.
that when you were asked to look at the same timestamp in December of 2024, that Celebrite removed the timestamp from their...
Alessi, is this your point? Because we've been around and around and around on this, and Celebrite removing it is a well-known point at this point. Alessi, is Celebrite removed it? Yes, and
Celebrite did remove that timestamp from the tool. That is correct.
Okay. And that timestamp was the subject of extensive reports and testimony that you participated in the first proceeding, correct?
That is correct.
and the other
And
tools
even
still
though
show it.
That timestamp, 22740 AM,
Also, it removed it from the way it's expressed in the report, but the artifact is still there, and the artifact is still highlighted by other tools.
showed up in Celebrite tools, Magnet Forensic Axiom showed up. That was removed by Celebrite, correct?
Celebrite no longer reports it. The evidence is still in the data. I want to be clear, just that it doesn't change the data. They just removed it from their automated parsing and reporting.
Right, so they
Correct.
removed it from their automated parsing and reporting, correct?
Yes, they did.
Correct.
That is correct.
We do know this.
However, your
It's still
former
an
company,
axiom.
Magnet Forensic Axiom still shows it.
Magnet Axiom Forensics currently shows it as a carved artifact and still shows that and gives a description in their artifact reference guide as to what they believe causes that artifact.
I'm going to ask the question.
Yes, it does.
Magnet Axiom Forensic,
where you used to be the director of forensics,
That is correct.
still shows that timestamp.
Yes, yes,
But Celebrate
She's like,
doesn't in the automated
that is correct.
tools.
That is correct in their automated parsing.
And you would agree
he's like, the language, the way that he's phrasing his questions and the thing that he's getting to aren't matching. Like the Celebrate removed it is very dramatic, but the answer is very clear. And Whiffen, I don't think, explained this as well. She has explained better that it is now expressed differently by the different companies, which she talked about on direct as well. Okay.
that Magnet Forensics is a very reputable company, correct?
Correct.
Where she used to be the director. And Whiffen also said the same thing. Whiffen, who works for Celebrate, she who worked for Axiom, Whiffen said Axiom is a very respectable company.
Let's go back to
They show the
your
artifact
December
different.
2024
And she is
report.
saying, yes,
Do you
Axiom
recall
shows it, but
just
differently.
moments ago when we
So they
went
have
through your testimony?
tech experts from both companies, and both companies express that artifact differently.
In June of 2024, in the first proceeding,
I think the reason she's answering with the tone she's answering in is because some of his questioning tone is getting into almost sing-song. Alessi, what are you doing? I don't understand. Just sir, you could have just led with that. You reevaluated this data in December 2024, didn't you? Yes. And when you reevaluated that data, the Celebrate report did not show the 227. Maybe put it up on the board, the former Celebrate report. It doesn't show this anymore, does it? No. So Celebrate changed between the first time you ran the report and the second time you ran the report, correct? Correct. But when you run it with Axiom, it still shows, correct? Correct. So Celebrate removed it between the first report and the second report, correct? Correct.
do you recall just moments ago when we went through your testimony in June of 2024
It's time to gift memberships.
in the first
It's just
proceeding
time.
where you stated various times how it was, I'll use the term best practices, to use multiple tools to analyze the timestamp?
Correct.
Memberships. We're going to do this in a couple rounds, you guys.
used many tools back then to analyze that timestamp. And you testified to those many tools on your direct examination, correct?
Correct. Yes.
And today as
However,
well. Many
In
tools.
December of 2024, when you returned to analyze the 22740 timestamp, how many tools did you use to analyze that timestamp? Can you give me just a number? How many tools?
At least 4.
Well, in your report, let's go to your report, what your report says. So in your report,
Don't worry, we'll do some
you
more in a bit.
state that under relevant findings, do you not, that review of data from Celebrite shows that the artifact of a Google search from a Safari suspended state
Mods, I'm sorry for breaking our slow
tab
mode.
with the search term
Welcome,
"House
new
long
members.
to die in cold," and I'm going to skip over. In addition to
That's
my
gotta be a
own
water
previous
bottle, right?
report, no longer shows a last visited timestamp.
I think that is not clear. The skipping there makes it sound like my report no longer shows that, and that's not what's being
That's
stated.
a fair statement. That's a fair statement. Let me rephrase it
Thank
this
you.
way. You're welcome.
She's like, no. Celebrate changed
In
their
this
shit. I didn't change.
report-
She's like, I didn't change my shit. Celebrate changed their shit. My shit didn't change. She's like, my shit did not change. Their shit changed.
You speak about Celebrate release reports, correct?
Are you referring to the Celebrate release notes
The
that come out?
release notes at the bottom,
Perfect.
right? You
Yeah.
referred to that?
Oh God,
That's
we're not
correct.
getting to
And-
release notes, are we?
That release note
Does anyone read them on the
states that
updates?
Celebrate has removed the
I feel like I should,
timestamp
but I just
value
don't.
from records, and I'm assuming that's a reference to Celebrate's.
Celebrate no longer parses that result. That is the statement in this report. Correct.
Right. And so I'm going to go to page 4 of your report,
For sure.
parsley,
I'm there.
And
parsnip,
I'm going to go
parsing,
down
parlance.
all the way down to the conclusion. In that report, is there reference to any company other than Celebrate in this entire report?
Which
In
report?
this report, no.
Okay, thank you.
Ma'am, you have to just hold the rest of that
Now
answer.
let's go to
You can the rest of the answer. You can see it trying to escape. She's like,
your
in this report,
prior
no, but.
testimony in the first proceeding, where you said that it was important to use multiple tools.
Absolutely.
Do you still stand
love
by
that all of you guys read
your
the
position that you've
release
given
notes.
today and that you gave in June, that it's important to use multiple tools?
Absolutely.
Now let's go back to
I need an
the
absolutely and an
issue
absolutely not
of
flag.
The extraction of Jen McCabe's phone.
Oh, okay. It's important to use multiple
And
tools.
what I want to do is to
Sometimes a
cover
girl needs
a
variety.
concept
I'm here
and
for
see
it.
if I've got this correctly. Are you familiar with the phrase Apple source codes?
I'm sorry, can you please repeat?
No worries, sir. Are you familiar
Ma'am.
with the phrase Apple source codes?
Apple's source code? Absolutely, yes.
I don't know who's coughing.
And isn't it a fact that
But she has
Apple
leaned forward a few times to
keeps its
hear him,
source codes
which is fair.
proprietary, meaning very few people have access to it?
That's correct. It is closed source is the term we would use.
Closed source.
That would be the term of art, correct?
And they keep it so close that they call it closed source.
And it's not just Apple. Lots of tools are closed source. That just means that the code isn't available like it would be for the tool I
Unix.
mentioned earlier, iLeap. That's an open source tool. Anyone can look at the code. For Apple, we cannot go look at the code that
Stick to the
makes your
code!
phone run. That's correct.
And isn't it the case, and I referred to that as the MB postulate. It's a shorthanded, but I don't need to have you
The what?
refer to it that way.
I'm sorry, could you repeat that phrase? I was unfamiliar with it.
I'm going to skip it.
Okay,
I'll
thank
just
you.
go on. Basically, the concept that Apple has source codes that are closed sources. So I just refer to them as Apple's closed source.
Proprietary. They're just proprietary.
Wouldn't the best information about when a search occurred, what it's associated
Come
with,
from the source code?
wouldn't
Probably.
the best information be in the Apple source code to answer that question?
It is acceptable in digital forensic science and in accordance with the NIST Science Foundation papers to conduct testing to determine how the functionality of something works. You do not need access to the source code to be able to speak to an artifact.
My question isn't that. My question is,
You don't
isn't
need-
the best place, the best place to go is to the Apple source codes themselves, or are you saying these physical analyzer tools are just as good, and the information they pull is just as good as an Apple source code?
Those are very, very, those are incongruent statements. Apple's source code is not a healthy way to do an examination because it would be so onerous, and we do not know the level of documentation, we don't know the language. That is not necessarily the most effective way to determine what data is. Forensics tools parse results of how data is. They don't interpret them. The examiner interprets them and provides meaning. And I would like to state that those three things should not be conflated. They are very individual concepts.
I think you misunderstood my question.
I probably did it because that's what I was seeing.
My question is this. Isn't the
She's
best
like, I can't tell you if the best source is the source code because nobody has seen the source code. So we don't know what's in the source code for me to tell you what's the best source because we haven't seen the source code. So if I can't see the source code, I can't tell you if the best place to get this information is the source code because I haven't seen it. It would be an assumption. And forensic analysts tend to not like to assume. And if they assume, they tend to give you a million reasons why they are making an assumption or not an assumption. But we don't know what's in the source code because we've never seen it. So we can't tell you if the Apple source code would be the best source of information because we just don't know. So he's going to fight with her over Apple source code. Okay.
Source for information about data in an iPhone contained within Apple source codes?
Not necessarily. Because that doesn't perform, operational performance is a better source in a practical sense to being able to determine what something is, as opposed to zillions, and no, I don't know the number because it's closed source, lines of code that may or may not have different levels of documentation. Apple themselves wouldn't be able to, any individual there who has access wouldn't know every feature of how every element works. Testing through the methodologies described in NIST is the accepted methodology in our science, not reviewing the source code.
I'm going to try it a different way. I understand what you're saying is, if I got it correct, you correct me. Are you saying
The thing is, the defense expert's going to come in and discuss this, and the defense expert also doesn't have access to the Apple source code. I wish he would just ask her, but wouldn't you love to see it? Like, but wouldn't you want to see the Apple source code? Like, if you could. Like, if you could see the Apple source code, wouldn't you have a better understanding of how iPhones register steps or how iPhones save information? Like, could the Apple source code hypothetically provide clearer information about when a Safari tab moves? Is that possible? Maybe go to the hypotheticals. Maybe not. Because the jury at this point doesn't give a fuck about the Apple source code. And maybe they're like half the chat going, are we talking about applesauce? Is it time to go back to lunch because I'm tired?
that these physical tools make it easier to interpret and view the data?
I did not speak about the tools at all in the statement I just made.
Okay.
I spoke about manual testing and checking the functionality and what results. Parse tools, again, these are three separate concepts. The concept of code and actually reviewing code to make a determination is different from parse tool results, is different from doing testing and validation. Those are separate concepts. They should not be
conflated,
commingled as if they equate to each other.
So have you ever learned
She's like apples, oranges, bicycle.
Mr. Whiffen? Ian Whiffen?
I have spoken with Mr. Whiffen historically, but not since the term of this trial.
Okay. Have you ever spoken to Mr. Whiffen about whether the Apple source codes are the best source of information about topics like timestamps? Have you ever
Ma'am, if you say, why would I, I'm going to lose my mind.
spoken? That's just a
I have
question.
not had
Have
that
you ever talked to him?
conversation with Mr. Whiffen, no.
Okay, already. I want to move on to, and do you regard Mr. Whiffen as a reputable?
Mr. Whiffen is a reputable forensics examiner, and I've actually reviewed his work in other instances and peer-reviewed his papers.
So you have regard for his
I have
reputation?
regard for his
I'm sorry,
reputation.
we have to wait for each other
Oh,
to
yes,
talk.
I'm
through the
sorry.
trend. It's all right. no
Forensic
worries.
Examiner Love
So
Fest
you
when?
regard,
Right
have regard
now.
for the opinions of Mr. Whiffen generally, correct?
Absolutely,
And
yes.
you believe he has a solid reputation, correct?
Absolutely, that is correct.
Now let's turn to the...
Ma'am, does he have a big reputation? Big reputation. I was waiting for there to be moments in this cross where we got to 200 calls and the timestamps, which I think were a very good point. But now we're having a love fest with Ian Whiffen, and I'm just... They keep talking over each other.
History DB database.
Exhausted.
You are familiar with History DB? History DB, are you familiar with that phrase?
I am familiar with that phrase.
Okay. Do any of the house-long searches
Kalo, I
appear
love
in
lots
the
of different
History
kinds of music.
DB?
In this instance, no, we do not have artifacts in the history DB of either of those two searches.
So I want
Okay.
to just repeat that in a different way. So
Objection asked and answered. It's just me being
the
sassy.
History DB, is that considered a valid and valuable source of information in an iPhone?
That is a valuable artifact for Safari history. That is correct.
But the house-long searches we've been discussing do not appear in that History DB, do they?
That is correct.
That's a good question.
You spoke about PYF.
How did it take so long to
PDF
get there?
on your direct testimony? Do you recall that?
I do. It's the Python framework for PDF. It is a GitHub tool, a tool one can download from GitHub to utilize to create PDFs using Python code. So a developer and a tool would integrate that to create a PDF.
And the PYF PDF can have the variables set, correct?
Yes, the Python script allows the developer to set things such as their name that they created the document. Yes.
Chad, I see the request to Zoom. It's
wanna go
important
to
testimony,
the
though
extraction
sometimes
of Jen McCabe's
expert testimony can be
talked about on direct
wandering in the
examination.
woods without a map.
Is the hash
And
value
no keg party.
signed or unsigned?
A hash value isn't signed. I believe your question you're asking me is if
Let him
the
finish.
Adobe document that contained, the PDF that contained the hash values, are you asking me if that's signed? Because a hash value is something that matches. A hash value isn't signed.
Let me ask it this way. Is there any hash value associated with Jen McCabe's phone that is unsigned?
That is not a valid question. I apologize. We don't refer to hash values as being signed or unsigned. We would refer to the PDF that
Just say yes or
contains that
no.
value as being signed or unsigned.
Don't try to help.
Have you ever read a report?
Just say yes or no,
of Mr.
ma'am.
Ian
Don't try to
Griffin,
help. She
in
404'd the question. Question invalid. The PDF was not signed. The hash value's hashed. You have conflated. But don't try to help. I feel like she's trying to help. But that question is invalid is just the most forensic examiner thing to say. It's just
this case.
I have, but I have to be clear. I have not read all of Ian's reports. I've only read some, so I don't know if I read some of his earlier reports.
Do you recall reading a report of Mr. Whiffen where he references a hash value being unsigned associated with the
She would need to see the
iPhone
exact
of
words.
Jennifer McCabe?
Can I see said report so I can validate if I did or did not? I'm not sure based on just that because I wouldn't use the term hash value being signed. I did see a report in which Mr. Whiffen spoke to the PDF not being signed.
There's no more question pending.
I just want to try to shortcut this and
Nope.
work off your last statement.
Not
You're
gonna
now
work.
saying you do recall seeing a report of Mr. Whiffen where he said a PDF was unsigned?
I need to see, I do remember him referencing the PDF. I would need to see the report, especially since the characterization of hash value being unsigned is not a term of art that I am familiar with in our field.
Let me ask if you agree or disagree with this statement. This value can be used to compare with the original hash calculated at the time of extraction in order to validate
What's
the
this
extraction
value?
data. However, this requires authentication of the original hash value, which is not possible with gray key extractions, as the PDF containing the extraction hash value is unsigned. Therefore, this hash value could be used as a suggestion of authentication, but cannot be guaranteed 100%. Do you agree or disagree with
His
that
statement there says the PDF is unsigned, not that the hash value is unsigned.
Right, but it's nonetheless unsigned, correct?
The PDF is not signed. That is a correct statement. Gray key PDFs that purport that value are not an Adobe signed document.
Do you know the history of the
We are saying the same thing
extraction
17
of
different
Jen
ways.
McCabe's phone? It's a yes or no.
Can you provide more clarity? What do you mean? Do you mean from the time the image was made? Do you mean from the time the device was received? Because I don't know the information pertaining to the receipt of the device into evidence, and then when I only have the documentation of the image forward. So I want to be clear about what period we're talking about.
It's an excellent point, and I am going to follow up with some questions.
Okay.
He's like, can you
In
just answer my
extraction,
questions?
Doesn't the
His
extraction
questions-
from a phone start with the raw data, raw image?
Have gotten
Can you tell me
wandering.
when someone brings a phone in, what's the first
That's the
step
thing.
that gets taken in order to do a full file extraction? What's the first step?
It depends. There's
She
got to be
doesn't
steps
extract the
with
phones.
regard to network isolation. I need to know if the device is AFU or BFU at that point. So I don't have that information from this case if that is the question. I get from the image forward.
No. Don't anticipate the question. Don't anticipate what the question is. Answer it or don't. Just answer it or don't. Don't help. Helping doesn't help. Helping isn't helping. She is trying to help him ask a better question. It is not helping at
What
all.
I'd like to do, and this may be my
And then at some
last
point, she's going to
section of
text speak
questioning.
at him over the level of
I'd
where
like
he's
you
at.
to describe the ideal situation. is
She's
to
going to say,
getting
I don't
the
have enough
most
information.
Reliable
'cause she
data
doesn't have the
from
most
an
information.
iPhone from the start.
Experts are
What's the most reliable way to do it?
I would say the most reliable way is following the recently released SWIG-DE Scientific Working Group on Digital Evidence document on best practices of evidence handling, preservation, and imaging. I may have that title slightly out of order, but it is
Fair
the
enough.
document released this January.
And tell me what that is.
Sure. In that, the first thing, from which point are we starting? Are we starting like extracting the data using a tool, or are we talking on scene,
Putting it in a Faraday bag.
taking the
Where are we?
device into evidence?
The latter.
Okay. So the first thing you're going to do is you're going to ensure that you are isolating the device. This is also going to depend on condition from the network. So typically this would be done
Airplane
with a
mode,
Faraday
Faraday
enclosure
bag.
in a best practice. However, there are alternative ways of isolating from the network, such as disabling all of the communication protocols, such as Wi-Fi, airplane mode, etc. The next step, once you've isolated, but prior to, you also want to make sure you're continuing battery stat. So if a device is on, you want to keep it powered on. If it's off, you want to keep it powered off. That's a general statement. So the best way to do that is to attach a battery charger. Just like when your battery runs low, you plug in a charger in the back of these battery packs. We do that with that before we put it in the Faraday bag. A Faraday bag is an enclosure that blocks signals from coming to the device. This is so a remote wipe command couldn't be sent, or so that more data isn't received to the phone, because phones are live and constantly obtaining data. So we're going to have it
They're
with a
spying on
battery
you.
pack in the Faraday, presuming
Get
it
that
was on. Again, I
6-digit
don't know
passcode.
the status of this device. The next steps are going to depend on what state that device is, and what make and model that device is, and what the current support for that device is. There are multiple types of extraction methods of phones.
What's the hardest
In
one to
modern
extract?
day
We all
on
want to go
iOS,
shopping.
A full file system image, what we had on the devices in question.
I don't know
in
why
this
Alessi's
case
just letting her
is
run.
considered the gold standard because it has the most.
I think he's trying to turn this witness into his witness and be like, she said a whole bunch of stuff, the experty expert, and law enforcement did none of it. Okay. Sure. How should this be done? This. How was it done in this case? Not this. The thing is, that witness just testified. And if that witness just testified, they didn't ask that witness any of this, so does it matter? She's just
robust information.
gonna just run with it.
So at this point, the next question is what's the best image type? And that's going to depend on if we have a passcode or if we don't have a passcode.
If I could,
Please.
and I'm going to allow you to continue.
Yeah, please.
I want to break it down for the jury.
He's like, she's like, you asked me to go through all the steps. I can literally sit here for 45 minutes and go through all the steps. If you would like to start getting like CLEs for it, we can do that. I can go through all the steps. That's what you asked me to go through the steps, and now I'm going through the steps.
So what I now want to do, you've stopped at a certain point, but you've talked about securing, what I would call securing the phone, right? And then making sure that there's no data swiped. You talked about airplane mode, Faraday bag, Faraday box, right? Do you
Step
know
one,
whether any of those
cut a hole in the
protocols
box.
were
Step
followed
two.
for either the iPhone of Jen McCabe or John O'Keefe?
as I mentioned, I was not there for those processes. I don't have documentation of it. As mentioned, what started where my receipt of the device is from the image.
She's like, I don't know what the fuck they did.
You don't
That's
know.
the point.
I can't testify to processes I did not or was not available or aware of.
Fair enough. But do you have a little bit of hint as to whether the phone of Mr. John O'Keefe
whiff
was
of it?
properly secured in airplane mode,
Do you have a hint
Faraday
about a phone?
bag, or a Faraday box, based upon your own report of the iPhone of John McCabe? Can you determine
Of John
that
McCabe?
from
John
page 5 of your report?
Obviously, there is data signals that are still being made and created. I believe that is what you're referring to. So the assumption is that I don't know at which point a Faraday bag is employed, but I also want to be clear, I don't know when, I don't have information outside of the digital forensics realm about this case, so I don't know precisely when the phone was taken into custody by law enforcement.
Fair enough. So assume that Mr. O'Keefe
Sir, I'm a forensic examiner. I'm not assuming. She looked like she wanted to throw up in her mouth when he said assume. Just ask a hypothetical.
was deceased
She doesn't know that.
around the latest 9 a.m. on January 29th, 2022. Isn't there activity on that phone, health data activity, up to around noon of January 29th?
Health data activity would continue to be reported regardless of if the device was isolated from the network or not. Health data has to do with the movement of the device, so if the device was being moved even within a Faraday bag, that data would still be populated.
How about location data?
Location data is unlikely to be reported in a device that is Faraday enclosed, but I do not know what location data you're referring to, so I cannot speak in absolutes without having a better reference to the artifacts in question. If you're saying it's in my report, I'll look at it, but again, I never knew when the phone was seized, so it was not part of my initial analysis. Do I have permission to look at that time, Nick? Yes. Thank you, Your Honor.
She just was like, Alessi, we don't need you. Let me talk to the judge.
Bear with me. It's a big report, as you know.
It is a big report.
We like
And it was at the bottom of my stack.
big reports.
Pardon me?
All right. It was at the bottom of my stack. I had to lift up the other ones to find it. All right. So
Your Honor, may I assist and point her to a page?
That'd be
Thank
great.
you. If you could turn to that report on your
Are
page.
Is there a contestation
47,
about
and
John O'Keefe's
continue
phone that we
on
don't know about
to
yet?
Page 50.
I do see incoming data that is consistent with the device not being Faradayed, such as the receipt of SMS messages, notifications from Ring, etc.
So, the iPhone of Mr. O'Keefe.
Are we going to just ask law enforcement? Because they're going to testify. Is this contested?
Not secured in the manner you described before we got to this, as would be the best practice with regard to getting the most accurate data from a phone. That is, once it comes in, that it's to either be put in airplane mode, a Faraday bag, or a Faraday box. Is that correct? By your own report, you see activity.
I do see activity. It was not Faradayed. Faraday prevents wiping of the device and additional data. So we actually, in this instance, it doesn't appear that the device was at risk of wipe because it was not wiped. And we actually have more data because we get to see the data that continue to come into the device. I'm not saying that's in accordance with best practice. I'm saying that that's what I see based off of what you just had me review in the data.
It sounds like you're trying to justify.
Oh, I'm not
if
trying to
right or
justify.
wrong, you tell me. It sounds like you're trying to
It's a good
justify
question.
the fact it wasn't secured. Am I correct? Or
No, you're incorrect. I'm just stating we have, you asked if we had more data or less data. We actually have more data with it not being Faradayed. But no, best practice would be to Faraday.
That
I
wasn't my
100%
question.
agree.
My question wasn't, is there more or less data? My question was simply, doesn't your own report
Sure.
show activity up until noon on January 29, 2022?
Correct. And for clarity, my scope was till noon, so I don't know if there was activity beyond that.
Right, but as far as your scope goes, I want to be clear.
Yeah.
There is activity on
Absolutely.
this phone.
Absolutely. The
Which
phone,
shows that it was
Let him
not
finish.
put in airplane mode, it was not put in a Faraday bag, and it was not put in a Faraday
That's the
box.
point.
And that failure is not best practice.
correct. It is not in accordance
Thank
with
you.
the best practices. I agree. I would have Faradayed it.
Thank you. So
If I, presuming.
that's okay.
No questions.
I have no further questions. Thank you for answering my questions, Ms. Hyde.
Thank you for your questions. Have a great day.
What?
Brennan, redirect.
Thank you.
That's the end of cross? Okay. Brennan, it looks like, waited until Alessi got back to his seat. I think, well, that was painful. There were a few very good points at cross, and then there were points where we just got lost in the sauce of that cross. And I think he got very lost in the sauce about the search of Jen McCabe's phone. And I'm surprised he didn't ask more about the 200 phone calls. But we've learned something that has not shocked me today. Did it shock all of you? That law enforcement did not do much to secure John O'Keefe's phone. Right. I'm not shocked by that at all. We still haven't heard from the officer that took John O'Keefe's phone from Carrie and then what they did with it. We have no idea what happened to John O'Keefe's phone after about 6. What time does, I don't remember what time he gets transported, but Carrie has his phone and gives it to law enforcement after 6 o'clock in the morning when they are all at 34 Fairview. So from 6 o'clock till after noon, and then whenever it's finally put into digital forensics, we don't know yet what happened. Okay. Okay.
Of course.
Whenever you're ready.
Thank you, Mr. Chairman.
You're welcome. You were asked when you began working on analyzing phones in this case, and you said it was in May. Was that of May of 2023?
May of 2023. May 4th, 2023 is the email I have of a note. Thank you. Yes. It's easy to remember because May the 4th be with you.
When you first were asked to begin work on this case in May of 2023,
One of us. Ma'am, 100% may the 4th be with you. Brennan's like, what the fuck are you talking about? She laughed at her own joke. 100% may the 4th be with May the 4th be with you. I like that she's laughing at her own joke and Brennan is like, the fuck? Oh my God. No one was going to ask her how you remember it's May the 4th. So she was going to tell you. I think the helpful part of that cross was when she showed user input stopping on O'Keefe's iPhone and when Whiffen shows it, and those being at different times. But we didn't loop back around to that. And I'm wondering if Brennan will get back to it. But yes, the court officer with the great glasses also looks like she's chuckling. I'm here for it. I'm going to back that up because it was funny. I loved it. 10 out of 10 no notes. 10 out of 10 no notes. So we're going to run that back again. I'll allow it because, oh boy.
Whenever you're ready.
Oh boy.
you're welcome.
And I want to watch Brennan's face respond. Oh, thank you, Lana.
You were
You
asked when
binged.
you began working on analyzing phones in this case, and you said it was in May. Was that of May of 2023?
May of 2023. May 4th, 2023 is The email I have of a note. Thank you. Yes. It's easy to remember because May the 4th be with you.
When you first were asked to begin work on this case in May of 2023,
She laughed at her own joke for sure.
what was the catalyst for you to begin working on this?
I was contacted by Mr. Tully and then contracted, a SOW was signed, and I began work on the initial request to look at those two search terms on January 29th. Does that answer your question?
Sure.
Okay.
Was there a certain claim that was lodged that you were to focus on?
I was to focus on the two search terms from January 29th, 2022.
And were you informed why? Was there any context to that?
I don't know if you're going a place you can go with that.
Probably.
Brennan.
I don't recall the exact conversation that I had with the DA's office and Lieutenant Tully at that time, but
I'm very curious to see if he starts to tread into the area I think he's going to tread into, but it is a tread carefully, Brennan. The way he said claims.
I'm assuming that I was given that context. I have in my notes that I was to look at those two searches on that date and do an analysis about those.
Were you asked to reach any particular result?
No, I was asked to provide my report, not to reach a particular result.
Were you asked to reach a conclusion that the 227 timestamp was inaccurate?
No.
When you engaged in your analysis, was it independent of
Probably
the district
asked to
attorney's office?
explain.
My analysis was independent of the district attorney's office. I actually, in the first case, had very little communication with the district attorney's office during the period of my analysis.
Was there any input from any outside source on what your result or ultimate opinions would be?
No.
Would you ever allow anybody to affect your input?
No.
I believe her 100%, and I think the jury probably does too.
Throughout the course of your efforts with this phone, have there been changes to software?
Absolutely. As mentioned on direct, software updates are near monthly.
I want to ask you about changes to the Celebrite software. You were asked about certain reports you wrote. Were the reports that you wrote relative to different requests for analysis?
Yes.
The report regarding report number 3, regarding changes to Celebrite software, was that report limited to the timestamp change, or was it to include other efforts?
The scope of that report, may I review what I have documented as the
Please.
scope? I believe we're talking about report 2. That's the one about the Celebrate change.
Yes.
And I have the request was to understand changes made in the newer version of Celebrate Physical Analyzer to artifacts pertaining to the timeline of a particular Google search on January 29, 2022, namely how's long to die in cold.
Okay.
When you looked at the Celebrite software and report, was the timestamp characterization changed or removed?
Yes, it was removed. That timestamp in the version starting in May of 2024, Celebrite actually removed that, and they put a release note stating that it was due to the ambiguity and potential for misconstruing the meaning of that data.
Was there any other releases informing other reasons why that was changed other than the potential that somebody could misconstrue, misinterpret, or distort the information?
It's kind of leading and
Can
compound.
I read Celebrite's own statement?
Please.
It's kind of leading and
Celebrite's
compound.
statement in
Yeah.
Yourself.
to myself? Okay, roger that. Thank you. I appreciate that.
The question's just objectionable. Why are we not just objecting to the question?
Can you
Could
repeat the
share with
question?
us, was there any reason other than the concern about misinterpreting or distorting?
They said that
So what's your understanding?
my understanding is that it is not a reliable timestamp, and that is why Celebrite removed it.
You were asked about
That's
Axiom.
the answer he wanted.
Axiom, is it the same or different?
Magnet Axiom and Celebrite Physical
Yes,
Analyzer
Roger.
are two different tools.
I'm
that
disappointed
both
it
do
wasn't
forensic
Roger,
analysis
Roger.
of mobile phones.
You were asked whether Axiom still has a timestamp that was similar to Celebrite before the change.
Axiom shows what I spoke to on direct, where they have it as a parsed versus carved result. And so that particular result shows in the suspended state DB artifact as carved.
Do companies like Axiom and Celebrite give releases,
Parsed versus
updates,
carved.
information about how to interpret their reports?
So Axiom actually has a document that's released with it called the Artifact Reference Guide, and that actually gives a brief description of the fields and of artifacts.
this.
All tools, when they release new artifacts, they put out in a release notes. Not all artifacts are clearly documented that are parsed. However, all of the vendors regularly put out webinars and blog posts that explain their new artifacts, but not necessarily all.
Is there any releases or cautions from Axiom on the same issue about misinterpreting a timestamp?
I appreciate that he asked about both.
Axiom, in their artifact reference guide for this artifact, does speak to the possibility of misinterpretation and states that the timestamp can be earlier than the search had occurred, based on what different reasons could cause that timestamp.
Let me ask you about a Faraday bag. You said that best practices is to isolate an item in a Faraday bag.
So what I'm hearing is
That's correct.
Do you
the
have,
software, both software that parse that particular artifact make a note that that artifact needs further investigation. It is not reflected on Celebrite reports any longer, and on the report from Axiom, there is a note in their reporting about it being carved. She explained that earlier. I've completely forgotten what carved means, but she explained it earlier. So all of the software says you need to, like, asterisk, look into this more. Okay.
have any information, or did you know the travel of Mr. O'Keefe's phone that night, or where it went after?
I'm sorry, can you clarify the time period?
On January 29, 2022, from, say, 6:04 in the morning until later that afternoon.
I did not have access to that information.
When you analyze data from certain devices, are they always placed in a Faraday bag immediately after an incident?
There's a lot of times when this is situation dependent.
They should be.
An example of when you would not put something in a Faraday bag is when you have a deceased victim and you're going to be using their biometrics to possibly unlock the device. Because a Faraday bag is enclosed and then can't be opened, if your intent, if you don't have the password, is to use a deceased person's fingerprint to unlock the phone, we don't want to put the person's finger in the Faraday bag, so usually those phones would not be Faradayed, but they would typically have airplane mode enabled or SIM card removed. But no, SIM card removed doesn't actually work on iOS, so I won't get into that.
Understanding or
Did it used to? Can we talk about removing SIM cards? Can we talk about removing SIM cards? Because we haven't gotten to removing SIM cards yet. Can we discuss removing SIM cards in the year of our Lord 2022, please? Can we get there? Can we get there, please? Can we get there, please? No,
having the
maybe
opinion
not.
that this item was not placed in a Faraday bag at 6:04 in the morning, does that in any way affect your opinions about the data that you analyzed on this phone and the conclusions
It's a good
that
question.
you reached regarding Mr. O'Keefe's phone?
It does not have any impact on the conclusions other than the fact that it wasn't Faradayed and more data came in. So we have additional data.
You were asked a very specific question about History DB, and it was simply whether or not How's Long to Die in Cold, whether it appeared in History DB. That isolated question, does that provide any context to you and your analysis and conclusions about How Long to Die in Cold and that it occurred at 6:23 and 6:24 the next morning?
The absence of the History DB artifact doesn't mean that that search didn't occur at that time. We have multiple corroborating artifacts, which is usually what we look for, 2 artifacts that demonstrate is like very good. You don't necessarily need that, But in this instance, we have both from the Mobile Safari plist, which tracks the history, as well as the Knowledge CDB. So we do have two artifacts showing that those searches were done at that time. Of course, 6 seconds apart for the difference between the Knowledge C and the Mobile Safari plist.
On direct examination, you were not asked questions about Mr. O'Keefe's phone.
That is
but
correct.
You were on cross-examination, so let me follow
That's
up.
correct.
You have a report that you authored regarding Mr. O'Keefe's phone,
That is correct.
and you had an opportunity to look at the healthcare data for January 29, 2022.
That is correct.
Page 6 of your report.
Thank you.
Okay.
You noted that there were steps that began at 12:11:09 a.m. Is that accurate?
That is accurate.
And the way healthcare data works, do you have an understanding whether steps means a person actually took a number of steps, or does it mean something else?
Steps doesn't necessarily mean that you took a
Health
number of
data.
steps. It's based on the motion of the device. So it could be steps. It could be you're carrying it. It could be that you're in some other kind of motion. You could be on a bicycle. You could any number of things. And the number of steps is
the jury hasn't heard from
based
Brian Albert
on
yet.
the presumed gait, based on the input into the Apple Health app in terms of gender and height. So it determines a gait and then prescribes a number of steps, but it is possible for other things to cause steps to occur.
You were asked specifically if you saw that there were reported movement or health steps at 12:21:10 a.m. and specifically pointed out to you notation or characterization of 80 steps. Is that accurate?
That is what's stored in the database. I try to clarify, as I did for you, sir, that that's what's stored in the database. I'm not saying that 80 steps were taken.
And by the way, in addition to the healthcare analysis, you did some
The database says 80
analysis
steps.
on the movement of a car, didn't you?
She did say
For Ms.
bicycle. She said bicycle.
I'm going to deny that question.
Yeah, it's
Can
leading.
these health steps occur if somebody's holding a phone while traveling in a car?
As mentioned in my report, it's caused by motion. It could be various motions that could cause it. You could be using an elliptical. You could be in a vehicle. You could be on a bicycle. It's not necessarily steps taken.
I mean, I object because when I treadmill, my Pokemon Go does not count my steps nearly adequately enough, and it is very frustrating.
Based on your analysis of Mr. O'Keefe's phone and the report that was pointed out to you
It's
in
so
cross-examination, and do you have
Let me hatch my
information or
eggs.
opinion where Mr. O'Keefe's phone was located?
And that was going back to
around
Whiffin's report.
12:21:10 while those steps registered?
Objection, Your Honor. Scope.
That's beyond the scope of the process.
It was pointed out to you at 12:21:10
The court-
there was a registration.
Sustained it by saying it's outside the scope of cross.
That is correct.
Okay. And then you were also asked about the last healthcare data, the last movements of this phone. And it was pointed out that that began at 12:31:56
healthcare
for
data.
20 seconds.
That's correct. Per the data in the database.
And is that the last movement of Mr. O'Keefe's phone that evening before 6:04 that you saw when you analyzed the entire data in the phone?
May I have one moment to review?
Yes.
He isn't asking directly what Alessi asked, so I think it's a little bit more confusing to clarify the difference between last user input on the phone and last.
That appears to be the
Health
last before the 6
data.
a.m. hour.
So that 20 seconds, if it began at 12:31:56, what was the last movement in seconds in time at that time of Mr. O'Keefe's phone?
I'm sorry, can you repeat?
Yeah,
Yes,
what?
if that was a 20-second interval at
That's correct.
12:31:56. What was the last second that evening that Mr. O'Keefe's phone moved?
12:32:16.
And then when you analyzed the phone and were asked about these times, is there any movement between that last movement and 6:04:01?
Between the 12:32?
Yes, 12:32:16.
He's
and
not asking about
6:04:01.
the
Any
phone
movement of that
locking,
phone
though.
whatsoever?
So He's not asking about the phone locking.
I do not have anything supporting that in my report.
Do you know what was going on with Mr. O'Keefe's phone at 6:04:01 a.m. on the morning of January 29, 2022?
I do not know precisely what was happening with his phone at that time in terms of movement. If that's, or are you asking me? I'm sorry. Can you clarify what
are you asking?
Mean
Yes.
by the question?
The next movement after 12:32
Is the 6:04.
6:04:01
Correct.
a.m.
Correct.
Do you have any information?
Let him
about
finish.
Where or why there was movement of the phone at that time?
No,
I don't. That wouldn't be inside my digital evidence. I don't believe.
And the last question is the next movement at 6:15:14. Do you know if that phone was being moved by somebody or somebody else than Mr. O'Keefe?
The phone was in motion. I do not know if it could be by a person. It could be on a rail car. I don't think it was on a rail car for clarity, but I don't know what is causing that motion at that time.
Thank you very much.
Oh, boy. And she can't know that. Right? The digital examiner cannot tell you what is causing the motion if the phone detects motion.
I have a moment, Your Honor.
It could be somebody else that grabs it. It could. Somebody could be throwing it around in their office to see if the screen lights up. They can't. They can't know that.
Ms. Hyde, you were asked questions by Mr. Brennan just moments ago about Celebrate and release notes. Do you recall those questions?
Yes.
And did Celebrate,
Recross.
beyond stating that their opinion was the 2:20:40 a.m. timestamp was not reliable, did they give any reason at all for why they concluded it was not reliable in that? I'm sorry, we'll wait for the...
Thank you. I appreciate it.
I appreciate
And I'll
it
repeat
too.
the question for you.
Thank you.
Oh my goodness. I'm going to zoom as best I can past all of that. Good Lord.
In that release note,
We're
does
back to
Celebrate
celebrate release notes.
state any reason for why they wrote not a reliable timestamp?
There are other
I'm
published,
sorry, my
but
question
not
is, do they
Celebrate?
state in the release note whether there's a reason for why they concluded?
May I look at the release note again? Thank you, ma'am. Thank you, Your Honor.
Please try not to talk.
I will,
Sorry, Your Honor.
The court wasn't talking to you, Alessi. The court was talking to the witness because in the middle of Alessi's question, the witness looked at the judge, I'm sure, because that's what she's done a few times, and said, may I look at the report? But Alessi hadn't finished talking yet. The court reporter has got to be like, please stop it. Question then answer.
Two.
Question then answer. That's it. Question then answer. That's all.
Not asking you to read it, just asking
No, I don't
whether or
think the
not
judge
they
was talking
give
to
any
Alessi. I think she was talking
reason
to the witness.
for the conclusion not a reliable timestamp.
One moment, I'd like to review what they wrote. Thank
Absolutely.
you.
You're welcome.
Yes, they do. They state that further research since is the reason that they're doing it, that there's further research.
Did they state what that research is?
They don't, but
All right, but they don't state what the
They don't
further
put-
research is.
that is correct. They
All right,
state
now
that
what I'd like
it's
to do is
unreliable.
move on to Axiom.
Mm-hmm.
You were asked questions by Attorney Brennan, and you referred to Axiom as using a different parlance with the timestamp of carved, correct?
Celebrate uses this deleted demarcation or recovered demarcation. Axiom does not do that at all. They speak to how they recovered the artifact, be it that it was parsed. When I say parsed, I mean the item was where it was expected to be in the algorithm, found it, located it, and said it's here, versus carved, which is when they have to go
She
into
described
an
it again. Thank
unexpected
God.
area, such as slack space, which would be the areas that are not yet used or were previously used to extract the data.
Her explanation is, and if I'm summarizing it correctly, at the end of this day, parsed is you found the artifact where you expect it to be. Carved is you find the artifact where not where you expect it to be elsewhere.
Data from that.
So Axiom actually recovers the timestamp, but
Well, they
Celebrite does not.
They
Is that
express
correct?
it.
Is that correct?
Yes.
Okay.
Currently, previously, when we did the first case.
Right, but
It's the
currently,
opposite.
Celebrite
Correct.
doesn't, but Axiom does. Axiom recovers 2:27:40 a.m., correct? Timestamp? They
That
recover.
is the timestamp that they show for that artifact. Correct.
Exactly. So now I'd like to go back to the next topic, our discussion about Mr. O'Keefe's phone and secured or not.
Chad, I have to ask. There are 42,000 of you in here, and we have been doing this for 700 years. With regard to the how's long Google search, how important is it to you that the way Celebrite shows their data changed? Is that the thing in all of this? Is that the thing that you're just like, well, there's that? I feel like that's not the thing. Whether or not Celebrite changed it, the artifact's still there. It shows this way, it shows that way. I feel like the thing is, was it Googled? Why was it Googled? When was it Googled? I don't give a shit what Celebrite says or doesn't say. I feel like Celebrite changing their report isn't the big deal. Everyone's making it a big deal. But I don't know if the Celebrite thing is a big deal. A lot of you don't think it's a big deal either, which is fair.
You talked about one example of,
and some of you say it
maybe needing
it's a big deal
to
because it shows that the
use
timestamp's
a
not reliable.
biometric
Fair.
to unlock a phone, and that might be a reason, as I understand it, as to why someone might not put it in a Faraday bag or box. Do I have that correct?
Correct.
Okay. Do you know whether the passcode was immediately provided on the phone of Mr. O'Keefe?
I do not have that information.
Assume that the passcode was immediately provided for the phone of Mr. O'Keefe. Can you think of any other reason why that phone wouldn't be put in airplane mode, Faraday bag, or Faraday box?
Best practice would be to put it in a Faraday bag.
Okay.
Sorry.
And that phone was obviously not put in airplane mode, Faraday box, or Faraday bag after 6:04 a.m. on January 29, 2022, correct?
Correct.
Now let's go to...
Well, I don't know if at some point past 12 o'clock.
Okay.
My report only goes to noon, so just for clarity, I don't know
Fair enough.
anything past noon.
Fair enough, but from 6:04 a.m.
Didn't look at anything past
until
noon. We're clear.
approximately noon
Correct.
on January
We're clear.
29, 2022, at least that time, that phone is not in airplane mode in a Faraday bag or a Faraday box, correct?
It would appear such. Because I didn't analyze past that, I don't know if it had been potentially Faradayed and then it broke Faraday and got data, but I don't suspect that based on this. It appears that that data was live. But I just have to speak to the fact that I just don't know because I didn't go past noon.
Right, but you're going past noon.
Right.
I'm not.
Okay,
My
yeah.
question,
6
and
a.m. to
I'm-
noon, it does not appear to be Faraday.
So to be clear, from 6:04 a.m. on January 29, 2022 until at least noon of January 29, 2022,
She's going to need to keep
the iPhone
apologizing to the court
of
reporter.
Mr. O'Keefe is not in airplane mode.
She keeps
It's not in a
over-talking
Faraday bag,
him.
and it's not a Faraday box, correct?
Unless it was in a broken Faraday bag, like they put it and it was failing. But it does not appear to have been placed in Faraday bag.
All right.
No, I'm just being honest. You should test your Faraday bags. They go bad. I use Dr. Katz's testing methodology, but 100%, it appears to have been receiving signal for that.
But can Dr. Katz's Faraday bag testing method track a cat? We've come back to tracking a cat. Can Dr. Katz's Faraday bag testing methodology track a cat? That's all I want to know at this point. I had no idea that Faraday bags go bad. I understand why she's apologizing now to the court reporter who is sitting right there next to her, because when they talk at the same time, you can't record two people talking, and it's been going on all of this testimony.
entire period and not in a Faraday bag, which would be best practice unless
don't know why
biometrics were needed.
So let's now go to.
I don't think it was in a Faraday bag. I don't think they secured it in that
Quickly, what are
way.
the last two categories?
I don't
of
think
questions?
anyone's shocked. I'm not surprised. Are we surprised? I'm not
With
surprised.
regard to the iPhone of Jen McCabe, do you have any knowledge as to whether over 200 calls were auto-deleted on her phone? You analyzed it.
Oh, the 200 calls. Yay.
We can see that calls were auto-deleted. You're asking me if the number of, I just want to make sure I understand the question. If the number of calls that were auto-deleted, if that exceeded 200?
My question is, do you know whether there was auto-deletions on Jen McCabe's phone? Do you know that?
I'm uncomfortable with the term auto-deletions because I don't know what that is inferring.
Okay. Did you analyze her phone at all for deletions?
I analyzed her phone to see if there had been deletions of call logs.
200 calls.
And what
200
I
calls.
found was that there were records that were removed by the system and not recoverable from that database, but were recoverable from biomes.
Understood. Now, what I'd like to do
So removed from
is
the
to address
system
your
and not
answer in response
recoverable
to Mr. Brennan's
except
questions,
in one area.
where you said that the
I guess auto-deleted is not a term of art.
issue with regard to Mr. O'Keefe's, or just generally your proposition, that there was no impact on your conclusion because more data had been obtained. Did I get that correct?
I believe my statement was there was no impact on my conclusion with the fact that it had not been in a Faraday.
Right. So isn't it, though, the case that when a phone's not in a Faraday and is therefore active, data can be overwritten?
Yes.
So if data can be overwritten when it's not in a Faraday, you can lose that data, correct?
Yes.
Is there data that we're concerned? Yes, theoretically. Yes.
Yes, just yes. Because Alessi is conflating two things. Jen McCabe's phone was never going to be in a Faraday because it was a consent search where she turned over her phone. The question I would really like to see Alessi ask is, let me get this straight. When you look at Jen McCabe's phone, you are telling me that from this point in time to this point in time, 3 days later, there were more than 200 calls. And at least this chunk of calls is gone. Do you know how many more than 200 calls? Because this chunk of calls is gone. Could it be 200? Could it be 230? Could it be 250? Could it be 300? How many calls? I would want to know more about how many. But we'll see.
You talked about, in response to Attorney Brennan, the 12/31/56 steps, and you said the last, according to you, last movement 12/32/16. Do you recall those questions?
I recall the questions.
Yeah. To boil it down, isn't correct that that phone was moving at that time?
May I check the timestamp again?
Absolutely.
I apologize. There's
Oh, no.
a lot of timestamps going back and forth.
Please do.
12/31/56? Is that
Yeah,
the?
that's the start. Yep.
Oh, yes, this one there definitely is. Yes.
So, doesn't matter what kind of movement, but that phone
is moving.
was moving starting at 12/31/56 and still moving until 12/32/16 a.m. on January
know if she's gonna agree to
29,
that.
2022, correct?
Yes.
Thank you.
Interesting.
Appreciate again you answering my questions.
Thank you.
All right, Ms. Hyde, you're all set.
Thank you, Your Honor.
Okay.
Counsel about scheduling? Honors, feel free to stand up and stretch.
Oh boy. Oh boy. That was at the end of Miss Hyde's testimony. There were points of the cross-examination that I just don't know where Attorney Alessi was going with his questions. We did not get into the 200 phone calls nearly as much as I had hoped that we would get into. We got a lot into whether or not multiple tools are used, and Alessi asked a lot of questions about Celebrite changing their reports so that their reports, if you are looking at the same artifact as in their reports prior to and during the last trial, those reports would have indicated a 227 timestamp. Those reports now would not indicate that same timestamp, though the Axiom reports would still reflect that same timestamp with an explanation. This witness explained the difference in those two. They had asked Ian Whiffen from Celebrite about that a bit, so that's not new information. It was just rehashed quite a lot in this conversation. Did we get all the way into the defense's theory of the 227 tab movement or Google search? No, we didn't. Did the defense lay foundation for what they will likely argue with their expert? I think so. We also saw them asking about whether or not John O'Keefe's phone was secured in their cross-examination. Was John O'Keefe's phone put in a Faraday bag? Was it put in airplane mode? Was information still coming in? And she said, yes, we still saw SMS messages and ring notifications coming into John O'Keefe's phone, and there's no indication that it was secured in a bag, excuse me, that it was secured in a Faraday bag that would block signal from coming into the phone and providing new information to the phone. So she said it does not look like this phone was secured in that way. We have not seen the law enforcement that secured John O'Keefe's phone after it was given to them by Carrie. We will see when that comes in, like when, if. Woo! That was a lot of a cross-examination, just a lot of a cross-examination. Let's see where the court goes after this witness is done. But at the end of the day, her testimony from before lunch, was it clarified a ton in cross-examination? I don't think it was clarified a ton in cross-examination. I don't think that her testimony differed when Alessi said, so you used multiple tools. Yes. So it is particularly undetermined as to which tab movement caused that timestamp, whether it was the tab being put into the background or the tab being opened or the tab coming into the foreground, which she didn't testify to as much in this case. She said tab movement and didn't define the type of movement, but I don't think that's inconsistent to say tab movement and not list all of those tab movements. So we will see if there are things from this cross that get to the defense's expert. What I thought was the most interesting part of cross at the beginning was when Alessi was asking about her report that said the last user interaction on John O'Keefe's phone was at 12:20, and he pulled up Ian Whiffen's report that showed that the phone of John O'Keefe was locked with a button click lock after 12:30 p.m. And I think the exact time was 12:32, and showed that after 12:20, there was a Face ID unlock of the phone. I thought that was very early on in cross, but I thought that was really one of the more interesting things in cross, that she said the last user interaction on the phone was at 12:20 in her report, but Ian Whiffen's report shows a Face ID unlock. Is that not a user interaction? So we will see. And that's, if I inverted PM and AM, that is after midnight. We'll just go with after midnight, but that is after midnight on 1/29/22. I thought that was the most important part of cross. It got lost in all of the conversations about Celebrite. I think the most effective cross may have been the 200 calls, Her report says that the user interaction on John's phone stops at 12:20. Whiffin's report says that it is well into 12:36 or 12:32, that 12-minute gap. Why is she not indicating Face ID as a user interaction? Why is she not indicating a button click as a user interaction? I think those are fair questions. And it didn't come up on redirect at all because I think the point got lost. Maybe it will come back around in closing or in other expert testimony. But I think locking a phone with the button, I don't know how you don't consider it a user interaction. And she said that she had that data and did not consider that data, which is also something I was curious to see followed up on redirect and did not get followed up on. Let's see where the court goes from here today. Where, if anywhere, are we going? Because right now we are at the only fan. But I think that cross could have been tightened to the things that are contradictory. And that timeline was contradictory. And I think John O'Keefe's phone not being secured, we will see come back up again with the defense. We're just not there yet. So I am just curious where, the prosecution has more clips. So I think we lost some of the important parts across in the rest of it, to the point where I almost forgot it until I was talking about it.
May I?
Yes.
Miguelina messaged me. Look, Team Baker, you guys, the mods, everyone, you guys, this trial, you have been crushing it. Miguelina messaged me in the group chat that the cat's out of the Faraday bag. Yes, the cat's out of the Faraday bag. He went with Dr. Katz's method for testing Faraday bags and then tracked across the dusting of snow. That's where it is. We have talked more about cats in this trial than I ever thought that we would. And now we're doing something different. But I'm with you, chat. A lot of you are saying I'm not over the 200 calls. Me either. I'm not over the 200 calls either.
I would like to play clip 15, please.
Clip. He's starting to sound like Dorinda. Clip. You guys will have to let me know how you interpret these clips. I think some of it's going to come down to how much you know about this case and not. It's hard to evaluate these clips in a vacuum. Katrina Bunny, that is a great question. Hold on, let me grab that real quick as I am taking a note on what date this is from, unless Miguelina sees it and grabs it, because I want to get to that question. Oh, it's going to get lost. Hold on. Miguelina, will you just type it in the chat? Thank you. I think how these clips are perceived may depend on how much about this case one knows. And I wonder if the jury's perception of the clips will change. But the question from Katrina Bunny, and I don't think I grabbed it, was how can they use unaired footage? The reason they can use unaired footage is because they requested it and it was turned over to them and they subpoenaed it. And two, because she said it. They are her words. Whether it was aired or not, it was the interview she gave. So the point is that she was speaking and it was recorded, not that it was aired to the public. Hopefully that helps. All right. This is from the ID series. Let's see what clip 15 is.
Absolutely more than Jen McCabe. Jen McCabe, it's me or her. Either I'm going down, Jen, or you are.
Can we just back up to the House of Cards analogy with all of this? Brennan, that was a really good use of clip. I'm not mad about it. It's going to depend on how the jury feels about Jen McCabe, but Brennan is going to use that to argue Karen Reed's team is pointing at Jen McCabe because Karen said, either you're going down or I am. Let's run that back and play it one more time.
Absolutely more than Jen McCabe. Jen McCabe, it's me or her. Either I'm going down, Jen, or you are.
So, folks, I talked to the lawyers briefly about scheduling at sidebar, and I'm told we're actually ahead of schedule. So with that, rather than beginning a witness who's probably going to take a while, we may as well let you go and enjoy the rest of this meeting.
Oh, I guess they're letting the jury go. Okay.
We're on schedule, ahead of schedule. We'll reevaluate that tomorrow night. You will see the lawyers at sidebar asking for those more parts. We can talk a little bit about scheduling. So same cautions, please. Do not discuss this case with anyone. Don't do any independent research or investigation into this case. If you happen to see, hear, or read anything about this case, please disregard it and let us know. And be very careful with the social media use. We'll see you tomorrow morning. Thank you.
All rise for the court, please. Close and open to follow me.
That is a good time for the prosecution to use that clip after all the conversation about the Google search, because it will feed into their argument that the defense is just trying to throw this on everybody but Karen Reed. Again, the jury may feel way differently after they see some of the other evidence come in. But that statement, I'm going to back it up. A couple of you were like, I couldn't hear that very well. I'm going to back that clip up again, and then we'll see if they go on the record to handle any more scheduling issues. But a lot of you are saying it's out of context. It's not for the jury out of context. The jury has just what they have. The defense can argue for more completeness. They can't clip or edit sentences, but that is the complete clip. The jury might want to see the entire thing. What was asked, what was said, but it is a complete sentence, and the defense cannot use clips from any of her interviews. The only way the defense can put in more information is to either argue completeness with the prosecutor or have her testify. Those are the only two options. The prosecution can choose what they put in and what they don't. And the defense can't submit other clips, because when the defense goes to submit them, it is their client's own statement, which is hearsay without an exception. When it comes to the prosecution putting them in, they are statements of a party opponent. And so the prosecution can use them. When they say you have the right to remain silent, it is because you have the right to remain silent. So whether the jury is going to be very tuned in to Karen Reed's statements. It is one of the most relevant things to them. How they interpret them is completely different. How they interpret them is up to them, but they are going to pay a lot of attention to that. Heyo said, can the jury request to watch the entire documentary? They can request it, but they won't get it. That request will not be granted. Ashley, do you like the order in which the Commonwealth is calling their witnesses this time around? It's a bold strategy, Cotton. Let's see how that plays out. But they have meticulously planned this out. I wonder if they have planned this out around the clips that they are going to use to put the evidence in, and the evidence comes in, and then there's a clip from Karen Reed, and they are using it to bookend their pieces of evidence. So I wonder how that will go as we get to later testimony, because there is later testimony to come. There is later testimony, much later testimony to come. So, how many total calls and text messages combined were there? Barbie lifts, they didn't answer that. So it's going to be interesting to see how they bring in their accident reconstruction expert, but they brought this around in this way also to use this clip at this time. All right, let's play it again.
Absolutely more than Jen McCain. Jen McCain, it's me or her. Either I'm going down, Jen, or you are.
Either I'm going down, Jen, or you are.
Folks, I talked to the lawyers briefly about scheduling.
All right, and then the jury gets dismissed. I'm going to just take a look and see if they come back in. Let's see. This is a great question too. Tyler says, do her clips in the docuseries mean she's kind of foregoing her Fifth Amendment? She chose no, because she can't be compelled to testify against herself. She can't be compelled to speak to law enforcement. She chose to speak to media, but that is different than being compelled. And Fifth Amendment is about being compelled. She cannot be forced to testify. The Commonwealth can't call Karen Read as a witness and make her testify. Law enforcement can't force her to answer their questions. But she chose to speak to media, and they can use statements she chooses to make against her. They cannot force her to testify. Though I wonder if the prosecution is thinking if they use enough of these clips, it might force her to testify. That they are seeding enough clips into the trial that she might feel that she has to testify, or she will feel that, and we can't guess, she and her legal team will know, it might be that they think there was enough context, because there are statements in front of the jury now that they did not have last time that I think add context, but there are statements that are very unflattering. Can the jury ask to see more? They can ask, but they're not going to get it. Can the jury go watch the docuseries over the weekend? No, they would need to disclose that to the court. They can't. I don't think the interviews are a good look. But by the time we get to accident reconstruction and Trooper Proctor, will the interviews matter or not? We're going to have to wait and see how that information comes in. But they are putting these in early on, and it changes the jury's perception of a defendant because they are hearing her words. That change could be good, that change could be not good, and that can shift. Jurors' perceptions will shift over the trial. They are told to keep an open mind till all evidence comes in. And I just have to wonder if by the time we get for Trooper Proctor, the jurors throw up their notebooks and are like, what the fuck is this even? I don't know. And it's hard for me to separate out what I know. But at this point, the prosecution has put in a stronger case than they did last trial. That's my perception of it. Does that mean it is a strong case? I don't think we're there yet. But they have put in a stronger case than last time. Will that blow up on them when we get to the coroner, the accident reconstructionist, and more? I think last trial, the accident reconstruction testimony is some of the worst testimony I've ever seen of anything ever. And that includes coroner armpits. So will the jury feel like all of that was buried at the end? Or will it be predominant in their mind? But the way they're presenting evidence is much stronger. All right, let us continue. Let's see if they put any scheduling on the record.
So that, rather than beginning a witness who's probably going to take a while.
I want to know who the long witness is that they're thinking of getting to. Maybe it's the reconstructionist. I really want to see it. I saw a number of you ask if the coroner was on the witness list. The coroner is on the witness list. I double checked before trial started, but the coroner is on the witness list. And if the prosecution doesn't call the coroner, I think that the motion JNOV gets real interesting. And the motion to dismiss at the end of the prosecution's case gets real interesting. They have to prove that John O'Keefe was killed. They have to prove that John O'Keefe was killed. And they're going to need the coroner to do that. So they are at sidebar, they are at sidebar, they are at sidebar. They come back on the, okay. I'm so mad that they don't put what they're arguing about on the record. I want to know. Nope. No answers for you. No answers for you. Looks like we are at the end of the day and the lawyers are grabbing their stuff, and that is enough for this day. Well, Law Nerds, we're at the end of the world as we know it. Just kidding. We're at the end of day 11. I think I gave the summary earlier, so I'm not going to give it again, which means I am sorry for all of you that are loving the case briefs. It might be me in a corner giving my summary of the case brief, because that's where we're at the end of day 11. The jury was released a little bit earlier, and the next witness is going to be a longer witness. So I wonder if it is one of the other experts, accident reconstruction, medical. I know the Commonwealth has a expert with regard to the injury to John O'Keefe's arm. So we have a couple experts that we have not seen. And it is starting to loom pretty large that there are a lot of civilians that we know we haven't seen, and will we see them? The Commonwealth said that their case would take about 3.5 weeks. We are at Wednesday of week 3. So does the Commonwealth have about a week left of trial? Maybe. Maybe we do. I'm real interested to see where we go from here, because it is a very different trial the second time around. And I'm shocked that there's still new information. Every time there's new information, I'm like, how is there still new information? Just how is there still new info? I don't know. I don't know how there is still new information. We're going to answer a few questions, and then I'm going to go, because it is my birthday. And I'm probably going to take a nap. Got to be honest. Go, shorty. It's your birthday. We're going to sleep like it's your birthday, because this trial is exhausting. And the 200 calls today. What? I'm real interested to see what the defense does with that. I hope that nugget comes back around. I really do, because I think it is an incredibly interesting piece of information. It explains that the calls weren't deleted for the Commonwealth, but I think the reason it explains that the calls weren't user deleted looks worse for Jen McCabe. Steph asked, why do you think he didn't get into the 200 calls more? It might just be to leave it alone and argue it. Leave it alone and argue it later. Because it is, sometimes you leave those nuggets where they are and just bring them back up and go, oh. Because if the jury might have been like, that's a lot. I mean, all of you, the second it was like, well, there were more than 200 calls in this 3-day period. Myself, and I think most of chat was like, 3 days. I mean, that's a lot of calls. And it might be just to hold on to that piece of information and tie it together later. Jen McCabe's already testified. You can tie it together with a different expert, maybe, or you hold on to it for argument and you bring it up during argument and just let the jury go, oh, no, that's why. It's a lot of conversation. And I think there's a lot of room for argument on that. Let's just, I don't know.
That's my opinion!
Let's get to a few questions.
Do it.
Thank you for everyone who super chatted. Thank you guys for the birthday well wishes. I appreciate it. It is very kind. For everyone who asked, Emily, what are you doing this evening for your birthday? Sleeping. Your girl is tired and the work days are busy. We're going to chill at home. We went to Metallica. We went and saw Metallica. That was the birthday celebration for me and Dr. B. We will probably go out to dinner sometime this weekend. It's hard when birthdays bump up against Mother's Day too, because then everybody's out to eat, and Brian gets that all the time because his birthday's on Cinco de Mayo. So it's always like, are we going to go out to eat? It's like, well, it's just going to be busy. So we'll do it. We've spent, I think Brian and I have spent all of our birthdays together since I turned 20. So by the time we're here at 27, we have spent a couple decades of birthdays together. So we'll go to a concert, we'll go to dinner later. It's fine. It's fine. Thank you so much for the birthday well wishes and super chats. I love that Kathy Jack is like, I haven't made 200 calls this year. I mean, how many of you in the chat are like, text me? And if you're going to call me, text me first and tell me you're going to call me. I am not prepared. I do not want my phone just ringing willy-nilly. If you're calling me, like there are a handful of people that I talk to on the phone on the regular. If it is outside of that on the regular, I assume that there's an emergency. And I'm like, why aren't you just texting me? Like, just text me. Text me if you need to call me. Otherwise, I'm immediately panicked. Why are you calling? I appreciate now, though, that I think school protocol has been when it is the school, everyone is okay is the first thing out of their mouth. And then they tell you what they need to tell you, because I think, well, at least both of my kids' schools have realized that it's panic inducing. And it's like, everything is okay. You didn't sign this thing. Can you sign it and send it in? Now, Potato said, is it fair for me to think this is the textbook of reasonable doubt? Or Potato, everyone gets to decide doubt for themselves, but it is not unreasonable to say there's a lot of questions here. And if there's a lot of questions, then how do you overcome doubt? If you have watched a couple trials with me, and I know a lot of you have, if you have watched a couple trials with me, I think the last trial we watched together was Sarah Boone. By the time we got to the end of the Sarah Boone case, was anyone surprised when the jury came back with the verdict? Were you shocked? Were you like, I'm not sure what the jury's going to do? Or were you sitting there at the end of the Sarah Boone case going, well, they could have charged that as a first-degree murder. It's interesting they charged it as a second-degree murder. How long is that jury going to be out? I wonder how fast they'll come back. Are they going to be out for more than an hour? Or are they going to eat dinner? Like how quickly will they come back? The question wasn't really, what's the jury going to find? The question at the end of that case was, how long are they going to chat for before they convict Sarah Boone? So when you look at cases, and we have seen a few of those cases where you look at them and you're like, well, that's probably going to be a guilty verdict. And then the jury comes back guilty and you're like, yep, that's what that's going to be. You can tell when you watch through the evidence and you get to the end of the prosecution's case and you're like, I don't know what the defense is going to do with that. Curious to see, but I'm not sure what they're going to do, because there's not much you can do with that. And then there are cases like this, when we are sitting here on day 11 going, can you explain to me how John O'Keefe got hit by a car? Please. I would like to understand how John O'Keefe got hit by a car, because we've learned a lot of things in this trial. But what we have not learned yet is how John O'Keefe got hit by the defendant's car. We have not learned that. We have not learned that. And so when you look at cases kind of on that continuum, you can see where cases have stronger evidence and where they don't. So it is not fair to say, what does doubt look like versus when you get to the end of a case and you're like, I think we know what happened here. This is not a case that we have gotten to, well, I think we know what happened here. In the Sarah Boone case, really the question was not, I think we know what happened here. It was it justified by her defense? Like, did her defense lessen the degree of severity? That was the question. Same with Taylor Shabiznes. Same with Darrell Brooks. I mean, the question in the Darrell Brooks case wasn't, did he do this? The question in the Darrell Brooks case is, what the heck is he doing representing himself? They knew he did that. We knew he did that. The jury knew he did that. But sometimes you're looking at a trial going, well, they had a trial because they have to have a trial because they weren't going to offer a plea deal. And sometimes that's just what it is. In incredibly strong cases that are incredibly serious, like the Darrell Brooks case, the answer there is, yeah, we're not offering you a plea deal. So we're going to go to trial and you're going to get sentenced to whatever you're going to get sentenced to, because we're not offering you a plea deal. Life and life and life and life. Just, this is not one of those cases. This is a case that is very, very, very much in dispute. Very much in dispute. And there are lots of facts to this case that are very much in dispute. So yes, it's completely reasonable at this point of the case to sit here and say, I still have questions and want those questions to be answered. The prosecution putting their case in better than they did last time doesn't, for me, overcome some of those questions. But the jury is seeing this case through a different lens than I am this time, and might be sitting there going, It's interesting that she's saying repeatedly, could I have clipped him? Could I have incapacitated him? Because I bet the jury's wondering, did she clip him? Did she incapacitate him? She says, could I run over his foot? You know what the jury's going to want to know? Was his foot run over? Was his knee hit? Does the things that I'm hearing match to the things I'm going to see? And then we'll see where we're at. But they haven't gotten to his injuries yet. I don't know if that will strike a jury as unusual because I'm too ingrained in criminal trial work to know whether or not a jury is sitting there going, I mean, we're 3 weeks in and we haven't found out how he died yet. I don't know if that's lingering with them or if they're just trust the process. I don't know. If you're watching this case for the first time, or are you sitting there going, why don't we know how he died yet? Because the first trial I was like, can we talk about his injuries? I would like to know what happened. How did he die? Are you going to tell me? And it's hard for me sometimes to wrap my head around information if I don't know, what are his injuries? What is the cause of death? What happened? And then give me the rest of the information. And then I have something to correlate it to. And they're doing that backwards, it feels. And I see a lot of you who are first-time watchers saying, I'm waiting for that information. Tell me what happened to John O'Keefe. What happened? We've got a lot of clips of Karen saying, could, and, Jen McCabe. But we still don't know how the victim died, and we are 11 days in. At what point does that start to cause frustration? Because I know it's frustrating for me. Michelle, thank you for the birthday wishes. Thank you. Amanda said, my 13-month-old kisses the screen when he sees you. Happy birthday. Smoochie kisses back because it's such a sweet age. I truly am still happy that my teens will still hug me. Sometimes the side hug, sometimes the full hug, sometimes the fist bump, but there are still hugs. I'm just thrilled. Occasionally Griffin will snuggle up on the couch. But at 13 months, it was so sweet. However, the benefits of a teen, A, he has introduced me to new music. B, we absolutely had banged together listening to Metallica and Limp Bizkit, and it was a core memory. He also sends me hilarious memes on the Instagram. So no smoochy 13-month-old kisses, but the memes are great. Squishy baby kisses are great. The memes are great. The memes are just 10 out of 10. So we also have a very similar sense of humor, which is fun. Lucy said, I missed it all today. I don't know if you did. It'll be in the case briefs. Get the Lawnard app. Case briefs will be out. I don't know if you missed too much today. 200 phone calls. You missed 200 phone calls. That's what you missed. Not that. Dina, yes, my brain has stopped. What's your birthday dinner? Happy birthday. I don't know what we're going to do for dinner. I don't know what we're going to do for dinner. Probably maybe leftovers from Brian's birthday dinner. Maybe not. Something easy. I don't want to go out to dinner. I'm tired. Something easy. Something Griffin will enjoy, which means probably pasta. Michael Peppertech said from Ian Whiffin's own website, essentially the last viewed time value could be before or after the actual time of the URL visit, making this time stamp utterly unreliable. They should bring this in. They didn't ask Ian Whiffin about that as directly because the defense doesn't want the timestamp to be unreliable. The defense wants the timestamp of 227 to be reliable. And I think that's why they didn't bring it in. But yes, this is a bigger conversation to have. This is a bigger conversation to have. So let's see. The May the 4th was great too. That was a moment, but it was a lot. And when you work with experts that are incredibly nuanced, you could see at times it was like, but I'm asking you this question. It's like, well, there's all this other technical information. There's all of it. There's all of it. Alexis said, I am trying to listen to this trial with an open mind. This could also back Jen's claim that she constantly butt dials with the amount of phone calls in a short amount of time. That is fair. Would inadvertent calls count as part of the 200 calls? Maybe. But I don't think the prosecution will even think to say it. And I think the defense can make a bigger argument of it. So, and I think that we will. Don't forget, today is the ARCA deadline. That's true. The lawyers are going to have to go read reports and all of it. Ninja said, EDB, can you imagine your misspelled internet search being repeated over and over for literal years and preserved in court records forever? No, because my internet searches should be wiped frequently. Yeah, no. Nope. Keep it out. They're not as unhinged as when I was at the DA's office, though, because, yeah, there were definitely things that would come up in cases, and you'd be like, what the fuck? And then you're like, when IT calls to ask what we're doing, I don't even know how to explain this case. IT is just going to have to figure it out. Yep, there are stories. We'll get to them another day. We're going to get to birthdaying today. Yellow Pill, good to see you, said in general, nothing is ever truly deleted from your computer, just buried deeper and harder to reach, requiring more sophisticated tools to get it, sort of like the dark web being harder to reach. Yes, they are nuanced. It seems that the only people that accurately and adequately got rid of their phones, their histories, their calls, their texts, and their call logs were those who were in law enforcement. It seemed like they did that the best. But we're not there yet because they haven't been called yet. So that. And Alexis also asked, so my understanding of the 200 calls is Jen did not manually delete, did not user delete the calls. The log got full, and so as the new one comes in, the last one drops off. Yes, and John's phone had the calls because his data hadn't become full. Yes. Yep. Mm-hmm. Totally True said, we are not deleting tabs. We are closing them. Yes, you can delete search history. This is what she's saying. Thank you, Totally True. Fair, that tabs get closed, not deleted. Dawn D said, EDB, my husband and brother, I think, bought my 15-year-old a fantasy book for her birthday because she likes those types of stories. It turned out to be a spicy book. He said, just give it to your mother. It was like, the thing is, like, Butcher and Blackbirds at Target. I can picture a parent not knowing and going to Target and being like, this cover looks like something that my teen would like. They like these other books that are in this section. How would you know unless you opened it up and started reading the trigger warnings that I am not going to read on the internet? But you can probably go find the trigger warnings for Butcher and Blackbird somewhere on a Google search that you can then never delete. But it's at Target, so I can totally understand walking through and being like, oh, this seems like something that they would love. And then you're like, oh. I was kind of surprised that Butcher and Black, I understand the ACOTAR series. Like, there's some series I get, but there's some I'm just like, oh, okay. So, just if you're going, most of the books will have just the first couple pages. I used to buy just music. We just buy music at this point. Just music. So the Sean, the 21st century viewer of this channel, EDB, this case couldn't get any dumber. This case, happy 35th birthday. Thank you. I will take it. We're off by a few, but no, I'm taking it. We're 27. I think we've declared that we're turning 27. Here's a surprisingly stupid development. Yes. And I read that terribly, but yes, this case couldn't. How am I still surprised? And then we get to, the IO didn't go to the autopsy. Just what? No, I'm not actually 27. I'm sorry, I'm not actually 27. We've just been, not actually, I'm teasing. But I'll take it. Artis asked way earlier in stream, EDB, did you cuss after breaking a nail in court? No, I probably ouched. My question is, did you cuss in court? Only in the way that we have seen the attorneys in cases like this cuss in court, which is if the curse words are part of the case. But did I look at a witness and be like, come on, you didn't fucking say that? Nope. But if a witness said, and then he said to me, die, motherfucker, I would be like, so when they said to you, die, motherfucker, were you in fear? And after they said to you, die, motherfucker, what did you do next? So after you heard, die, motherfucker, then where did we go from? Like, would I repeat it? Oh, yes. And then in closing argument. So the stupid, dumb shit, goddamn motherfucker, when they were saying all of that, then how did you feel? Oh, yes. Not quite with the emphasis on the word fuck like Jackson, because Jackson puts like all of the emphasis on fuck. He's like, and you said fuck. And I'm like, damn, man. But no, yes, I absolutely would. There was a colloquy. We're probably already demonetized, but the Lawnards, it's birthday stream. It's fine. There was a colloquy during, I think it was a preliminary hearing. And it was a sting operation for those engaged in illegal, illicit sexual activity for pay. And in the report, the undercover would write out the agreed upon prices, the things that the parties agreed to do, and all the rest of the things, and would use the colloquial term for a thing and then the like in parentheses the thing. So if they like asked for a BJ, they would then put like oral sex into the thing. And so while the defense was doing their cross-examination of the undercover officer, they were like, so when you said, is it like whatever amount of money for a BJ, what did you mean by that? And it's like, as it says in my report, it was relating to oral sex. And so there was this back and forth with the defense as the defense is trying to get the definitions of oral sex into court, because of course that is not what any undercover would ask someone for. They're not like, excuse me, how much for the oral sex, please? That is not what happens. And so the back and forth on this would not stop. And at some point, the defense attorney looked at the undercover officer and said, well, do you want oral sex? And I'm like, it's 10 a.m. and we're in court. What are you hitting on the cop? Are you propositioning the officer? What happened? Just what? Where have we gone? And the officer just looks at this defense attorney and was like, now? And then the defense attorney's like, no, not now. When you were asking during the sting operation, which again is not really a requisite of the crime. It doesn't matter if the person asking for the thing actually wants to do the thing. And the defense attorney was just going down this road of, if the officer didn't intend to like follow through with it, then apparently it somehow undermined the elements of the crime. And so then the defense attorney got into how much this officer wanted or did not want oral sex from the defendant in the case. And I was just sitting in court trying not to laugh, but also being like, is this happening? Did I miss an element of the crime? That like the intent doesn't go to the receiving party. What? And so we got back round to, no, at the time when you asked defendant for, a BJ, did you want oral sex? And the officer looked at the defense attorney and went, well, I mean, not from your client. What is happening in court right now? I was just like, what? Could you not have just answered, it's a sting operation? So, nope. Not from your client. Thanks, officer. I appreciate it. I mean, which is nothing apart from the time that in another sting operation with a undercover who was soliciting those that were purchasing versus those that were seeking to purchase versus, no, I'm not describing that right. Different undercover operation with John's, yes, customers, the consumer end of that transaction swooped in because, again, they all came in on the same day because they all got arrested on the same day. So they all came in on the same day to my courtroom. And there's a dude I went to high school with. And I was just like, I'm just going to have another DA do all of this. I'm not. Nope. You and I are not talking about this case. I'm not talking to your defense attorney. Nope. Let me out, please. But also, you run the risk. If you are in your hometown, not only is law enforcement part of your hometown, the DAs are part of the people in your hometown. So we're gonna know your business. No, I'm gonna go get one of my colleagues. Nope, not doing it at all. None. And that remains between them and I. So your high school classmate was a customer. I mean, they were not able to complete the transaction because they went to exchange money and then got arrested. So yes. So yes. But this is, chat's not wrong. The undercovers were all very, very, very attractive humans. So, you should be able to suss it out. Sangha, thank you for the birthday wishes. We have gotten far afield into stories. Carrie said the court reporter is the real MVP. Today, the court reporter had her work cut out for her because, oh my goodness. Needham asked Emily, are you going to cover the Idaho case? I have been covering the Idaho case in the Emily Show podcast that drops on Mondays on the Emily Show channel because we are streaming this. Do I intend to stream it? Yeah, it's going to start in August, and then it's supposed to go through November. So it's going to be a long one. But, yep, we're going to be here. we are going to be here for sure. Law Nerds, thank you. So many of you are like, we can't even with the 200 calls. I know we didn't get to all of the questions, but we are going to go do birthday things. Law Nerds, you are the best. Thank you for being here. Thank you for spending my birthday with me, covering the Karen Reed case this year and last year. I appreciate it. Maybe next year we won't be in trial in May, but I am not going to even put that into the universe because I don't think it's going to happen. I just don't. We'll be back in court tomorrow, and we will see who the witness that's going to take a long time will be. I wonder if it will still be scientific evidence of some sort, but we will see, because today was just wild. Today was wild. You guys are the best. Thank you to all of Team Baker, the amazing mods, Miguelina, and the editors, because don't forget that we have a case brief dropping every single day summarizing what's happening in court. So if you miss a day and need to jump back in, or if you're just like, oh, I might have missed something, or I want to see the condensed version, those are on the Emily Show channel. And if you have the app, which I was going to pull up and show you, and then I swooped. If you have the app, we also send out notifications when those go live. We try to have those go live before court. So if you are an early riser and are like, hey, I'm up waiting for court to start, you can catch up on those before court starts for the day as a quick little refresher. I appreciate all of the team for making sure those get done and for making sure I get a little time for my birthday this evening. So I'm going to go. I appreciate you. Law Nerds, we'll see you tomorrow. Everybody, have a good evening. Get some rest. Hydrate. And we'll see you for more Karen Reed tomorrow. Thanks for joining me on this stream. If you don't want to miss a moment in court, you need the Law Nerd app at lawnerdapp.com. It's a free download on iOS and Android where I can keep you in the loop with everything happening in court. And of course, when the jury has a verdict. So if you don't want to miss a moment of this trial coverage, make sure you get the Law Nerd app. Thank you for being here, and thank you for being a Law Nerd.